All right, good afternoon, everyone. Welcome to our hearings today. We've got both variance, special exception, and code enforcement matters on today. If you're here for code enforcement, you are in the correct place. However, the first hearings that are on the agenda deal with a special exception and a variance. So we're going to start with those first. But again, if you're here because you want to speak on one of the code enforcement matters, you're in the right place. Do not leave, stay here, and we'll get to those in the agenda. So with that, welcome to the City of Madeira Beach Variance Special Exception Use Special Magistrate Hearing. My name is Bart Valdez, and I'm the appointed Special Magistrate to hear today's cases. I'm a practicing attorney and have been a member of the Florida Bar for approximately 25 years. I've been appointed to this position in accordance and with the authority set forth under Florida law and the City of Madeira Beach Code of Ordinances. It is my role to fairly and objectively review the matters presented today in these variance requests. As such, I would like to advise you of certain matters related to today's proceedings. Today's matters will be heard in the order that they appear on the agenda. At this time, I have read and reviewed the applications with all attachments, any written submissions by anyone having an interest, any timely submitted written objections, and the materials provided by the city staff. In all cases, the hearing will be conducted in the following order. And this is subject to some procedural mechanisms that we'll go through, but essentially the city or the applicant will present its case and staff report, and the applicant may ask questions of the city's representative. The applicant will present his or her case supported by witnesses and evidence, and the city may cross-examine each witness. Third, public comment will be solicited or received from parties directly affected by the variance. Individuals testifying do not have the right to cross-examine the parties. All public comment shall be limited to 3 minutes per person. Public participation will then be closed. I'll deliberate and then make a decision to grant or deny each variance requested in the application. Formal rules of evidence do not apply to this proceeding. However, I will exert every effort to ensure that fundamental fairness is afforded to all parties. After my decision today, I will issue an order. The order will be reduced to writing, and the applicant will be provided a copy by mail. Additionally, you are advised that I do not have the authority to grant you a building permit. You must still obtain a building permit for any work you intend to do on your property. If you wish to present any information to me today, it is necessary that you swear or affirm that you will tell the truth. Therefore, in just a moment, the city attorney will administer the oath and swear in any witnesses. If you expect to talk to me today during the hearing, then you will need to rise and be sworn. This includes any members of the public who are directly affected by the variance and may wish to provide public comment. So anyone who wants to address me today, please rise and be sworn.
Raise your right hand, please, if you're going to testify today. You swear the testimony you're going to give today is going to be the truth, the whole truth, and nothing but the truth? Thank you.
All right, the first matter on the agenda is case number SE 2025-01 for Barefoot Beach Club. Ms. Trask, how do we want to proceed given the number of people who have said they want to be an affected party?
So what I'd like to do is to go through the process that's set forth in the code. First of all, to give you a summary of the application, the standards to be applied, the burden of proof to be found, the identity of the parties, and the order of presentation. That is how it's set out in the quasi-judicial rules of the city. And if I can do that, we'll get to the point where the order of presentation comes basically last in a little bit of the presentation. So is that okay? Yes. Okay. All right. So this application is SE 2025-01. The applicant is Amanda Huffman. The property owner is Barefoot Beach Resort South LLC. This special exception use request is for allowance of a commercial use on an open rooftop under section D-1056C of the city's code. The property owner intends to obtain a liquor license for the hotel on the property and serve drinks on the rooftop and pool deck for hotel guests, therefore necessitating this request for the special exception. The standards to be applied are set forth in the code. They're specifically set forth in section 110-124. The city's staff report will address each and every one of those standards to be applied. The burden of proof in this proceeding is the greater weight of the evidence that's set forth in section 2-10 of the code. The identity of the parties are as follows. The applicant, Amanda Huffman and Barefoot Beach Resort South LLC, the City of Madeira Beach, and the following people who have filed notices of intent to become affected parties. And I'm going to read them in the order that they were received by the city, and therefore we'll talk about the process followed after this list. So I'm going to read them from the top. John Klein, Sarah Klein, Ronald Loggett, Thomas Edwards, Joanne Claben, Cynthia Edwards, Robert Bello, Barbara Ray, Michael and Ilana Costa, Mitchell and Sandra Rayburn, and Rose Loggett. And it's my understanding that Ms. Claben is not present, but she did provide a letter because she was not able to attend. The order of presentation will be as set forth in the city's code, section 2-9, paragraph A, provides that I will provide a statement on behalf of the city. The first party to present evidence to the board or to this special magistrate is going to be the applicant. The second party to present evidence to the special magistrate will be the city. And pursuant to section 2-9D of the city's code, other parties shall follow the city in the order that they filed their notices. Thereafter, persons who are not parties may testify. Lastly, the applicant and the city shall be permitted to provide additional evidence to rebut the evidence presented by any other party or person. So at this point, it would be appropriate for the applicant to proceed. I did provide you with a list of those people who have filed their notices of intent so that you have that in front of you. I've also provided it to the attorney representing the applicant and the other attorney that is representing one of the affected parties, so they would have the list too. They took a photograph of the list. I didn't have an extra copy to provide to them, but they're aware of them. So the first party to present would be the applicant.
All right.
Good afternoon, Your Honor.
Hello?
Brian Ungs, 625 Court Street, McFarlane, Ferguson, and McMullen, here on behalf of the applicant Barefoot Beach Resort South LLC. This property is known as the Barefoot Beach Club, and I'm joined by Amanda and Aaron Huffman, the proprietors, owners, and operators of the hotel, which has existed and been in operation pursuant to the terms of a now expired development agreement for many, many years. Your Honor, I believe you have a copy of our PowerPoint and you have a copy of the development agreement. I did bring additional copies of those, but unless you feel like you need my highlighted version, I'm sure you can rely on the versions that you have.
And if you want to put that into evidence later, I have no objection. Just show Mr. Trask, and then we can get it into the record if you want.
I've seen it. I have no objection.
Okay.
Yeah.
All right,
Thank you.
then let's make sure before, when you're done with your presentation, so it's in the record, just give me whatever you want. We'll put it in the record.
I will. Thank you, Your Honor. So this is an outline of the property. The property is in the C1 zoning district and is part of the Johns Pass Village Activity Center. So, Your Honor, I think it's important to understand this is part of an activity center. It is the transitional area of the activity center, but nonetheless, it's part of the Johns Pass Village Activity Center, which is designed, of course, in part to promote activity, including economic activity, tourism, cultural activity, and generally to provide for more intense uses and more intense activity in the city of Madeira Beach than those areas that are not within a special area plan, particularly an activity center. The special exception use is requested for the allowance of a commercial use on an open rooftop under section D-105 sub 6 sub C. So, Your Honor, this is a permitted use. It's a specifically permitted use under section D-105 sub 6 sub C. And I don't think there's any question, at least in the staff's mind, that this is a permitted use. And of course, it's subject to your approval under the special exception, special use criteria. Your Honor, I did want to draw your attention to the development agreement because I think this is very important. The development agreement was entered into by the Madeira Beach City Commission on December 1st, 2015, so 10 years ago. On page 2 of the development agreement, they continue a matrix of uses, essentially almost like a version of a site data table. And amongst those uses at the bottom is an ancillary rooftop bar. And it goes on to say, with typical and customary limited food service for hotel guests for their convenience only. So this specific request to use this space that has been constructed and has been developed pursuant to the terms of this development agreement was contemplated and understood at the time that the City Commission went through the legislative process of approving the development agreement and approving the development in general. So this is not a new use. This isn't something that the city and the public was unaware of at the time that this project was approved. On page 5 of the development agreement, Your Honor, it specifically talks about this rooftop area. It's subsection S, and it says, "The proposed roof deck, fitness room, and bar area shall be clearly ancillary and subordinate to the principal hotel use. The proposed facilities are intended for the convenience of the hotel guest and as such shall operate in a manner that is customary and incidental to the operation of a hotel. It is understood that the practice of providing at least limited food service is a service expected by hotel guests and service that is routinely provided by hotels." And then it goes on to say, "Because of its limited nature, this ancillary restaurant does not increase the need for additional parking." So again, this was very thoroughly understood and explained as part of the conceptual site plan and as part of the development agreement that was approved for this overall development. And Your Honor, just to give you the full history on this, at that time, this was part of a PUD application. So it was a planned development. So this hotel and this use is a planned development. It has since been rezoned to C1, and it is part of the Johns Pass Village Activity Center transitional area, as we discussed. On page 7, as is typical, the City Commission specifically found that the development permitted pursuant to this agreement is consistent with the city's comprehensive land use plan and the land development regulations of the city. So again, Your Honor, as you know, a development agreement must comply with the comprehensive plan. It cannot permit uses that are not otherwise permitted. And the City Commission went through the process legislatively, not quasi-judicially, but legislatively, of approving a rooftop bar and restaurant. Now, that development agreement has expired. It expired at the time of the CO. But when you read the city staff report, the city staff is obviously, having been involved with the development agreement back at that time, is well aware of the development agreement and the intention of the developer, the intention of the City Commission, and what was discussed, and has developed conditions for your approval of this use that, in the staff's opinion, according to their report, carries on the intent of the development agreement and provides limitations on the use that are protective of the community and of the surrounding properties to make sure it truly is a very, very minor ancillary limited use. So again, the owner intends to obtain an alcohol license for the hotel on the property and serve drinks on the rooftop and also at the pool deck, thus necessitating this request. And here is the floor plan. It's kind of hard to make out, but I wanted to make sure you're aware. Nothing in this application is proposing any structural changes at all to the roof. All of these structures have been developed pursuant to the development agreement and were CO'd, inspected by the city. So there's an interior conference room space, there's an enclosed space that has a bar, there is an outdoor sun deck, and there's an outdoor covered deck that has a window, like a service window, where the bartender could then serve drinks out onto that deck. We're not adding any seats, we're not adding square footage, we're not adding anything other than the ability for my clients to sell the alcohol directly. And again, Your Honor, you're not approving the ability to provide the alcohol sales today. That would eventually go to the City Commission if you approve the commercial use. You're approving a special exception for the commercial use of the space. So I wanted to make sure that was understood, that regardless of your decision today, if you supported the staff's recommendation and findings and approved the special exception with conditions, we still have to go forward with the City Commission, and we still have to go to the state as well to actually get the license to serve alcohol. So again, Your Honor, this area already has a bar that was developed pursuant to the development agreement, and there's nothing right now that is prohibiting our clients' hotel guests from bringing in their own alcohol and consuming it on the roof deck, which they do. So, I mean, there's absolutely no ability for the city or for my clients even to prevent people from legally consuming alcohol on their premises. And that's, so this use is essentially already happening. Their just point of sale is not the hotel. The point of sale is some other retailer. So I wanted to make that clear as well. So going through the staff report and the specific conditions of approval under section 110-124, the first one obviously is that this is a permitted use. As we discussed, it is a permitted use under section D-105 sub 6 sub C, which states that open rooftop balcony and elevated terrace use is a permitted special use if commercial use or accessible to more than one temporary lodging, vacation rental, or residential unit. Obviously, the hotel complies and qualifies with that definition and those standards. So I don't think there can be really any question that it is a permitted use for your consideration and potential approval. And again, as I've discussed at length, it was also a use that was specifically agreed to, called out, and planned for in the development agreement. So not only is it a permitted use now, it was intentionally developed for that use as part of the overall development back 10 years ago. The second approval criteria is that the use is so designed, located, and proposed to be operated that the public health, safety, welfare, and convenience will be protected. And again, the applicant has gone through the process with the city staff of agreeing to pretty stringent conditions of approval that are not currently on the property to date. And we'll go through those specifically in a moment, but it has to be ancillary to food sales. Food sales have to be 60% of the sales. Alcohol sales cannot be a majority of the sales. It has to be limited to hotel guests. This rooftop area will be restricted to people with a room key, so you won't be able to access the rooftop via elevator unless you have a room key. And that is currently, how it's operated. There will be no special events other than events of people of 50 or less that are actual hotel guests. Which again is how it's currently being operated. So there's no change in that. And no amplified music or amplified noise of any kind whatsoever. So this isn't like a party deck or anything that's open to the public or anything like that. This is truly a very minor ancillary use. The third approval criteria is that the use will not cause substantial injury to the value of other property in the neighborhood where it is to be located. Again, Your Honor, we believe those conditions that were developed along in collaboration with the staff address that. And additionally, again, this is in the Johns Pass Activity Center. So the neighborhood that this property is in an activity center where this type of activity is supposed to be encouraged and promoted. Number 4 is that the use will be compatible with adjoining development and the proposed character of the district where it is to be located. Again, the requested use will not change the primary use of the property as a hotel. The rooftop use will be ancillary to the hotel and is compatible with adjoining development and the proposed character of the Johns Pass Village Activity Center. The Johns Pass Village Activity Center development standards are an attempt to memorialize the character of this tourist, commercial, and cultural center and to provide for future enhancement and revitalization. Approval of this requested use would further these goals by enhancing the hotel by allowing it to utilize the rooftop for commercial uses, which are customary to many other hotels in the city that have restaurants and bars, except for this one will be severely limited as we've previously discussed. The 5th approval criteria is that adequate landscaping and screening is provided as required in the land development regulations. This property is beautifully landscaped. The landscape plan was part of the development agreement. There's no issues or concerns regarding the landscaping, and no additional landscaping is required as part of this request or this approval. The 6th approval criteria is that adequate off-street parking and loading is provided, and ingress and egress is so designed to cause minimum interference with traffic on abutting streets. I read to you the portion of the development agreement, Your Honor, that specifically found that because this use is so ancillary and so minor that it doesn't impact the parking, and that, again, that was a legislative determination by the City Commission, but that also, again, this is for hotel guests, it's space that's already there. We're not adding any intensity. We're not adding any intensity. We're simply allowing the applicant to have a point of sale for alcohol services and food services as well. As we've discussed, the food service is the primary use of the site. So there's no issues with traffic. There's currently plenty of parking available for the hotel guests, and we're not increasing the number of trips or any way how the hotel currently interacts with traffic. The seventh approval criteria is that the use conforms with all applicable regulations governing the district where located, except as may otherwise be allowable for planned unit developments. And again, that box is checked. It is a permitted use. It is consistent with the Johns Pass Village Activity Center. Number 8, if a variance is also desired or requested, a separate application shall be submitted concurrently with the special exception application. There is no variance request, Your Honor. So that one is not applicable. We are seeking no variances as part of this application. Number 9, the special exception use will not grant to the land more privilege than the best use available in a zone where the special exception use would be a principal permitted use. I think that is another one that's very clearly checked here. Any other hotel that has the C1 zoning in the Johns Pass Village Activity Center could come to you and ask for this special exception. It's available to everyone. That's why it's available. And certainly if it was a permitted use, this rooftop deck permitted use, it certainly doesn't give us any privileges that anyone else wouldn't have under those circumstances. And then number 10, no application for special exception may be considered when we have outstanding fees and charges. There are no outstanding fees and charges. So let's go through the specific conditions of approval, and I'll wind down my presentation, Your Honor. Number 1, no amplified music and no amplification of sound, including but not limited to radios, stereos, karaoke machines, and televisions shall be permitted on the rooftop bar. So again, or open rooftop. This is not going to be a party deck. This isn't open to the public. There are not going to be large events there. It's not going to create noise pollution that's violative of the noise code or any of those types of things. Number 2, no events that include non-hotel guests, which is 50 people or less, and no special events of 50 people or more will be permitted. The definition of a hotel guest is a registered overnight room occupant. And again, the rooftop bar or the rooftop will only be available to those with room keys. Number 3, if an alcohol beverage license is approved by the Board of Commissioners, the following conditions shall apply. The applicant must sell food. The applicant must meet the restaurant definition, 60% of sales from food and non-alcoholic items for an alcoholic beverage license. And C, the applicant shall only serve food and alcohol to hotel guests and cannot operate as a restaurant open to the public. Number 4, the commercial uses approved in this application will continue this is coming from the staff report. So this is, I believe, the staff's opinion here that we're repeating. The commercial uses approved in this application will continue the intent of the development agreement dated December 1st, 2015, and allow the open rooftop use of a sun deck and the enclosed rooftop area to be used as a fitness room and or a bar restaurant for hotel guests. These uses will be considered ancillary uses for the primary hotel use and shall not become primary uses for the property. Number 5, we're not changing anything about the lighting. But if there is any lighting changes on the rooftop, it has to comply with the Sea Turtle Preservation Zone ordinance. Again, there's currently no issues with that right now. We're not planning any changes on that. And then finally, Your Honor, as you know, the trump card here in this whole thing, Your Honor, is that you can revoke this if they don't comply. So if any of these conditions are violated, the special magistrate may revoke the special exemption use if the conditions and safeguards made part of the special exception use approval are violated. So I think that provides, not just are the conditions, tailored to protect the community, but the ultimate protection is you can always revoke it. So if this does become a problem, which it has not been, but if somehow it does become a problem down the road, and these conditions, unlike the development agreement, never expire. They're there forever, as long as that use is there, and if that use has been approved, whoever the special magistrate is, whether it's 10 years from now, 15 years from now, they can come back and say they're violating these conditions of approval. And then just finally, Your Honor, I already went through the development agreement, so I won't reread it, but that final slide is the specific reference to the development agreement's contemplation and approval of this rooftop area to be used as a bar, restaurant, sun deck, fitness room. Your Honor, at this time, that concludes my presentation. I just want to make sure the PowerPoint is moved into evidence. I know the development agreement was already in evidence along with the staff report. Other than that, we look forward to answering any questions you or the staff have, and then obviously look forward to final addressing you with rebuttal.
All right, don't go anywhere yet. So Mr. Trask, if it's okay with you, we'll go ahead and introduce as exhibit number 1, the agenda packet for this agenda item, which is pages 3 through 74 of the agenda packet. Is that correct?
Sorry,
All
that's
right.
correct.
And that does contain in it the development agreement that I
Correct.
think is 18 pages and then with some attachments. Then as exhibit number 2, I'll put in the PowerPoint presentation that we just went through today. Any objection, Mr. Trask?
No objection.
All right. All right, sir, is there anything else in the way of documents or evidence that you want to introduce in the record today?
No, just, Your Honor, Amanda and Aaron, would you just confirm for the special magistrate that you are the owners of the property and that you will comply with all these conditions of approval?
Yes, we will.
Okay. Go ahead.
Yes, we will.
I think that's good for now, Your Honor.
Okay. Stay there real quick. And Mr. Huffman, what is your first name?
It's Aaron?
Aaron?
That's correct.
Okay. Mr. Trask, do you have any questions of the witnesses on behalf of the applicant, or do you have any clarifying questions you'd like to ask their counsel?
I don't have any questions. They covered, the question I was going to ask is whether or not that they are in agreement with the conditions and they will comply with the conditions. They have responded to that already.
All right. All right, and for purposes of this hearing, is there anything else we need from the applicant at this point in time, Mr. Trask?
Not at this time.
Okay. Have a seat, don't go far.
Thank you, Your Honor.
All right. Mr. Trask, is the city prepared to go forward as the second party to present evidence?
I just want to make sure that there is no cross-examination by any of the affected parties on
Oh, good point.
Ms. Graham, why don't you step up to the microphone so we can get that on the microphone? So this is Attorney Graham. She represents one of the affected parties.
Good afternoon, Your Honor. My name is Jane Graham. I represent Cynthia Edwards, and I just have a couple very quick questions for the applicant.
All right, Mr. Huffman, Mrs. Huffman, will you please come forward?
Jane,
And I
why
think
don't
we
you
got to,
step over here, use this microphone so that they can stay with their client? This should be on. Try that out.
and just so the record's clear, Ms. Graham, who do you want to ask questions of first, Mr. or Mrs. Huffman?
This is probably, it could be to either, I think to,
All right, we'll
let's
start
say
with
to
Mrs.
Mrs.
Huffman.
Huffman, to Amanda Huffman.
All right.
Good morning, how are you?
Hello, good, how are you?
Or good afternoon, actually. I only have a couple really quick questions for you. Barefoot Beach has gotten complaints for noise before, is that right?
It's been quite some time since we've had a complaint or a police officer out.
Okay, and at one point, one was for a wedding with only 30 guests, right?
I do not have recollection of that. I might not have been the manager on duty at that date.
Okay. All right, that's actually, it would be a question for Mr. Oxt. Yeah, I'm,
You're done asking questions then from Amanda Hoffman?
yeah, I'm all done. Thank you.
Just to clarify, does the city allow for cross-examination of attorneys presenting legal argument?
It doesn't say you testified, and so I would assume the answer is
Okay.
yes.
Good afternoon. I have an email from you to Mr. Trask on December 5th, 2023. Do you remember having a communication with, and I can give you a copy to
I
refresh
do
your.
not have any
recollection.
recollection whatsoever of that.
Okay,
If you want to show it to me, I'd be
sure,
happy to
yeah,
read it.
I'll show it to you.
Let me just read it real quick.
Sure.
So I can understand what we're talking about. Okay.
Okay, great. So just a simple question. The situation that's referenced in that email, it relates to a noise complaint. Is that correct?
I assume so. I wasn't a party to that, so I'm just relating information from my client to the city's attorney in this email. My understanding was that there was, one of the neighbors came on your property, right? And was kind of uninvited. And then that person, I think, was the source of a complaint. And as you can see in my email, I'm explaining that essentially the allegations that were made apparently at that time were not an accurate reflection of what occurred according to my clients. But again,
Okay.
that was information I was relating from them to the city. And I believe I
So,
provided
so-
photos and video also. Yes, we provided photos and video of that wedding
Okay,
as well.
but, and so just so that it's clear, you say in this email that the wedding in question, where there was some kind of, at least there was some kind of complaint, contained roughly 30 people, right?
30 guests.
30
hotel
guests.
Yep.
Okay.
That's what it says.
All right, that, I have no further questions. Thank you.
All right, thank you, Ms. Graham. Ms. Trask, what's the next step here?
Would be time for the city staff to make its presentation to you.
Okay,
You're represented by an attorney? No, I am not. You, okay. So all affected parties get an opportunity to cross-examine? and
okay.
So,
So I guess it's time to go ahead and deal with the affected party status
I
of
think so.
everyone. Mr. Unks, have you seen the list that has been prepared of the ones who have filed, individuals who filed the notices of intent?
I just saw it before the hearing, yes.
All right, do you have any objection or any comment to these people as being, whether or not they're affected party and whether I need to hear any evidence as to their status, or will you agree that these are affected parties for purposes of today's hearing?
If you'd give me one moment to confer with my client, I'll get right back to you.
Sure, no problem. While he's conferring with his client, Mr. Trask, is there anyone on this list that the city objects to their status as an affected person?
no, not at all.
Okay.
Yeah.
We have no objection to the list as stated. Thank you.
Okay. I just want to make sure I've got everyone on here. Mr. Trask, remind me, is there anyone else we need to add to this list that's,
No, there's
An
no one
affected
else that needs
person.
to be added to the list that I gave you prior to the hearing. These are all people that had to have provided their notices of intent at least 5 days prior to today's hearing.
okay. All right, based upon the stipulation of the city and the applicant, listen for your name. You've been designated as an affected person, is that correct?
Yes,
An affected person. John Klein, Sarah Klein, Ronald Leggett, Thomas Edwards, Joanne Claben, Cynthia Edwards, Robert Bello, Barbara Ray, Michael and Elena Costa, Mitchell and Sandra Rayborn, and Rose Leggett. Did I read that correctly, Mr. Trask?
yes,
All right. These, if you're an affected party, you have the right to cross-examine the witnesses, and that would be either Ms. Huffman or Mr. Huffman, or if you have any clarifying questions for Mr. Ungst. So, Mr. Klein, are you in the audience today? All right, and again, I'm going to give you, this goes for everybody. I'm going to give everybody who's on this list an opportunity to come up and tell me anything they want to tell me. This part of the hearing is solely if you want to ask questions of those witnesses. Do you have any questions of those witnesses?
Is that the only opportunity that we have to?
No, no. So the question was, is that the only opportunity? No. This is purely cross-examination. You saw what Ms. Graham did. She asked 2 or 3 questions. She's going to have a full opportunity to present anything else she wants to me. So this is your opportunity and anyone else's opportunity to ask questions, just like Ms. Graham just did.
I have a question.
All right, come on. How do we want to do this, Ms. Trask? Do we have a separate microphone around
Yeah,
here? Or how do we want to
sir,
do this?
could you step over here? We're going to use this as the place to ask questions. Thank you.
All right, Mr. Klein, first identify who would you like to ask questions to?
Aaron, I'd like to ask Aaron.
All right,
I,
Mr. Huffman, hold on, let Mr. Huffman come on up here with Mr. Hunks. Now, as I said to everybody out here, just so we're aware, formal rules of evidence do not apply. However, these questions still generally need to be relevant to what is going on here today and would not otherwise be objectionable. So I realize we're dealing with people and you may not all be attorneys and that's okay. But there may be certain questions that you ask that one of the parties objects to, and then I'll make a legal ruling as to whether or not that question can be asked. So with that, Mr. Klein, go ahead.
yeah, John Klein, and we're at 13213 Gulf Lane, approximately 2 houses south of the Barefoot. And we've been there, my wife and I have been there for over 60 years, so we're well familiar with this residential neighborhood. I heard during the presentation that there would not be amplified noise or disruption or anything that would disturb the residential neighborhood. Yet, evidence will show that there's been repeated claims, complaints, and police calls. Can you tell me what the management structure is, 24 hours, to ensure that there won't be noise? Because there's noise already that's causing complaints. Now, when we have alcohol, we're going to increase the decibel rating of the noise. What is there in place now, or what is going to be in place that ensures that this doesn't happen? I mean, bars have hotels, major hotels have security. They have, and I don't mean a college student at night. I mean real security. And they have managers on staff who have the authority to throw out disruptive guests. So what is it now that you have that allows?
Yeah. So currently at the property, I have an on-site superintendent that lives or resides at the property that is on call 24 hours and responds to any noise complaints or maintenance issues that we currently have. I've had security in the past, and I've went through 3 separate security companies where I had to fire them because they were not on property or sleeping in the units or found to be not doing what we were paying them to do. I think being at this property myself over 17 years and finding out what works and what doesn't work, having somebody on site is the best method, because that not only is their job or duties to keep the peace at the property, but it's also their residents as well. So they share similar concerns that the residents around the hotel would have as well. If there's noise being made or disruptions, then they're not going to be able to sleep as well.
And have they taken action?
Yes, I frequently make sure, and we have communication with that individual. If there are any complaints, we have an after-hours number. The guests call, it goes to 4 separate individuals, it rings the phone, and there's accountability for any of the guests. We have a 0 tolerance for noise, and we post that at our property and let our guests know at check-in that if they're disrupted by any manner, that we ask them to leave the property with no refund.
And when did you have this 0 tolerance? When did this start?
Oh, we've always had a 0 tolerance.
Always had it?
Yeah.
Okay. That's all that I have.
All right, thank you, Mr. Klein. Sarah Klein, are you here today? Yes. All right. I heard a yes, correct?
Pretty much covered everything.
Okay, so for the record, Ms. Klein says that Mr. Klein covered everything she wanted to ask. All right, Ronald Laguette, L-L-A-U-G-E-T, are you here today? All right. Sir, you've seen some questions before. Would you like to come up and ask any questions? All right, who would you like to ask questions to? Who did he say, Mr. Trask? I didn't hear him.
Mr. Huffman?
Okay, Mr. Huffman, can you come on back up?
Just to clarify for the record, can I get who Ms. Graham is representing?
Sure.
Ms. Edwards, okay, thank you.
Mrs. Huffman.
How's it going, Ron?
Mrs. Huffman.
Oh, Mrs. Huffman. Oh, I'm sorry.
I thought you,
You'll come next, don't worry. I'll give you a chance.
Hello.
Hi, how you doing? You stated that you're gonna open up a restaurant?
We would like to serve snack-like items. So
Pardon?
We would like to serve, it's not a full restaurant with steaks and things like that, but more snacks. So we have 2 children and they're 16 and 9 and they've grown up at the hotel. And so many times they're like, we're hungry, we want a snack. And there's really, you walk down to John's Pass, which wouldn't be safe for a teenager alone.
Nope.
And a lot of families have that issue. So we
What are you gonna be
just-
serving again? I'm sorry.
like sandwiches, pretzels, things like that. Maybe chips and salsa, simple snacks to grab and take to the beach or eat up on the roof deck, just to make it easier for families.
Have you had any experience in restaurants?
I have, yes. I've actually been in hotel and restaurant management since I was 16, so that's over 20 years. I still assist in running restaurants in North Carolina and on Amelia Island as
Very-
well.
Do you believe that selling sandwiches will make up for 60% of the total sales?
Actually, I do, especially with 2 kids on summer vacation. They eat a lot, and it's very expensive to feed children, especially teenagers.
Will rentals of rooms, rentals of cabanas, sale of T-shirts or any other item be included in that 60%?
No, that's just food only,
Just
sir.
food only? Okay. You answered my question.
Okay, thank you.
Thank you.
Mr. Leggett, you say you also had some questions for Mr. Huffman, or did Ms. Huffman answer all your questions?
Pass them, he's answered my question.
You're good?
Thank you.
Okay. All right. Thomas Edwards, are you represented by Ms. Graham as well? Are you here? Okay. All right, so you're on your own at this hearing today. Okay.
thank you.
You've seen the drill. Who would you like to ask questions of?
Mr. Huffman, please.
All right.
So you're the general manager?
Correct.
Okay. So when a guest checks in, is there a set of rules that you give them or post it that tells them what they
Yes.
can and can't do on the property?
Yes.
Could you enumerate, tell me what some of those are, please?
So whenever a guest checks in, we let them know that there's no smoking on our property, and that there's zero noise, zero tolerance for noise. We also let them know that, that there's only parking for 1 vehicle, because I know that parking is a premium on the island, especially at our property. And they're told that if there's any complaints or issues, to call or contact the after-hours number that's posted on a pamphlet that we hand them, as well as posted in the elevator and in the room.
But you don't have the number posted on the office window or door, so
Yeah.
one of us can go ahead and call it
Sure,
when we have a noise issue.
certainly.
It is published?
Yeah,
Or on-
yeah,
I-
yeah, there's a, on the window, it says for after-hours, please call, and it has the
Okay.
number posted, yeah.
All right. So, Miss Joanne Claben has written a letter and has talked to you before about noise on the property. And she was complaining about a wedding that was up on, I'm sorry, there was a functioning up there, I believe in 2020, and it was extremely loud, the music and the noise, and it was going and emanating into her home, which is 2 houses north of you, of the property. And then she went ahead and contacted you, and I just want to find the part that she contacted Barefoot to turn down music, and she was told by the front desk employee that only Aaron Huffman could authorize that. And then when she talked to you, you said something to the effect that we're not here to make friends in the neighborhood.
I don't recall that statement.
She wrote a letter, she's discussed this with you, there's, letters have been in the record a number of times, especially with the alcohol permits that you've applied for.
So, yeah, I disagree with that. The instance that she's referring to was when we first opened or got the CO for that building. We had the Mad Beach Fish House across the street wanted to have their company Christmas party at the hotel. I told the owner, Amy, at the time, I said, this would be great. Then we can figure out what's going to work and what's not going to work for that roof space. They had amplified music. We found out that that did not work, and we never repeated that again after that. Any event or anything after that has not been permitted to have any sort of amplified music. I haven't had any complaints from any of the residents. I've even texted some of the residents that are nearby during the events, asking them, can you hear anything? Is there any noise? And I get responses, no, you're good. So from that point forward, when we first opened the building, we learned a lot from that first event, and we've taken steps to correct all those measures since then.
When it was shortly after that you had a huge wedding on the beach in front of your place that had a tent set up and huge speakers, and we had to send a deputy over there to turn it down because I couldn't even hear the TV in my own home, and I'm 3 houses away. Do you remember that event?
I do not recall that event, no.
All right. So when Mr. Gomez, the city manager, came here, myself and Mr. Loggett had a meeting with him and with the outgoing city manager, Bob Daniels. And the development agreement had expired and when you got your CO, and it basically said that you couldn't have any events after that. And Mr. Gomez sent you a letter to that effect. Correct?
I'm not aware of that letter, no.
You're not aware of that letter that you received from Mr. Gomez, that you weren't supposed to have any events afterwards?
No, I didn't. Not aware of that.
About a year and a half ago, when you all made an alcohol permit application, and when the neighborhood had gotten together to discuss this, you showed up at our neighborhood meeting and you bragged about having a dozen events in the last 8 months, and we hadn't heard any noise. Now, this is after you would have received this letter from Mr. Gomez that you were not to have any further events, and yet you ignored the city and continued to have events there.
No, it's not true.
I spoke to you once before about, and I know you're talking about noise at the motel, but it would apply to noise anywhere on the property, would it not? So do you have any thing in your regulations where you tell people they can't discharge fireworks on the beach?
The only issue we've had with discharge of fireworks is a neighbor that's on the north side of our property, but it's not one of our residents. No, it's not a guest of ours.
So your property extends all the way down to the high tide mark, doesn't it?
That is correct, yes.
I mean, according to the property appraiser, okay. And yet, people have been seen setting off fireworks, deputies have been called, and the people walk back up to the barefoot beach.
Like I said,
And I've been told by an employee, well, it's down at the beach, we don't control that.
yeah, I'm not.
You're not aware of that either?
I'm not,
Okay.
just the neighbor that's to the north of us.
Okay. What about people having large boom boxes on their balconies and playing excessively loud music? Do you all take any action on that?
We do, whenever there is a boombox or any outside music heard, because we do have a speaker at the pool that's kept at a volume that doesn't disrupt anyone.
Right.
We make sure that we identify who has it and tell them that they have to turn it off immediately. We've actually lost some customer base because of it. They thought they were being targeted and isolated because we made them turn their music off. So it's very well regulated. Even at the pool, they're not allowed to have speakers. It has to be headphones or Bluetooth.
I'm going to show you a photo, and will you verify if this is your vehicle?
Sure. Yes, that is a vehicle of ours.
introduce this evidence, sir. And the reason being is there will be a video played later that will show excessive noise, and Mr. Huffman's vehicle was there at the present time.
I'd like,
Hold on. So I think he's trying to move into evidence during cross-examination, which I don't think is
I'll be glad to
proper.
wait. I'll be glad to wait. Thank you.
Any other questions?
The rules that you have, does it also include what time the pool closes and things for noise? What time is that, sir?
our pool has to be closed at, it's open from sunrise to sunset because we can't have additional lighting at the pool to meet code because of turtles.
Okay, thank you, sir.
Thank you.
All right, thank you, Mr. Edwards. Okay, Joanne Claben, are you here? Okay. Ms. Edwards, I take it that Ms. Graham has asked the questions you'd like to ask, correct? Correct. Okay. Robert Bello, are you here today? I heard a yes? Yes. Do you want to come up and ask questions? Okay. Let the record reflect Mr. Bello says he has no questions. Barbara Ray, are you here? Barbara Ray, are you here? Okay, let the record reflect that it does not appear that Barbara Ray is here. Michael or Elena Costa, are you here today? Are either of you here today? All right, let the record reflect that they are not, no one is saying they're present. Mitchell and Sandra Rayborn, are you here today? All right, Mr. and Mrs. Rayborn, would one of you like to come forward and ask questions of the Huffmans? All right. All right, who would you like to ask questions of, Mr. or Mrs. Huffman, or do you have any clarifying questions for their lawyer?
I have a clarifying question for the attorney.
For who?
The attorney.
Okay, Mr. Unks, again, this is, I view
Just a
it's not,
question.
yeah, I view it more as a clarifying question, not cross-examination.
Not at all.
Yeah.
First-
Hold on just one second, let Mr. Unks get up here. Okay, go ahead.
Thank you.
Hi. First of all, when you say that you have ample parking, you have 115, to my knowledge, you stated this before, you have 115 rooms as your capacity. How many parking spots do you have?
I do not know the answer to that. It
I would
says, the
beg to
development
differ.
agreement says
Less than
84.
150.
Hold on,
Hold on a
hold
second,
on.
let him answer.
Sorry.
The development agreement says 84 spaces provided. Allowable compact spaces, 84 times 20% is 16.8. Parking calculation notes, 73 tourist rooms at one space required 73 spaces. So required spaces is 73, provided spaces is 84, and that was approved in the development agreement. There's nothing changing about there's no impact to parking because we're not changing the number of trips to the hotel.
Okay. It wasn't that it was changing, I just noticed that if they've got a 115 capacity, and there definitely wasn't.
This
100.
says 73 rooms.
I understand. Didn't he tell me?
They don't have 115 rooms. They have, how
At
many
the
rooms do you have?
last meeting, he told me.
They have 73 rooms.
Last meeting, they said 115, I noted it. Okay. The other thing I wanted to know was, when you said they rezoned it to a C1, when did that occur?
You'd have to ask the city that. I believe it was in the last year as part of the Johns Pass Village Activity Center.
Andrew, you're not going to respond to that,
Okay.
okay? These are questions for the attorney.
Well, it was something he brought up, so.
Questions for the attorney. He
And-
answered your question.
It wasn't an applicant-driven application. This was something the city did as an
There was
amendment.
something that you said expired that you guys submitted, and I didn't get clarification on what you were saying was expired.
The development agreement
Okay.
that approved the overall project expired at the issuance of a certificate of occupancy.
And when was that expired? Is that not a question for him
I
too?
don't know. When was the certificate of occupancy?
Okay. I'm just trying to get clarification, that's all.
I don't have personal
Okay,
knowledge of
that's
this.
fine.
They're telling
It
me
was just
around
questions
2020.
I was putting down.
Around
Okay, those were
2020.
my direct questions, that was it.
Thank you.
Thank you.
All right,
I'd like to ask a clarifying question.
okay. Mr. Rayborn, you have a question for who?
Attorney,
All right, Mr. Unks, can you come up and answer a clarifying question for Mr. Rayborn?
Certainly.
my question is concerning when you mentioned earlier that if they didn't meet all the sound ordinances and liquor issues and stuff, that after so many times, they would lose this ability to serve at the restaurant or liquor, correct?
So what, what I'm referencing there is, right now, there are currently no restrictions on amplified noise whatsoever, other than the decibel limit in the city code for noise. If this is approved, the special magistrate will enforce these new conditions that require no amplified noise, and it goes into more detail. And if they violate that, and you have evidence that they violated that, the special magistrate can revoke their ability to serve alcohol and food.
And how many times would they have to violate that
That,
before it
that
was
would be a
revoked?
question for the magistrate. If you found an issue, you could raise it with the city, raise it with the magistrate, and I think that would be more of an equitable issue, case-by-case basis. If it was once in 10 years, hopefully it's not a huge deal. If it's every night and it goes on despite notice, then that would be something I would expect them to lose their license. And they're aware of that, and they're willing to agree to that.
I just want to get an idea of, is it 2 times? Is it 10 times? Is it once a week?
It's up to, it
Twice
would
a
be up to
month?
the magistrate.
Does the magistrate have any thoughts about that?
It's not time to ask questions of the
I-
special
I'll read
magistrate.
you what the condition says so that we're all aware of it. The condition that the applicant is agreeing to just says the special magistrate may revoke the special exception use if the conditions and safeguard made part of the special exception use approval are violated. That's what the application says, or that's what the staff report says. All right, Rose Leggett, are you here? All right, Rose, would you like to ask questions? Okay. And who would you like to ask questions of? Ms. Leggett, who would you like to ask questions to?
Aaron.
All right, Mr. Huffman, please come forward.
This is hard because we're neighbors, and so we have some different sides of the fence, that is. After the CO for the hotel, when was the kiddie pool put in?
I'm assuming, well, I don't know. I'm assuming all of it was done, we got a CO for all of it at the same time. But I don't know, I don't know.
Was the
answer to that
kiddie
question.
pool part of your development plan?
I don't have the answer to your question.
Okay. There was also a retention pond that was mandated on that side of your hotel. Where is that retention pond now?
Do you know where the stormwater facility is?
I'm assuming it's still there.
There's a kiddie pool there, but where is the retention pond?
Underneath the deck that is there, we have an elevated deck that's next to the kiddie pool. And that was underneath it is the retention. From my understanding, that's where it's at.
Was that in the design that was presented and approved?
I don't have the answer to that question.
Okay. There was also additional parking spaces there. What happened to those parking spaces?
I'm assuming they were removed to accommodate the pool.
Okay, so the kiddie pool, the retention pond, and the parking spaces, did it have approval?
I don't have the answer to your question.
Okay, thank you.
Okay, I think we've gone through everyone who timely filed a notice of intent. Did I miss anyone, Mr. Trask?
No, sir.
All right. Mr. Trask, do you have any follow-up questions for the applicants based upon the cross-examination
I do not.
of the affected parties? All right. Mr. Unks, I just have a couple clarifying questions before we turn to the city, because I know people are asking a lot of questions, and I just want to clarify what exactly is before me today. It's my understanding that the only thing I'm being asked to determine today is that there'll be a special exception allowed for the commercial use of the open rooftop. Meaning I'm not approving any liquor license, I'm not approving any, them to serve food or drinks or anything else. Only essentially what the applicant is asking is that I approve as a special exception what was already set forth in the development agreement that the city commission at the time approved. Is that a fair statement of what this applicant is asking for today from me?
Yes, Your Honor, specifically section D-105 sub 6 sub C, which states open rooftop balcony and elevated terrace use. And then it goes on to say, is permitted special use if commercial use are accessible to more than one temporary lodging, vacation rental, or residential unit. That's specifically the request before you, and you are correct, Your Honor. If you approve this application today, it does not give my client a liquor license or the ability to sell alcohol. That still goes to the city commission, and it still goes to the state of Florida.
And also, in reviewing the application, I saw a sentence that says the property owner also requests ability to serve drinks poolside. I haven't heard anything, testimony or anything. Is that something that's before me today?
I don't know that the poolside is a part of that approval. I think that's a separate approval. That would be the commission. So I think the only thing before you today that as I understand it, unless the city disagrees, is the rooftop commercial use. The pool is not on the roof. The pool is in the back. So that would be for another day.
Understood. Okay. Ms. Trask, do you have any questions for Mr. Ungs based on my questions?
No, I don't, thanks.
Okay.
Thank you, Your Honor.
All right. To remind everybody that the order of presentation today is the applicant went first. Now, the next party to present evidence to me shall be the city. So, Mr. Trask, is the city prepared to move forward?
Yes, we are, and the city's going to call Andrew Morris. Andrew, what is your occupation here at the city?
I work in the Community Development Department as the long-range planner.
Okay, is it your responsibility to review applications for special exception uses?
Yes, sir.
And were you the person that was responsible for reviewing the application that was submitted by Barefoot Beach Resort South LLC?
Yes, sir.
And did you issue a staff report and recommendation?
Yes, sir. Staff report with recommendation, but with proposed conditions.
All right. If you would go over your staff report then, please. If you could speak up so that everybody can hear you.
The special exception use request is for the allowance of a commercial use on an open rooftop under section D-105-6C. The property owner intends to obtain a liquor license for the hotel on the property and serve drinks on the rooftop and pool deck for hotel guests, thus necessitating this request. A little bit of a background. Ordinance 2025-17 and the Barefoot Beach Club development agreement were adopted by the Madeira Beach Board of Commissioners on December 1st, 2015. Ordinance 2015-17 rezoned the property to a planned development to allow for the construction of a 5 stories over parking structure with rooftop ancillary space. This new structure brought the total number of the hotel rooms for Barefoot Beach Club up to 73 rooms. The intent of the rooftop facility at the time of the rezoning was an ancillary space exclusive for hotel guests. The development agreement allowed for ancillary uses like a restaurant to only serve the hotel guests. Page 2 of the development agreement states the ancillary rooftop bar sun deck fitness room with typical and customary limited food service for hotel guests for their convenience only. Further, the development agreement states that the roof deck, fitness room, and bar area are intended for the convenience of the hotel guests only. The development agreement for the property expired when the construction of the project was completed and the certificate of occupancy was completed. The adoption of Ordinance 2024-09 and Ordinance 2024-11 rezoned Barefoot Beach Club from planned development to the C1 Johns Pass Village Activity Center zoning district, transitional character district. The transitional character district west of Gulf Boulevard is a mix of residential uses and temporary lodging uses located in low to mid-rise buildings. On the west side of Gulf Boulevard, commercial uses like restaurants must be an accessory use to a permitted use of the property and can only be up to 20% of the building floor area ratio. The current regulations on the west side of Gulf Boulevard transitional character district are similar to the previous zoning district, which was the R3 zoning district that Barefoot Beach Club had prior to the rezoning to planned development. Properties located on the west side of Gulf Boulevard are restricted to alcohol beverage licenses that meet the definition for a restaurant as defined in section 110-526 7, a restaurant must have more than 60% of its gross sales of non-alcoholic items. Even if the development agreement is expired, the proposed special exception use would support what was previously approved in the development agreement and the original intent of the rooftop space. The next part of my staff report goes through the criteria from the code that we look at for when we receive a special exception use application. The first part of that is that the use is a permitted special use. And for findings, any property in the transitional character district of the C1 Johns Pass Village Activity Center Zone District can apply for a special exception use for open rooftop use. Section D-1056C requires that open rooftop balcony and elevated terrace use, if commercial use or accessible to more than one temporary lodging or vacation rental or residential unit, must retain a special exception from the special magistrate. The open rooftop use at Barefoot Beach Club requires a special exception since all hotel guests have access to the area, and the alcoholic beverage use would expand the current use of the open rooftop area. The next set is that the use is so designed, located, and proposed to be operated that the public health, safety, welfare, and convenience will be protected. When Barefoot Beach Club's development agreement and planned development rezoning were approved, the ancillary uses for the property were exclusively for hotel guests. This was included in the previous development agreement to mitigate the potential impact on nearby residential properties. Since the development agreement is now expired, city staff is recommending conditions to the special exception use to continue the intent of the development agreement and to protect health, safety, welfare, and convenience for the neighborhood. The next set is that the use will not cause substantial injury to value of other property in the neighborhood where it is to be located. The structure with the rooftop spans between Gulf Boulevard, which is a commercial corridor, and Gulf Lane, which is mostly residential and temporary lodging uses. The older portion of the hotel is located between Gulf Lane and the beach. Most nearby properties are either residential uses or temporary lodging uses along Gulf Lane, and there are mostly single-family, multifamily residential properties along Gulf Lane. The proposed rooftop commercial use and proposed city staff conditions would help protect property values of the surrounding neighborhood. The next one is that the use will be compatible with adjoining development and proposed character of the district where it is to be located. The primary permitted use of the property would remain as temporary lodging. The open rooftop use would be ancillary to the hotel and only open for hotel guests. City staff are offering additional conditions that can be included in the special exception use for additional mitigation to reduce the impact on nearby residential properties. The next one is that adequate landscaping and screening is provided as required in the land development regulations or otherwise required. The rooftop has an enclosed area of air-conditioned space and a wall around the perimeter of the open rooftop. The property does have adequate landscaping and setbacks between the structures and nearby residential properties. And the next one is the adequate off-street parking loading is provided. Ingress and egress is so designed as to cause minimum interference with traffic on abutting streets. The property meets the parking requirements that were required when the development agreement and planned development PD zoning were approved. This special exception use would support what was described in the development agreement. Any expansion of commercial use beyond the intent of the previous development agreement will require additional parking or a shared parking agreement. The next one is that the use conforms with all applicable regulations governing the district where located, except as may otherwise allowable for planned unit developments. And the proposed open rooftop use is an allowed special exception use for the C1 zoning district and transitional character district. Number 8 is if a variance is also desired and or required, a separate application shall be submitted concurrently with the special exception application. Findings: as of the date of this public hearing, a variance has not been requested. The applicant will be turning in an alcohol beverage license permit application separately, and that goes to a separate, the board of commissioners, like public meeting to have a public hearing. The special exception use will not grant the land more privilege than the best use available in a zone where the special exception use would be a principal permitted use. Other neighboring properties could apply for an open rooftop special exception use. The proposed special exception use would not grant the land more privilege than the best use available in a zone where the special exception use would be a principal permitted use. The primary permitted use of the property would still be as a hotel. And then the next one is, no application for the special exception use shall be considered by the special magistrate until the applicant has paid in full any outstanding charges, fees, interest, fines, or penalties owed to the city by the applicant or the owner or possessor of the property under any section of the code. The applicant does not have any outstanding charges, fees, interest, fines, or penalties owed to the city. And the last part of my staff report is the staff recommendation. The staff recommends the approval of SC 2025-01 with the following conditions. No amplified music and no amplification of sound, including but not limited to radios, stereos, karaoke machines, and televisions shall be permitted on the open rooftop. No events that include non-hotel guests less than 50 people, and no special events 50 or more people shall be permitted on the rooftop. The definition of hotel guest for this special exception use is registered overnight hotel room occupant. Number 3, if an alcohol beverage license is approved by the Board of Commissioners, the following conditions shall apply. The applicant must sell food. The applicant must meet the restaurant definition, which is the 60% of sales from food and non-alcoholic items for an alcoholic beverage license. And C, the applicant shall only serve food and alcohol to hotel guests and cannot operate as a restaurant open to the public. For the commercial uses approved in this application will continue the intent of the development agreement dated December 1st, 2015 and recorded in our book 19105, page 1649 through 1668, and allow the open rooftop use of a sun deck and the enclosed rooftop area to be used as a fitness room and or a bar restaurant for hotel guests. These uses will be considered ancillary uses for the primary hotel use and shall not become primary uses of the property. Any lighting use on the open rooftop must be compliant with the Madeira Beach Code ordinances, section 110-505, lighting within the Sea Turtle Conservation Zone. The special magistrate may revoke the special exception use if the conditions and safeguards made part of the special exception use approval are violated. Attached are the application and the attachments the applicant included, the previous development agreement, and the public notice mailing and posting.
Okay, and this has already been received into evidence, so I don't need to ask you that question. Have there been any changes to the conditions that were being requested since the staff report was issued?
Are you talking about the staff report from the previous public hearing, or?
The one that's in the agenda package today?
There have not been changes to the one that has been published in the agenda packet.
All right, thank you. I have no other questions.
All right, Mr. Ungst. Do you have any questions for Mr. Morris about his testimony here today?
Yes, sir, just a few. Mr. Morris, can you just confirm for me the development agreement itself has expired as of the certificate of occupancy being issued? Is that correct?
That is correct.
And right now, are there any limitations other than the city's noise ordinance on amplified music at the property?
I mean, with what's being proposed, like, it has to stay an ancillary use. I think, well, I guess I'll just focus on this application. I mean, there's other restrictions in our code that are enforced, but I mean, yeah, I'm trying to think of anything off the top of my head.
Okay, I was just trying to get at that. I'll get around it the other way. In your opinion, does the legislative history and the fact that the development agreement was entered into by the city commission support this use on the rooftop and support this application?
With the conditions included, yes, that it does meet intent of a limited ancillary use for hotel guests, and that's the way it's written, as a very limited use because of the surrounding area being a mix of various kinds of residential properties.
Okay. And can you confirm, as you state in your staff report on bottom of page 2, that the open rooftop commercial use is a permitted use as a special exception use in the transitional character district of the C1 Johns Pass Village Activity Center zoning district?
That is correct.
Is there anything in the development agreement, even though it's expired, that in your opinion weighs against supporting this application with the conditions that you've laid out?
No.
Okay. And in your opinion, are the conditions that you've required for approval that the applicant has agreed to, is it more restrictive than the conditions that were in the original development agreement, which didn't include a limitation on amplified music, didn't include a limitation on special events?
I mean, I do think it is more restrictive, but it's based off of requests from various nearby residents and to protect the character of that neighborhood.
Thank you, sir. No further questions.
All right, let's go through our affected parties and see if any of our affected parties want to ask Mr. Morris any questions. Again, another reminder, everyone is going to get an opportunity to present to me anything they want to present to me. So this is just the opportunity to ask questions. Mr. and Mrs. Klein, do either of you want to come forward and ask Mr. Morris any questions?
Thank you. You've stated that this special event center and potentially a bar would enhance the value of the neighborhood. Can you explain how potentially a noisy bar will help a residential area?
So they are not allowed to do a special event center. I think you're referencing a previous alcohol application that they rescinded, and it is not reflected in this special exception use request. Any sort of alcohol use, they have to meet the restaurant requirement in our code, which is at 60%, be from like food, and then like non-out, like, and soda. But I mean, it meets that limited ancillary use, so it's not, it can't be like a standalone. I like the nearby, like, was it West Events? I mean, it is a allowed special exception use for, and even other property owners, if they redeveloped and built a similar hotel or condo building, they could apply for the same use. So it's not a special privilege or anything for them to apply for this.
So you can't tell me that it won't affect property values of a residential area?
I mean, the area you live in, residential is one of the uses allowed, but I mean, someone could buy a property and do other, like temporary lodging uses, like a hotel or condo hotel. But if you have a small lot though, you can do single family. It's kind of a difficult along the beach side because you have a huge variety of mixes of various kinds of uses, property sizes. So it's trying to mitigate that because you have everything from older single family homes to like a multi-story hotel and condo buildings.
I'm just surprised that I don't understand the statement by the city regarding the special use permit, special use of this rooftop, why they would state specifically that it won't affect property values of the residential neighborhood. I don't understand why that found itself into there, or unless there's some evidence or document that you have that would show that it doesn't. Otherwise, it wouldn't be in, I wouldn't think it'd be in the statement, that's all.
Any other questions, Mr. Klein? All right, Mrs. Klein, you want to ask any questions? Okay, let the record reflect the answer is no. Mr. Leggett? Yes, I have a couple questions. All right.
My questions relate to the answers that you provided on this paper, specifically number 3, that you state the use will not cause substantial injury to the value of other properties in the neighborhood. What do you mean by substantial? Some, but not a lot?
Okay, let me just. So with number 3, are you talking about the criteria? I mean, the proposed use is an allowed use in our code. And previously, we didn't even require a special exception use meeting for it. It would have just been allowed by right. So the reason why we did add the special exception use is we wanted to make sure to have public hearings so the public does know and conditions could be added to that use to limit the impact of it because of previous concern from residents.
You say there are some single residential properties along Gulf Boulevard? Single family?
Along Gulf Lane.
Gulf Lane, excuse me, yes.
Yeah.
How many?
I know one of the residents gave a list of how many, but I mean, define how much area are we talking about within 300 feet or within a quarter mile? Because if like a quarter mile, you have residential areas nearby, and then within 300 feet, I think one of the residents did include it, but I don't have the number off the top of my head. But there are other buildings, like there's a timeshare building near there too, and other mix, so it's not all, it is a mix of different types of uses with some single family.
The information that the other resident included, how many did they include in that? Are they close to it or not?
Within the, attached with the affected party form, they listed 28 single-family homes, but it doesn't say within what radius, if it's in the 300-foot radius or not. And that has been included into the record.
Seems like more than some. Number 4, the state that the use will be compatible with adjoining development. What adjoining development is there along Block 6 based on the on the plat book where these properties are located? What adjoining developments are compatible to this?
I mean, it has the underlying land use, even before it was changed to activity center, was resort facilities medium, which is a like a mixed use land use for a mix of residential and temporary lodging uses. The transitional district and continues that, the intent of that. So, I mean, the thing is, with that with the underlying land use and zoning, you could have anything from a single family home to a 4-story over parking condo building next to it. Right now, there are adjacent residential properties, and then across the street, there's a restaurant with a liquor license and 2 condo hotel buildings. So there's a pretty big variety of uses adjacent and across the street from the Barefoot Beach Club.
What about on the west side of Gulf Boulevard? How many liquor licenses are there?
Currently in the city, the the only active one you have Caddy's and Snack Shack may have one. I'd have to check that, but I know Caddy's got one in the last couple years.
So that's one?
And then Schooner applied and received one, but they never really acted on that, and currently the site has, the previous structure was cleared, but that would probably be the next one that would probably be applying for an alcohol license once that's built.
So there's no other compatible adjoining development on the west side of Gulf Boulevard where this is going to be? I mean, do the other condos on the west side of Gulf Boulevard have liquor licenses or rooftop entertainment?
I mean, most of those were, or fall under, would it be the multifamily residential, but with vacation rental use. I mean, historically on the beach side in Madeira Beach, there was a Holiday Inn that was demolished in the 2000s. But it has been allowed use, but as shown here, I do understand there are nearby residential uses, so that's why we have that very long list of conditions that if those conditions weren't put on the property, then it would really limit what we could do related to enforcement outside of stuff like the noise, and then the noise we can currently enforce, and then the special events, which in our code is events of over 50 people or more.
So this would be the only one west of Gulf Boulevard if allowed. Is that correct?
Well, are you talking about the special exception use? Because any like if new building that's built that has like an open roof, even if it's like a residential condo building, they would have to apply for this. If it has a like open rooftop use that's open to all the units.
Yeah, they would have to apply, but none have they?
We haven't really had any I mean, along the beach side outside of Caddies and then Beach Flower. I'm trying to think of any other projects along the beach side that have been active. And Caddies is a restaurant that's 1 story over parking, and then Beach Flower is 4 stories over parking. That's eight multifamily condo units.
Thank you.
All right, Mr. Edwards, do you have any questions of this witness? Okay, go ahead.
Good afternoon, Andrew. Gulf Lane runs from 129th Avenue to 135th Avenue, is that correct?
Yes, sir.
Okay. And within that residential area, do you know how many condos, units there are on that strip there? If I were to give you a number, would you say it would be approximate that number?
In my mind, when I look at planning, I usually look more like in a radius around it. So the thing is, focusing on Gulf Lane would then leave like Madeira Bay, the condo hotels, and then Mad Beach Cantina. But I mean, on the Gulf Lane it looks like there's 2 condo buildings, a timeshare building that's 5 stories over parking, and then some other smaller multifamily, and then the 28 single family that one of the applicants sent in.
So the question would be is there any structure along Gulf Lane within that area that has rooftop activity or an alcohol permit? Because we're talking about the character of the district.
I mean, currently, no one has applied for an alcohol permit. The open rooftop thing is a new thing we added in our code recently. So I would have to check to see if any of the previous buildings that were built before we put that in our code, because we put that in very recently, to add additional restrictions on that because of noise concerns.
But there's none that have a rooftop activity within our district
No.
on Gulf Lane between 129th and 135th.
None have applied for it,
Okay.
but it also has just been recently added into our code, so it
Okay.
wasn't a thing when a lot of those buildings were built.
And actually, as what I think you testified before, if you were to go north of Gulf Lane, going all the way up to the city limits, on the west side of Gulf Boulevard, there's only 2 alcohol permits. One is being Caddy's, which is a restaurant, and the other is Archibald Park, which is a city park, correct?
Correct, those are the two that are active that I can think of.
So in number 2, you discussed the public health, safety, welfare, and convenience will be protected. And in the recommendations that the city was making, it talked about that the rooftop activity would only be for hotel guests, and that it wouldn't be for more than 50 people. And I think we've discussed this before, that it would be very difficult for the city to monitor or to see if it's being enforced properly. Is that correct? So if Barefoot were to violate the condition, how would we know?
I mean, most likely it'd probably be a complaint through to the sheriff's department who does our, we contract out code enforcement, and they get the noise complaints, so it'd probably end up.
Right, they would get a noise complaint, but they wouldn't go around to identify each and every person that was on the rooftop to see if they were a hotel guest. Or, they could be a friend and family for a hotel guest, and yet they're accessing that rooftop. So that's my question is, we have a condition that the city is proposing, but there's no way to assess if it's, if they're following the rules on this, because in the past, they haven't followed the rules. That's my question. How is the city proposing to go ahead and monitor and to verify this, because it seems like it's a worthless condition?
Well, the applicant does know that if they violate it and they get caught doing that, they could very well lose access to their roof that they currently do have access to, because it was done before this was required in the code, but this would, because right now, and what happened, why it was rezoned from PD back to a zoning like C1 is the PD basically stated that the development agreement regulated the property, but then the development agreement expired. So then you had a PD that had nothing in it because the development agreement expired. So we have, by fixing the zoning and then requiring this special exception use, we have brought back to requiring restrictions on it to mitigate and try to, that previously weren't there, that we did put in our code based on resident concern. I know enforcement hasn't been perfect, and I apologize for that, but moving forward with these conditions, I think the outcome would be much better than the current status quo or what has previously happened.
Tom, am I able to further clarify? No.
So you're in condition number 2, that is part of the public health, safety, welfare, and convenience will be protected. We had also discussed previously that there is a delivery vehicle that blocks Gulf Lane for deliveries to the Barefoot Beach. Are you aware of that, sir?
You have previously told me about that issue.
And so does that become a safety issue with that vehicle being blocked? And the reason I'm asking is that we've had accidents on Gulf Boulevard where the deputies have rerouted traffic to come down Gulf Lane to expedite traffic, and we have this vehicle blocking the roadway 2 times a day.
I mean, some of that would come down to the deputies would have to deal with that, with rerouting traffic. I mean, the loadings, that's kind of a separate issue from this rooftop issue. But it would be, honestly, even contacting Rob or our city manager during when that's happening would probably be good to show when it's happening, because if I don't see pictures of it or I see it physically happening, it's hard to really do anything related to that. But them doing that doesn't really impact this request for the rooftop.
Well, it talks about the health, safety, and welfare of the area. And with the rooftop, the reason it is important because if they're proposing for food deliveries and alcohol deliveries, are the delivery trucks going to be blocking the lane and therefore causing more congestion and safety issues? So it does apply to the rooftop activity.
Question? Was it a question?
It is a question.
What's the
Yes.
question?
The question was, will the delivery of alcohol and food to the Barefoot Beach create a safety issue because are they going to be delivering on Gulf Lane as the laundry truck is and causing a safety issue there by blocking the lane?
How long does the laundry truck usually sit there for?
Well, that's a question for the applicant, but I'm aware of at least 10 minutes.
Okay. I mean, if you get an Amazon delivery, the Amazon truck has to park somewhere to get out of the driver, to get out of the truck.
They have parking lots they can park in.
Okay. I know there's, depending on what vehicle, is it a van or is it like a semi-truck?
It's a van.
It's a van, okay. But, I mean, if there's difference between it parking for 10 minutes and if something's parking for hours on end in the street, that wouldn't be right, and they would need to move because they can't block our public right-of-way. And I'd have to look at what code provision that is about, because I know we do prohibit parking in our public right-of-way, so. But, I mean, since it's an ancillary use, and it wouldn't really generate any more traffic than whatever currently a hotel deals with related to deliveries. Like, it'd be a very minimal impact.
All right, I'm not going to belay the point any longer. Thank you.
Okay, Joanne Claben, have you arrived? All right, still not here. Okay, no problem. Ms. Graham, you're up now.
Good afternoon, Mr. Morris. How are you?
Doing well. Good afternoon.
Mr. Morris, you've been working on issues relating to the Barefoot Beach and their requested alcohol beverage permit for a while. Is that right?
Yes, ma'am.
All right. And I don't want to belabor the point, but I do want to just get some absolute crystal clarity on this. There are no adjoining rooftop bars that are currently operating next to the Barefoot Beach. Is that correct?
So across the street, there is an alcohol use at a restaurant that is along Gulf Boulevard, like how the structure that this alcohol would be served at, or on the rooftop would be the frontage of it is on Gulf Boulevard.
But that's not on Golf Lane, is that correct? Which is significantly different, because Golf Boulevard, is that the cantina that you're talking about?
Yes, and Barefoot Beach Club, the new structure, the frontage for it is along Gulf Boulevard. It's between both streets, but I mean, the frontage is still along Gulf Boulevard for the newer structure.
But it's also on Golf Lane, and so that's why I believe why we're here, right?
And the issue is and why we add the conditions was because there are neighboring residential properties, a mix of single-family and multifamily, and there's other temporary lodging uses nearby also that are within 300 feet of this property.
And there are no temporary lodging uses on Gulf Lane that have alcohol beverage licenses or rooftop uses, is that correct?
Well, they are allowed to apply for them, just like how the applicant can. If they build a new structure that has those uses, they are allowed to apply for them, but we have, and the open rooftop use was previously an allowed use that we added as a special exception use to define it, to add more restrictions and require public hearings for more public input, because previously we recently added that special exception use requirement in our code, because that was.
And so you would say, and I think that this is a fair point for context, that the reason why we're here is in looking at the criteria for special exceptions, you do look at the compatibility with the surrounding neighborhood.
That is correct, and a challenge in Madeira Beach and why we did these conditions is you have Gulf Boulevard, which is a commercial corridor with commercial uses, with adjacent streets like Gulf Lane that have a mix of like residential and temporary lodging uses. So to try and to kind of try to find a balance between the two is why we do require the special exception use, and we did include these conditions to mitigate, because previously we didn't even define open rooftop use, and it would have just been just one hearing for the alcohol and that's it. And that's why we added this into our code and why we have to do this public hearing now.
All right, and so the property is in the transitional area of the Johns Pass Village Activity Center, is that correct?
That is correct, and even if it wasn't in there along the beach side in the R3 zoning, it's the same requirement where it had been the special exception use for the open rooftop, and the alcohol, the only one they would be allowed is the 60-40 for restaurant. So the
Okay.
transitional district is pretty similar to the R3 zoning that's up and down the beach.
Okay, and so section D-101 this is the Johns Pass Village Activity Center Development Standard states, the Johns Pass Village Activity Center Development Standards establishes regulations and means to preserve and rebuild to the existing character, uses, and density and intensity of Johns Pass Village. Would you agree with that?
The correct statement.
All right. So yeah, let's move on now. I want to talk to you about events. And for context, the development agreement didn't specify for the project didn't specify that it allowed events. Is that correct?
I mean, the previous development agreement basically talked about uses for hotel guests. And I know previously on other alcohol permits that we did not support proposed additional uses that are not included or referenced in what's currently being heard today.
Okay, and I have an email from you dated October 6th, 2023 to the city manager, Robin Gomez, Jenny Rowan, Jay Hatch, and C. Snyder, where it's, and without giving further context, just it simply says, Robin, located below is a section of the development agreement for Barefoot Beach Club related to the rooftop. Events are not mentioned as an allowed use on the rooftop. Do you recollect that?
Yes, so in a previous alcohol permit, that is not being heard today, but related to that email, they wanted to propose expanding and doing a events commercial use on their rooftop, which we did not support because of the impact on the community, plus that would have made it like a larger use that would have required additional parking. And the applicants are not applying or proposing that type of use because of, but that's what that email is a reference to, that previous application from
Can I
from
get a little
2023.
further clarity on that? And I know that we had a discussion the other day. So the code doesn't define event, but it does have a definition for special event. Is that correct?
That is correct, and that is why we have written as based on our definition in our code
Okay.
related to.
And a special event is for over 50 people. Is that right?
That is correct. That is what's in our code.
Okay. And so the conditions as drafted right now for this special exception do allow an event that is up to 50 people, or rather less than 50 people.
The people have to be hotel guests, registered and staying at the hotel, so they cannot turn it into a event space. So those guests would be at the hotel as hotel guests. So I mean, there's only so many things and we can do relay the regulations, but this basically enforces what's in our code while doing the intent of what the previous development agreement, which would have.
In Madeira Beach,
ancillary
there are
use.
events that are with under 50 people. Is that correct? I mean, for example, if you look online for the Madeira Beach wedding permits, you can get a permit up to 25 people and then a permit for over 25 people. Is that correct?
So the beach use and a use on, these are different things. I mean, related to Barefoot Beach Club, I mean, if they're hotel guests and it's less than 50 people, it's kind of hard to enforce that. But I mean, obviously, if it has more than 50 people and they're not hotel guests and you see cars parked everywhere, it's kind of that they're not following through with the intent. But
All right. So you actually, and you just said that. So if it's less than 50 people, it's hard to enforce that. Is that correct? Just to repeat that. Is it possible that there's a wedding of people who are guests at the hotel that take their festivities to the rooftop in this scenario? So it's like 49 people having a party that are all guests of the hotel. That's how this would work in these conditions. Is that correct?
I mean, that is, I mean, they're all hotel guests. They're all staying there. They all have room keys. They all have access to it. I mean,
All right. So
and it's
like
less than, I mean,
40 people in a bachelorette party, all guests, that this would allow that. 49 people in a bachelorette party.
They still,
This is
yeah.
okay.
And they still have to meet that noise order. They still got to meet all those other requirements. And
Okay.
if they violate them, they could very well lose that
Okay, so
access.
let's talk about the noise ordinance. Now, right now, the conditions do say condition number 1 says no amplified music and no amplification of sound. That's correct, right?
That is on the open rooftop area.
Right.
of
Now,
this
it doesn't address voices or yelling. Is that correct?
I mean, if
Okay.
you want to propose to add that as a condition, but we went based off of, in our code, it does mention raucous noises, which could include yelling. But
So-
I didn't, I guess I should have referenced the whole part of that, but.
So here's a question for you, because when you look at the language of the code's noise ordinance, you have section 34-86 that does say it shall be unlawful for any person to willfully make, continue to cause to be made, or continue any loud and raucous noise. And then it defines that, and then it says that this term includes the kinds of noise generated by activities enumerated in section 3487. And then if you look at 3487, it says the following acts as limited by section 3486 are, and subject to the exceptions are. And so they have number 7, yelling and shouting, whistling or singing at any time or place so as to create a raucous noise between the hours of 10 p.m. and 7:30 a.m. daily. So it doesn't appear that under the noise ordinance that a noise that occurs between 7:30 a.m. to 10 p.m. are explicitly covered under this ordinance. Is that correct?
I mean, we could only enforce what's either in ours or the county's noise ordinance, so,
All right. And I mean, likewise, there actually is a section of that same ordinance relating to amplification. And so you've actually expanded the protections for amplified music, saying that, you know, it's just not allowed on the open rooftop. But there's no such condition for yelling and shouting. And I would imagine that that would be because that would be very hard to enforce. Is that correct?
after review, we felt what we were proposing is sufficient to mitigate and reduce the risk of that noise. So we support the way our conditions are written.
Okay. The conditions as drafted don't provide a solution for a 49-person bachelorette party of women yelling at like 9:30 p.m. Is that right?
I mean, I'd have to check our noise ordinance related to other times of day.
Yeah, I mean,
if
as
you're
I just explained, it's limited to between the hours of 10 p.m. and 7:30 a.m. daily. So if there's somewhere else in the code, please tell me. But I believe that based on this, you know, that's not protecting it. Okay, so let's talk about the history of prior requests for the beverage permit application. Now, and just as a caveat, and I know you've mentioned this a number of times, what's in front of us today is different than previous proposals. Is that correct?
That is correct.
Okay. Now, would we be here today if it wasn't Barefoot Beach's ultimate intention to serve liquor on the rooftop?
I mean, that is in the application, they even referenced that they are also, and we've sent out the public notice for the alcohol permit, but their intent would be, they are applying for an alcohol permit.
Okay, and so that really is the true intent of this. It's the first step to get an alcohol permit.
Correct.
Okay, and with respect to prior alcohol beverage permit applications, on February 23rd, 2022, you had drafted a letter relating to the prior application explaining that you had concerns about the parking and expansion of use at Barefoot Beach Club as it relates to residential areas and expanding the use with special events. Is that correct?
So previously, with the previous application you're referencing in the email, they wanted to add an additional use to the property, which we did not support for various reasons probably listed
When
in
you
that.
say additional use, what do you mean?
The previous alcohol permit, that's not the current one or the special exception use, and it's not being publicly heard, but was the previous one. They proposed to do special events, which we didn't support, and they have removed, and as shown in the current special exception use application, that is not what they're applying for. And they are just following through with the limited use, ancillary use that was the intent with the development agreement. So
Okay.
it shows, basically, by showing that, it shows how much more restrictive what's being proposed now compared to previous attempts.
Okay. In the prior request, there was a letter by John Bodziak on February 3rd, 2022, that it references an entertainment space with square footage of 830 square feet. Do you recall that?
I mean, I do remember an email. I'm trying to think specifically, I think it was proposing adding an event use, which we didn't support, and I think that's, and once again, that's not being publicly heard today, because that is not what the applicants are currently proposing. So, I mean, it was, that was the issue with the previous one, and it didn't go through, and I don't, since it's not really being included in this, and it's not referenced, or, I mean, is it very relevant currently compared to what's being proposed, which is basically continuing the intent of what the development agreement was, which was to have ancillary uses for the guests, very limited, and then we've added those conditions on top of that to make sure to keep those restrictions, and if they violate them, they can very well lose that rooftop use.
What is the total square footage of the rooftop that will be open for this proposed use?
I don't remember off the top of my head. I'd have to check.
Don't know off the top of your head. Okay.
But it's also important to remember it is a hotel that has 73 hotel rooms, so it's a very small portion of it is being used for that, and it's not like a standalone use like West Events or any other certain hotels in other cities, not us, that have full-fledged conference spaces and events and all that, which our applicants are not proposing any of those things.
Yeah, well, I mean, I would think that it would be important to at least have the square footage so you know of what exactly is the impact. I mean, are you telling me you don't have this information? They haven't provided this? And it,
Let me go to the, I mean, the area itself already exists. I mean, it was built with the hotel and approved with the development agreement. I mean, the hotel itself, if you look at the development agreement, that is included in that, with the agenda packet. It lists find the floor area. So the gross floor area of the structure in total is like the 50,000 square feet, and it has 70 in total, and it has the 73 hotel rooms.
yeah, that doesn't answer the question though, does it? And
Yeah.
in the development agreement, just so that I'm clear, on page 5 under S, it says the proposed roof deck, fitness room, and bar area shall be clearly ancillary and subordinate to the principal hotel use. Now, the way that that's drafted, it says and bar area, which seems to be different than what is being requested to allow the entire rooftop, open rooftop, to be open for to serve drinks on the rooftop. If you don't have that answer, that's fine. It sounds like that's something that is unsettled. Now, just a few other questions. The development agreement does state that the now, and you've mentioned this already, the development agreement has expired. Is that correct?
That is true.
But would you say that the elements of the development agreement, at least there's, to some extent, there's some enforceability and requirements for them to comply with what has been previously agreed?
We're talking about, what thing in the development agreement are we specifically talking about?
Well, like, for example, it says the dumpster and trash pickup will be contained within the property and fully screened from adjacent residential properties. And I think as you've heard, and as you've been made aware, this is not actually in compliance right now, that it is not fully screened.
I mean, no code enforcement case is currently active. I know previously there was an issue with the dumpster not being screened. If you want to add that as a condition or propose that, they have to, if that's still an issue, to fix that as a condition.
Okay. Let me ask you one more question. During her testimony, Ms. Huffman said that, I guess it was her understanding that the food sales would only be food, it wouldn't be any other items. And with the city, now, you know, without getting into, I'm not going to testify for my client, but I just want to confirm the city, if that is Ms. Huffman's position, that the city would be willing to clarify that in a condition as well.
So with the restaurant, when we look at that, so the city does have the right to look at their books, and we have done that before with other alcohol permits, like with caddies. So, I mean, they know that we have the right to look at that, to make sure they stay in compliance. And so, and I mean, that food and then non-out, like soda, but the city has previously enforced that and reviewed to make sure places stayed in compliance.
Okay. One last question for you. Are there any other single-family residential neighborhoods that you know of on Madeira Beach that are along Gulf Lane, like the ones that's stretching in this specific area in the immediate vicinity of Barefoot Beach?
Are we talking about like specifically down there, or just in general?
Like on the beach?
So on the beach side, I mean, it's mostly become like condos. There are some smaller multifamily, and there are a couple single-family homes along Gulf Boulevard, but some of those are, I think, at least two of them I know of that are, I think, they're being used as vacation rentals.
Yeah. Would you say it's fair to say that it's unique, that there is this, I would say, assortment of quaint single-family homes in the nearby area, directly on the beach?
So, I mean, in Madeira Beach, there are streets that are near Gulf Boulevard that do have single family, and then on Gulf Boulevard, there's commercial uses with alcohol.
Yeah, you're not
Up in-
answering my question, though, because I'm talking about directly on the beach.
I
All
mean,
right.
there's residential uses up and down it, but I mean, that area does have a couple, like specifically a couple of single family homes, but there also are condos and a timeshare building, and we also look on the other side of the street too, because we're looking in a radius, not along one street. So there's a variety of uses, including 2 condo hotel buildings and a restaurant with a liquor license too, also within 300 feet.
Which is on the other side of Gulf Boulevard. You'd have to cross a really busy street, so you can't walk.
You can walk. It has a crosswalk signalized and everything. I've done it.
Okay, but it's, all right, that speaks for itself. Thank you very much, Mr. Morris.
All right, thank you, Ms. Graham. Okay, excuse me, Robert Bello. Mr. Bello, would you like to come ask any questions? Okay, that's a no. Barbara Ray, have you gotten here yet? Barbara Ray? Michael or Ileana Costa? All right. Mr. and Mrs. Rayborn, would either of you like to come ask any questions of this witness? Okay, let the record reflect there was a no. Ms. Leggett, would you like to come ask any questions of this witness? All right, come on.
Mr. Morris, I want to pedal back on a statement that you've continued to make about this development or this special permit would help protect the property values, or on the converse, it would not cause substantial loss of value. How is this? Can you explain how you came to that conclusion?
So other property owners, including yourself, if someone bought your property and combined enough land together, could do something similar and would have the right to do that. Obviously, this area doesn't allow for standalone commercial uses, that has been a restriction that we have continued to enforce. I mean, since it's an allowed use and I foresee it would have an impact, and we just in general, with looking even at other alcohol permits we've done that do have, because there are other areas of the city that have similar situations where you have Gulf Boulevard with commercial uses and then single-family residential just a street away. So I mean, it's not like, and even other area, so I mean, it's not like exclusively this is the only area where you have alcohol that's within 300 feet of residential uses. We understand there has been concerns and complaints, so that is why we did very, very detailed conditions, but I mean, you'd have to really do like a, more
So it
detailed.
seems to me that you're making these statements based on your assumptions. There's no hard concrete facts that if this facility opens, that our properties would not be affected. So let me go on.
Has your property value gone down since Barefoot Beach Club is open? Like if you go on Zillow, has your property value gone down?
Okay, so you're looking at property value, not lifestyle value or anything else, okay? I understand. Precedent setting is one of the things that I'm concerned with. It's been mentioned a couple of times that the Snack Shack and Caddy's are both on Gulf Boulevard. And comparison to Gulf Boulevard and these locations has been made, but we are specifically talking about a small neighborhood, a residential area called Gulf Lane. If this is granted and you keep saying that other places could be built or other places could apply, then they have a right to do that. But would you not agree that granting this would also set precedents?
I mean, even if this didn't pass today, someone could come through and apply for something similar. So, I mean, since it's a allowed use, I mean, I don't think it would set any additional precedent. Because once again, it's like, I mean, the hotel itself got approved a while ago. And then we did add the special exception use thing as a restriction, because previously we had nothing really related to open rooftop in our code. That it was just allowed by right. And the only thing we could really enforce was the noise and special events thing that are in our code already. So, I mean, when we added the special exception use, it was actually additional restrictions. But, I mean, I don't think it would set any negative precedent if it got approved.
So if I'm understanding you correctly, you're saying that the rooftop provision was added to the code after the development plan for the Barefoot was actually proposed and then subsequently expired. Is that true?
That is correct. It was added based not on specifically to this, but in general in the city, because we've added this to other zoning districts too, through other commercial and mixed use, like multifamily residential and temporary lodging zoning throughout the city to try to mitigate noise impact based on in other parts of the city too. So we've actually put it throughout like any commercial or mixed use area in the city.
And then it is my understanding, and it seems to have been confirmed, that though part of the development plan, the initial development plan that is now expired, that it was not actually approved for them to have the entertainment section up there, or events, or a bar. Is that correct?
They're allowed ancillary uses. The problem with when the previous that was referenced was they were proposing it as basically as a equivalent of like a permitted use of the property, where it would, people that would be going to that without having to stay, which wasn't that we didn't support, and why those alcohol permits didn't move forward.
Okay. Another point that you made about the loading and delivery, okay, is that the point in case that was cited was that the delivery truck may be there 10 and in minutes or so it's unmanned. I myself have been prevented into accessing my property or exiting my property in that direction because that delivery was there. Would you not agree, if there is going to be additional usage up there, especially with food and beverages and things like that, that additional deliveries would be required, correct?
I mean, there would be deliveries required for deliver food and alcohol. I just would like with planning, you look at trips generated. It's like if it's like a couple more trips a day, it's usually not as much of an issue versus like going, let's say, from a residential use to something with a drive-through. That's like a big jump in trips, and that generates a lot more versus a hotel that exists. But if they are blocking up the road for a while, it might be good to contact either contact the city, like Robin, so he can go down there and see what's going on and tell them to stop. But it's important, like if it is happening where they are for a considerable amount of time, it might be good to contact our city manager to bring it to his attention.
Did you not state that this loading and delivery should occur on premises?
I mean, ideally, but depending on what vehicle they're doing the deliveries with, I know there's probably, like, depending on what type of vehicle they use.
Are you aware there is a parking lot that is to the north of the Barefoot and also to the south of the Barefoot that has significant amount of space for these delivery trucks to park and not impede traffic on the street?
Oh, I have been down there, and there are parking lots that exist, but I mean, if there is concerns and complaint, it would be important to contact the city and also include pictures too of it happening, so we can go down there and deal with it if it's an issue.
So in this process, the onus is on us to show you that the parking lot to the north is being blocked and not used for delivery or pickup.
I mean, usually if residents complain about something specifically and send pictures and that, like, I mean, we do react on it and do deal with the issue. But I mean, I would have to really see firsthand down there what's going on, but it would be important to contact the city manager because he does handle these things.
I think it's been done several times, but also about 1.5 years ago, there was some parking places came into question, and there was 2 spots that were occupied by the dumpsters. So someone went down and calculated there were supposed to be how many parking places in the existing? Was that 75?
On their site plan, they list 75, but I think 3 of those are bike parking credits that are listed. I mean, are we? I would have to. Is the dumpster still in parking spaces down there currently?
Yes.
Okay.
So those parking spaces are not available, are they?
Tom, could we as a condition that they have, the dumpster would have to be,
You just need to answer her question.
I mean, I haven't been down there in a bit, so, I mean, if it's in the, like, it needs to be moved out of them, but, it shouldn't be in the parking spots, but I haven't been down there to see recently.
So there's been some answers to my questions that you're not sure or you haven't been down there lately, but yet you've made a decision and put it out there that we're not going to be impacted, the residents aren't going to be impacted. This residential area is not going to be affected, and it's the same as Caddy's or the Snack Shack in alcohol service. However, it's not on Gulf Boulevard, and it is a residential area, and there's a significant difference between the two. So how did you come to the conclusion that this is an okay thing to do, and it's not going to be setting precedents for the neighborhood?
I guess I don't see much of a difference along Gulf Boulevard on the beach side. I mean, obviously, we don't, in our code, we don't allow for standalone commercial uses on the beach side along Gulf Lane. We do allow for, as shown with Caddy's up there, because it's along Gulf Boulevard and it's fronting Gulf Boulevard. I mean, it has a land use that allows for mixed uses and I mean, a zoning that allows for it, limited mixed use. So, I don't really see much of it. It's more of it seems like it's more of an enforcement thing related to the city needs to follow through with enforcement. And I feel like with these conditions, it strengthens, it makes it much easier to enforce things than currently.
Based on all the questions that you're getting and the concerns of the residents that will be impacted, are you feeling that your conclusions are in the best interest of those affected?
Yes, because currently we don't have these conditions in place, and it really limits enforcement outside of stuff like with the noise and no special events currently, because that's already in our code. So I feel like these conditions help strengthen and allow for the city to do better, more consistent enforcement. So, and I think it's fair because once again, there's other areas of Madeira Beach on the beach side with residential and other mixed uses. And even if this one passes, someone could buy land and do a hotel and propose this use. So I mean, that's what I mean. Like other property owners have access to do it too.
And because of this decision, then it has set precedents for those people to come and do so. But again, my question was in the best interest of those parties that are affected. Thank you for your time.
All right, thank you, ma'am. Mr. Unks, do you have any additional questions of this witness following the questions and the cross-examination from the affected parties?
No, Your Honor, I do not.
Mr. Trask, anything else?
No, thank you.
All right, does the city have any other witnesses or evidence that you'd like me to consider today?
I'd like to call Jenny Silver.
Okay, go ahead.
Jenny, during the testimony or the cross-examination of Mr. Morris, and during the testimony of Mr. Morris, you felt that you needed to respond to a question that was raised by one of the affected parties. Now is your opportunity to address that.
Okay, thank you.
Yeah.
One of the questions that Mr. Edward rose was the enforcement. I know that's been a question of multiple residents as well. Talking specifically about the events and number of people at the events, I just wanted to reiterate what Mr. Morris has said, that enforcement of the number of guests would be difficult for us to to verify. Just with code enforcement, we don't have somebody standing at the door verifying how many people are up there. But we feel as though through these conditions, this is a way that residents could come to the city and call and complain with code enforcement, whether that being city staff code enforcement or that being the Pinellas County Sheriff's Department, and then notifying city staff. These conditions, specifically that last condition, number 6, that the special magistrate may revoke the special exception use if the conditions and safeguards made part of the special exception use are violated. That does give a way to protect residents, letting us know as a city that they are in violation of these conditions. That allows us to bring this special exception back to the special magistrate, showing that they did not follow these conditions and that their special exception could be revoked.
Thank you. I have no other questions.
All right, Ms. Silver, go ahead, just for the record, and give your title with the city and your role and duty with the city.
Yes, I am Jenny Silver. I am the Community Development Director. I oversee planning, zoning, and permitting, building department.
All right. Mr. Unks, do you have any questions of Ms. Silver? No, sir. All right, let's start with the Kleins. Mr. and Mrs. Klein, do you have any questions for Ms. Silver based upon her limited testimony? Did I hear it? Did Mr. and Mrs. Klein? Going once, going twice? No? No questions? Okay. Mr. Leggett, any questions of this witness? No questions. Mr. Edwards? Yes, sir. All right.
Jenny, I know a little something about doing investigations. So most of these events are going to occur in the evening. You don't have code enforcement in there. So if a resident makes a complaint, and if it's on a weekend, any type of complaints made probably wouldn't be investigated by a code enforcement officer for several days. How do you think that code enforcement is going to go ahead and determine if they have had too many people up there or have violated with only having residents go up there? Guests going up there. How do you propose that? Because it doesn't seem like there's any way of investigating properly. Deputies aren't going to investigate it because they only investigate law enforcement or noise issues or something like that. So if you, when you're talking about numbers and whether the person is a guest, I'd be very curious to see how you think code enforcement could investigate that.
Yes, like I said, I think that would be something very difficult for us as a city to enforce. But any evidence that was provided to the city, maybe indicating more than 50 people at the rooftop, providing that to the city, as well as if we received any complaints, us trying to further investigate that. But I do agree that it is something difficult for the city to enforce regularly.
Right, I thought that, and also the city manager kind of referenced that too. Thank you.
All right, Ms. Clavin is not here. Ms. Graham, do you have any questions for Ms. Silver? No questions. Mr. Bello, any questions? Ms. Ray is not here. Mr. and Mrs. Coaster not here. Mr. and Mrs. Rayborn, do you have any questions for this witness? Okay. Ms. Leggett, any questions for this witness? None? Okay. All right. Does the city have any other witnesses to call here? Any other information to provide to me, Mr. Trask?
No, we don't.
Okay. All right, everyone, now we're going to move to the portion of the hearing where first the affected parties can provide me any information they want, testimony, documents, or any other evidence. After that, if you're a member of the public and you want to provide public comment on this, and you'll be allowed to do so. So we're going to go in the order, again, that everyone filed their notices. And for those people that want to come forward and speak, again, this is your opportunity to tell me anything you want, providing documents, call for the affected parties to call any witnesses they want to call, and for the members of the public to tell me what you have personal knowledge about. Mr. Trask, before we get to that, I I was going to mark as exhibit number 3, the notices of intent to be an affected party, and then the comments. Is there any objection doing that, or how do we want to get that in the record?
The city has no objection to that be receiving that.
All right, Mr. Unks, you have any objection to just getting this in the record? Okay, so for purposes of the record, we're going to go ahead and put in as exhibit number 3, the notice of intent to be an affected party, and also attached to this, there were emails that I have reviewed that objected to the proposal and the application, and I have read and reviewed all of those. So with that, Mr. Klein, you're up first. Is there anything you'd like to come forward and tell me about this project?
To be clear, the 6-block area west of Gulf Boulevard, which is Gulf Lane, is a residential area. In fact, almost 90% of the structures along Gulf Lane are either single-family homes or duplexes, we're being one of them. And this was a known fact to the Barefoot when they constructed the 7-story high-rise. They were building, a hotel, a high-rise hotel in a residential area. So this has been the character of the neighborhood for over 60 years. We believe that, I mean, the question really is, was the Johns Pass Development Agreement designed to change the character of residential neighborhoods? I don't think it was, but yet it has. Noise has been an issue, and although I've heard that there's been a zero tolerance for noise, fact of the matter is, I think the police department will show an evidence that over 200 calls since 2019 have been to the Barefoot Beach Hotel. So clearly, whatever is in place is not working. And my experience is past performance is really indicative of future performance. And I question whether when potentially a license for alcohol is granted and that becomes a party area on the top floor, how will they manage? And if they haven't been able to manage it now, because clearly I have a video that I took at 1:30 in the morning on or about November 30th, where the noise and yelling coming out of the hotel was clear. And it's evident that from the admission that the manager was there at the time, there was nothing done to mitigate that noise. So that's, and I believe that this noise issue, which has been and will continue, is going to affect the property values and the ability to resell a home. Nobody wants to live next to a party house or party hotel. So that's the main concern that I have, is past noise and surely future noise.
All right, thank you, Mr. Klein. And is there a video that you'd like me to review?
I don't know if we can play it.
Open for the monitor. Oh, just got me on sound with it. There we go. Thank you. Yeah.
Just as a note, the red truck was Mr. Hoffman's, so he was present at the time.
All right, thank you. I'm looking at, which red truck are we talking about here is Mr. Hoffman's truck? Pickup truck, okay? All right, any objection?
And introduce the video as evidence as well. We have
All
a
right.
thumb drive.
Mr. Unks, any objection to the videos or this photograph?
Is that the photograph I was previously shown? Yes. Okay. In terms of the videos, no objection to them for your consideration, and I believe that the magistrate is obviously well aware of the quasi-judicial standards and can weigh the evidence appropriately. So I'm not going to object to the picture either, other than just to point out that it's a still photo of a red truck at an undisclosed date and an undisclosed time. But other than that, thank you, sir.
Mr. Trask?
No objection.
All right, I'll go ahead and accept into evidence, and you'll have to figure out with the city how to do this. Exhibits number 4, 5, and 6 will be the 3 videos that were played, and exhibit number 7 will be this still photo of a red truck in the in a parking garage. All right. Mr. Klein, was that it? Yes, sir. Okay. Mrs. Klein, would you like to add anything to what your husband said? All right, if you're going to talk, come on up. We got to get it on the record. You don't have to, but if you want to talk, you have to be up here to talk. Okay. All right, Mr. Leggett.
Good afternoon, Mr. Velez. Hope it's not good evening either. My name is Ron Loggett. I'm at 13231 Gulf Lane. That property is abuts the pool area where the of the hotel there. I'm going to cut down to the chase here. Gulf Lane is a residential neighborhood. Proof of the pudding, the true acid test. Take a walk there. Go up and down Gulf Lane. Don't take my word for it. Don't take anybody else's word for it. You're going to be surprised at what you see. Every time I have neighbors or anybody that comes over to visit me and they take a walk, they say, how did that building get approved? Okay, it has been approved. Okay, and we're going to go with it. We never really had any trouble when it was a motel called Sands of Madeira, which was built next to us. That was built back in the mid-'80s by John and Lillian Stark. It was called Sands of Madeira. They lived on the premises at the corner of, across the street at the 133rd and Gulf Boulevard. They built a house there that also was their office. They were on premise all the time. Strict managers, no absentee management. People, all the years I was there, we never had a complaint as far as I know of people doing it. It has been a lot lately. My concern is that, as stated by Mr. Morris, granting this application for the rooftop, when asked of other areas that have this, his statement was they can apply. Well, we don't want them to apply, okay? We wanted to, they're okay the way they are right now. Don't increase the west side of Gulf Boulevard as an entertainment center. We've got John's Pass Village, which is a big attraction for people to come. Don't take away from that. Again, walk down Gulf Boulevard. You know, and I think I've been a good neighbor to Barefoot Beach, and I'll give you an example of that. Even though I objected to the building being built, when it was near completion, their contractor, a gentleman called Guy Ganaway, who was the president of GSA Contracting, who built the building, came to me and asked for a favor. The favor was this: the building inspector at the time, Frank DeSantis, would not grant them a certificate of occupancy. One of the concerns he had was that people could come off of Gulf Lane and get into the pool. The way he structured it was that I have the fence, concrete fence, knee-high, that abutted their fence, which was higher than mine. It was flat. He asked for the favor to say, so they could get the CO, was to, can I come over here and build a 45-degree, add 45 degrees of cement on that fence, converting it from a flat surface to a 45-degree angle so people could not climb. And I granted that, no problem. Even though, again, I was opposed to the entire building. So we know we're trying to be good neighbors on that. But again, take a walk down Gulf Lane, take a look at it. You're going to be surprised at what you see. Thank you.
Thank you, sir. All right, Mr. Edwards, you're up.
Your Honor, I have several Thomas Edwards, an affected party protected address. So I have several things here. When I had a meeting with the city officials on Friday, I asked for copies of all letters and emails that they had received. They gave me 4 of them. There's 3 additional that have come in that I'd like to give you and the attorney here so for your consideration.
Yeah, that's fine. Start with Mr. You have copies, or are they all? Okay, start with Mr. Unks and Mr. Trask. Let me hear from both of them, and then you can hand one to me.
Mr. Trask, and this is yours.
Just bring it on up. Thank you, sir.
Thank you.
I have a couple other things I'm going to be referencing, so I want to make sure everyone gets copies.
All right,
This-
hold on just one second, Mr. Edwards, because I want Mr. Unks and Mr. Trask to be able to listen to your presentation,
Yeah, yes, sir.
but let them look through here first. Mr. Unks, do you have any objection to this going in as exhibit number 8?
Just appears to be emails and letters, so no objection to being included in the record.
Mr. Trask?
No objection.
All right. We'll go ahead and accept exhibit number 8 into the record. Some of these I have viewed
Yes.
before, so
Yeah,
maybe the
there's
city.
4 of them that you would have had.
Okay.
There's 3 more that came in.
All right, and what we'll do is, before I render decision, I'm going to take time to review all of those, but I will set those over there. So go ahead, Mr. Edwards.
So the other thing is, I walked Gulf Lane here this week, and I just wanted to give them a document. This is a list of all condominiums on Gulf Lane, how many stories they are, when they were built, because it applies to what my presentation is, so I can just go ahead and give it to them. Hand these out, please. And the next thing that we have is a map of the short area around Gulf Lane there and Barefoot Beach. Pass those 2 out. Pass those 2 out. Pass those 2 out. Mr. Valdez, I'm not sure if, when you get requests for these type of variances or things like that, if you ever take a drive-by and look the area over or not?
I do not. I'm confined by the evidence that's presented here today.
Okay.
So hold on real quick. So I'm going to go ahead and mark as exhibit number 9, this condominiums on Gulf Lane. Mr. Unks, any objection to this being exhibit number 9? Mr. Trask?
No.
Okay, and I see, Mr. Edwards, tell me, you want all this as part of one exhibit, or is this going to be separate things?
I think one lists the addresses and the other kind of referenced with the map.
Okay, so what I'm going to do is I'm going to put the map as the first page, then this will be the second page, and this will be the third page of Exhibit 10. Mr. Unks, any objection to Exhibit number 10? Mr. Trask?
No objection.
Okay. All right, go ahead, Mr. Edwards.
So I was going to take I didn't want to belabor the point here. One of the things I was going to do is take Google Maps and just go down Gulf Lane so you can see what kind of area it is. I mean, we've been referencing this, that it is a bedroom-type neighborhood with a lot of residences and things like this. It's our belief that what they're proposing is going to change the character of the neighborhood. And that's why I wanted to go ahead and take a few minutes to go ahead and use Google Maps to go down that. I've taken photographs of all the structures that we're talking about, and I was going to introduce those as evidence. But I didn't know if it'd be easier just to electronically go down and why.
This is your time, sir, however you want to
Well, then
present
I
it,
would
it's
like
fine
to
with
do
me.
that. Thank you. Ask the gentleman, put it up on screen. There we go, we got it.
Yeah.
So if you're not familiar, Gulf Lane runs from 129th Avenue to 135th. What you have here is Johns Pass Bridge, and there's a city parking lot here. Then you have a series of condominiums here. This one is Beach Place, which has a large facility there with 2 buildings. And you can see that it's 5 over parking, which is basically what the Barefoot Beach Resort is 5 stories over parking. And then if you were to go down Gulf Lane, you'll see that there's other places along here, and I wanted to get my you can see that the next building over here is going to be Sandy Shores. We have the Crimson there, and as you look at the list that I gave you, you can see the number of stories and when the units were built. The next one is Surf Song, which is an older structure. There's at one point, because we had a lot of traffic going along Gulf Lane years ago, it was requested to put a fence here across Gulf Lane to keep traffic from flowing through there, because we used to have a lot of cars racing down there. So that was taken to a vote, and that fence area was put up so that Gulf Lane doesn't go any further down south past that. This is Gulf Lane here. So then we have Madera Norte there. You can see it's 5 over parking. You can see that we have some parking lots. We have some small apartments that are over here. It's a 1-lane street, and if you have cars coming from opposing directions, one of the cars will usually move over into a parking space there and driveway partially, and then let the other vehicle go across. As we come up here, you can see we have some small apartments here. It's basically a residential area. There's a house here and one in front of it here. The problem with this one is there's a house here and there was a house here. This house was destroyed and is being rebuilt here. There's a single-family home up front here, right here, and there's an apartment here. As we go down here, this is a no-name condominium. They have 10 units in there. This was a single-family residence owned by a father and son. You have a single-family house here. You had 2 cottages here. There's the Barefoot Beach. This is the Klein's residence. And then you have Loggett's residence right here, and you see how close they were. When Barefoot Beach was proposed, and you just need to understand a little history on there, they had a planned development agreement that they were attempting to get. And in the process of getting a planned development agreement, they have to do a presentation before the public. And when it was presented to the public, it was presented as going to be a 30 condo unit. It wasn't presented as a hotel. It's presented as a condo unit. Their architect got up there and talked at the presentation. He says, oh, we're going to have a bar, kind of like a fruit bar. We're going to have an exercise room up on top. We're going to have yoga. It's all going to be quiet activity. And as soon as they got their CO, then changed. We had wedding parties up there, loud noise coming right off, affecting the entire neighborhood. They had parties in front on their beach side with big tents and everything like this. So they weren't being good neighbors during that time. In fact, when they were going to build this thing, what they wanted to do is they want to move this whole building to be a zero lot line along Gulf Lane there. And they also wanted to go ahead and move this entire building to within 10 feet of their south line here. So it would have been right up across next to this building and blocking these two residences here. As Mr. Loggett said, the Starks used to have this property here, and they're the ones that built this hotel here. It's an L-shaped one, the one that's on the beach here. There's parking and a pool here. This is what used to be there, was a single-story building with four businesses. In fact, the one here used to rent out mopeds. And the Starks had their house sitting right here on this parking lot, and they had it set up where the second floor was going to be a breakfast area. They were looking at putting a breakfast restaurant in there. So when Barefoot Beach came in, they went ahead and tore all this down, including their house. They would have had a resting facility already there, but they chose to tear it down and then built that hotel. And then coming along here, you have a house here on the corner that's blurred out. You have another house here. This is immediately north of Barefoot Beach. You have another house here. You have a residence here. You have some little apartments there. You have a house here, this brown one. No, it's blurred. You have a condo here, Chambray. One of the letters that you have is from their condo president that specifically asked not that the special exception not be granted there. You have several little apartments in here. You have the Princess Building here, which is only 3 stories over parking. You have some more small apartments here and some more additional houses. This is my son's cheap mouse. I'm sorry, I don't have good control over this.
Don't worry, I'm following you.
All
You're
right.
doing fine.
So then we have the Callwood, which is this unit here, and this large building at the end of the lane here. So that's 7 stories over parking. Is not on Gulf Lane, but it is directly at the end of Gulf Lane. What you do have is you have a house here that was destroyed, and then you have a small apartment building here with 4 units. The 5th door is not being occupied as an apartment. So the point I'm trying to make is that, and with the documents I gave you, is that there's a lot of residences here. You don't see the high-rise condos that were there are directly on the Gulf side. There's nothing between Gulf Lane and Gulf Boulevard, except when Barefoot Beach was created. And what it was doing is really creating that wall. We didn't want to see a wall of condos like we have in Sand Key and stuff, but this was built, and again, it was presented as a condo and not as a unit, as a hotel. We weren't getting the true facts of what was finally developed there. So I'd like to go ahead and introduce this drive into evidence and also the pictures.
All right, so what am I looking at here?
The thumb drive has a copy of all the pictures that are in that box. The pictures have been placed by block, so you have the ones from 129th up to 130th, 130th up to, so each block has a picture of what is there in that area now. Pretty much what I showed you, except for a few houses that have been destroyed by the hurricane.
All right, hold on. Mr. Unks, have you seen these photographs before?
I have not.
Mr. Trask, have you seen these photographs before?
No, I have not.
All right, I'm gonna look through them quickly. I'm gonna hand them to you, Mr. Unks. Could you come forward, please? And it appears to be similar to the tour we just did there. Let me hand those to Mr. Trask when you're done. And then Mr. Edwards, is, what's on the thumb drive here?
All the pictures that are there and some additional ones that are basically were shown in the presentation.
Okay. Yeah, say that again,
Yeah,
Mr.
so
Edwards.
the thumb drive has all the photos that are contained in that, as well as some additional ones that were just kind of copies of 2 or 3 pictures of the same structure. It basically, it's just the structures along Gulf Lane, that's all. There, so there's a couple of structures that are in Google, but they're not there any longer because the hurricane wiped out a few houses, that's all. I'm sorry. So Jack's video is also on that thumb drive, Mr. Klein's video, the 3 videos that were presented. And the truck, I did a screenshot of the truck that was in there, that red pickup truck, which Mr. Huffman has already identified as his. So when this loud noise was occurring up there on the 6th floor in the corner lot of their condo, it appears that he may have been present on the property, but you heard how loud that was. That was at least where Mr. Klein took the video from his property would have been at least 120 feet away.
All right, let me do some housekeeping here. So what I'll mark as exhibit number 11, this box of photographs. Mr. Unks, do you have any objection? Is that a no?
Correct.
Mr. Trask?
No objection.
All right, we'll go ahead and mark as exhibit number 11, this box of document, or this box of photographs. And what I'll also do is put in this thumb drive that apparently has exhibits 4, 5, and 6 on it. I'm just gonna drop it in the box. So it's all here. Okay, Mr. Edwards, I've been following you. What else would you like to tell me?
So one of the other things we had talked about was their delivery truck blocking the lane. So I have photos here that I want to introduce as evidence too. Right. The date that photo was taken, I think I put a date on there, it should have been May 19th.
It looks like, I don't know, is it 5/12/2025?
Yes, sir.
All right, mark this as exhibit number 12. Mr. Unks, any objections?
We'll address it on rebuttal, so no.
Okay, Mr. Trask?
No objection.
All right, I'll accept into exhibit number, as exhibit number 12, this photograph. Give me some more context for this, Mr. Edwards.
Yeah,
What am I looking at
so
here?
this is a routine time, my wife and I, as the other neighbors, have seen this delivery. It's a laundry delivery truck. It's usually there twice a day, once in the morning, once at night. It's blocking traffic for 10 minutes or so. They may have changed drivers because the previous driver used to run the stop sign all the time at 132nd. So the point that I was trying to make is that they're going to have extra delivery trucks delivering. They're going to have alcohol and food. The service is what they're asking for. So there's no reason that this vehicle should have been parked there. They have the south parking lot that the vehicle could have pulled into and gone ahead and made its delivery. And then we're concerned about these other delivery vehicles. It affects the safety of the neighborhood. Again, people walk up and down. They're inconveniencing the residents trying to come down and drive down Gulf Lane, as well as any other visitors. And so that's why I wanted to point this out, is that it does directly affect the character of the neighborhood. The other thing I have is,
Mr. Evers, just real quick, so I just want to make sure the context is right. Is, if I'm looking on the right side
It
of
is-
the picture, that the applicant's building?
that is the Barefoot Beach building between Gulf Boulevard and Gulf Lane. So that is the 5-story over parking building that they built. Yes, sir.
Go ahead, Mr. Edwards. What would you like to tell me next?
So there had been talk also about these dumpsters. Let me give you a picture of the dumpster. Now, I know we're only talking about the rooftop activity, but I'm concerned about the enforcement of number 6, or item number, where they were going to talk about, doing city enforcement if there's more than 50 people up on the rooftop, if they are just guests there, that type thing. So these dumpsters have been around since they built the building. When they were going to build that building, and I'll reference it as the hotel because the other is actually a motel. When they were going to build that one, the plans actually said that they were going to have the dumpsters contained within the building. They had double doors and they were going to put the dumpsters in there. And after the building was built, they never put the dumpsters anywhere. About a year and a half ago, when they were asking for an alcohol permit and parking was an issue, and yes, they do have 73 units between the two buildings, and they said they had 75, and I talked to Andrew and I said, Andrew, 2 of the parking places are being used by these dumpsters. These dumpsters are supposed to be within a contained enclosure by city code, and he agreed. And Andrew and another employee went down there and counted parking spaces and came back and saw, yes, they were utilizing 2 of the parking spaces. So for months now, these dumpsters have been out in the north parking lot of that building, and they're supposed to be enclosed. The city has known about that they weren't enclosed for well over a year and a half and haven't taken any enforcement action. So that's one of the things that we're concerned about, is what kind of enforcement action is the city going to take if they can't even get these dumpsters enclosed? One of the things that came up in a meeting, and this was when we were going to address their alcohol permit back a year and a half ago, was how many calls for police service that they had. So Andrew had requested the community deputy to go ahead and run calls for service. And when he ran it, they found that between in 2019 to 2023 at the time, there was over 200 calls for service related to the property. And so I think one of the residents referenced it, and it also came up in a meeting again with the city on Friday. We have some police calls here that I was going to introduce as evidence also. And I've only got a few here. I didn't go through all 200 to go ahead and do that. And I have the Barefoot Beach Resort calls for service, which I have copies for the attorney and for you on this.
All right, so first of all, let me mark exhibit number 13 will be a photograph of the dumpsters. Mr. Unks, any objection to the photographs of the dumpsters?
No, sir.
I'm sorry, I only have one copy.
Can I look at it?
Yes, you
Mr.
may. Yes, sir.
Mr. Trask, any objection to this picture of the dumpsters?
No.
All right, I'll be exhibit number 13. Okay, take your time, Mr. Unks. Review what you have there. Don't feel like you're rushed. And I'll hear any objections that you have.
And as I say, I have a couple of police reports I'll give him to review too, so they
Yeah,
can be
that's
introduced.
fine. Do you have extra copies? Okay, you do, great.
Was this my copy of this?
Okay, Mr. Edwards, I'm looking at two different, one is an email from Mr. Morris, to Mr. Morris from Deputy Snyder.
And it
And
talks about some calls for noise and that type of thing.
Yeah,
I
loud
think.
music in courtyard,
sir.
possible noise, fireworks, okay, and I'm looking at a second one, which is an incident detail report for an event that occurred in December of 2020. Am I looking at everything that you've handed?
I think so, and I
Me?
think that might have been a complaint my wife had made.
Okay, I'll mark this as exhibit number 14. Mr. Ungst, any objection on this exhibit?
No, we'll address it.
Mr. Trask?
No objection.
All right. Okay, sir, and I went ahead and I've looked at it. And I'll accept into evidence as exhibit number 14, these documents. Let me make sure I've got everything from Mr. Trask. Okay. All right, I'll go ahead and mark as exhibit number 15 what appears to be a compilation of CAD reports. Mr. Ungst, any objection?
Again, we'll address on rebuttal, but no objection.
Mr. Trask?
No objection.
Okay, give me 1 second, Mr. Edwards, to review this quickly. All right, Mr. Edwards, go ahead.
The video that Mr. Klein introduced clearly shows that there was loud noise coming from an upper room on the 6th floor there, well over 120 feet. It appears that Mr. Huffman may have been there at the time on premise, that he's already testified that that was his truck there. They have zero tolerance, yet this video went on for 8 minutes that he recorded this noise going on, and it doesn't appear that any action was taken. This is just a sample of the noise that we had. I was walking down to my neighbor's house this past summer. There was a lady that had a huge boom box on the balcony for the pool side, and she was up on what would be the 3rd floor, parking and 2 levels up. And it was so loud, I could hear it 3 houses away, and no action was being taken. It seems if there's a person in the office is working, and I don't know if they can leave the office to address these noise issues, but it doesn't seem like they address noise issues. So what the neighborhood mainly is concerned with is noise mixed with alcohol. And I was in for law enforcement for 40 years. I've dealt with a lot of alcohol-related people. And you get alcohol, and a lot of people tend to get stupid when they have too much of it. And so it certainly appears that those in the upper room might have been having drank some alcohol. And so even though they're saying there's no amplified music is what they're suggesting, you can hear the noise that could be emanate from the rooftop. And the way the buildings are, it almost creates an echo effect. I mean, you got 2 buildings, and if they're yelling down in between them, it just kind of amplifies the sound. And that's one of the things, I mean, the neighborhood, you can see with the number of people that have addressed this with their letters. One business or one condo group even represents like 1,200 or 1,400 timeshare owners, and they were totally against having this type of activity up on the rooftop. We're concerned that the city, given past experiences, that they may not be able to enforce some of the suggestions that they're proposing, saying that only guests can use it. What about family and friends coming in? Before the city raised their parking rates, we used to see anywhere from 8, 10, and one day I even saw 12 cars in the city parking lot at 132nd Avenue, which is just 3 houses down from them, where people had stayed overnight. And people are coming from the Bear Beach and getting in these cars early in the morning to leave, which tells us that there was probably family and friends. They were not registered guests because they would have had parking space there. They only allow parking for a registered guest. And so that's the problem, is people staying over. You go to a hotel, they don't ask you, give me the names of all the people in your party that are going to be staying in the room. I mean, they don't do that. So the question is how is this thing going to be enforced with preventing it really being open to the public? You're going to have a lot more traffic because of this. The public health, safety, welfare, and convenience is protected. I can't see how our convenience is protected if you have vehicles parked on Gulf Lane that prohibits traffic from freely flowing up and down Gulf Lane because of a delivery vehicle that is there on a daily basis blocking traffic. And we look at that it's going to be even worse if you have a delivery truck for food or beverages there. So, I mean, if they're going to increase beverage sales, that's going to be a much larger truck that's going to be there. As I say, the dumpster issue, again, it's unrelated to the rooftop. It's related to city enforcement, which is the problem. And so because of that, and because of the number of police calls that have been there in the past, and we didn't pull all the calls, but Andrew will testified that he had a deputy pull, at least during that time period between 2019 and 2023, there's 200 instances. Now, some could be directed patrol by officers or whatever, getting out there, called for whatever assistance. But it seems like an excessive number of calls for that location. I think that's all I have right now. Thank you for your time, sir.
All right, thank you, Mr. Edwards, for that presentation. All right, Ms. Claiborne, I understand, is not here. Ms. Graham, going to give me your thoughts?
Yes, thank you, Your Honor. And I'll be calling up my client to testify in a minute as well. Also, one other thing is that I have a composite exhibit, which I'd like to walk through, but I'll do it in my testimony. And then when I'm done, I have copies for Mr. Ongstew and Mr. Trask.
All right.
All right. Good afternoon, Your Honor. My name is Jane Graham of Sunshine City Law, and I represent Cynthia Edwards, who lives on Gulf Lane within 300 feet of the Barefoot Beach property. She's lived there for over 40 years with her husband, Tom Edwards. Mr. Edwards is a retired law enforcement officer, so their address is private for their protection. If you need further information relating to their affected party status, we're happy to provide it privately or as needed. And so I do want to put that on the record. If there are any objections, let me know. As a
And
threat,
just, Ms. Graham, I hate to stop you. Everybody has stipulated, so I'm
Yeah.
treating them as affected party, and I find they are both affected parties.
excellent, thank you. As a threshold issue, I would like to make an objection to the process of having this requested change today without a development agreement. And I will do so on two different grounds. One is that if one looks to the idea that the development agreement has expired and that that this property is subject to the Johns Pass Activity Center standards, and I would say that the density of what has been approved is over the 50 units per acre, which is allowed for temporary lodging in the transitional zone. And because of that, and so that is under section D-109, 6B. And so because of that, there actually are alternative temporary lodging use standards under section D-112, which requires a development agreement is required by the city's land development regulations and Fort Pinellas countywide rules to use alternative temporary lodging use standards. And so that allows transitional temporary lodging density up to 75 units per acre. There are 73 units on this property, and currently the density is 59 units. And so we would just say that any change on this property should subject it to a new development agreement process based on these regulations. Now, on the other hand, if one were to take the perspective that the development agreement, even if it has expired, is still subject to the same applicable regulations that were put in place, which is on parens 18 of the development agreement, then we would look to section 21G, which is page 11 of the development agreement, that says that no changes may be made in these agreed upon dimensional requirements or any other matter that is reflected on the final site plan or addressed specifically in this agreement through an appeal process to the special magistrate for a variance, special exception, or other process. which would serve to vary or to change the terms of this development agreement and final site plan attached here too. Now, to the extent that there are changes, I would say that the fact that originally it was spoken to the proposed roof deck, fitness room and bar area means that what is being asked for is actually an expansion of this commercial area, which was not originally contemplated in the development agreement. So that said, we do object to this even being heard through this special exception process. Nevertheless, we're all here, so we want to go ahead with it, and so I proffer that objection. We're requesting you respectfully today to deny this special exception use for commercial use on an open rooftop because it is not in harmony with the purpose and intent of the city land development regulations and adversely affects the public interest as required by Section 2-506A and C and Section 110-122. You have heard testimony of others and will hear testimony as to why the proposed use fails to meet the standards and requirements for granting a special exception use as required under Section 110-124B as being incompatible with the adjoining development and character of the district where it is located. Now, sometimes the easiest thing is just to go to a definition, and I'll read you. Now, compatibility actually isn't defined in Madeira Beach Code or Comprehensive Plan, which is unusual, but we look to the Florida statutes, which defines compatibility as a condition in which land uses or conditions can coexist in relative proximity to each other in a stable fashion over time, such that no use or condition is unduly negatively impacted directly or indirectly by another use or condition. This is Florida Statute 163-3164-9. You have heard multiple testimony so far, and you'll be hearing more that speaks to the fact that this cannot exist, that coexist in a stable fashion over time, and in fact is causing injury. Now, what is your burden of proof? And I think that your city attorney did speak generally to the greater weight of evidence as being the burden, but Section 2-10A actually says that it's the applicant who has the burden of proof at the hearing to show by the greater weight of evidence that the application is consistent with the comprehensive plan and complies with the procedural requirements of law. And here they've failed to do so on multiple points. My client and I and Mr. Edwards met with city staff last week to discuss possible amendments to the proposed conditions. And we genuinely appreciated the opportunity for discussion and a mutual goal to find solutions. But it was illuminating and disheartening because what it revealed is that as we further discussed these conditions, we were unable to find language that provided adequate assurances to my client that the special exception use will be in harmony with the neighborhood. And in fact, you heard testimony directly from Ms. Jenny Silver today saying, yes, we think that this will be challenging as far as enforcement. That should give you red flags because here they're asking for something that is like putting a Band-Aid on a broken leg. It's just not going to fix a problem. Notably, based on pre-existing conditions that are unpermitted relating to noise, unpermitted events, parking violations, safety concerns, and incompatibility of expanded commercial use in an exclusively residential neighborhood. Again, there's some things that just can't be fixed. In the conversation with Mr. Morris, we do appreciate that there is a condition placed against amplified music under condition 1, but it doesn't address the tunnel effect that you saw from Mr. Klein's video of voices going back and forth. And when you look at the code, you find that it is true that Section 34-86 does, and it says prohibited generally. It shall be unlawful for any person to willfully make, continue to cause to be made, or continued any loud and raucous noise, which because of, shall mean any sound which because of volume, level, duration, and character, noise disturbs those in the city. But then it says that this term includes the kinds of noise generated by activities enumerated in Section 3487. And so in looking at statutory construction, it says that it includes. It doesn't say including but not limited to. So we do have to look solely to those acts that are in 34-87. And when you get to 34-87, you see number 7 is yelling and shouting. And it says yelling, shouting, whistling, or singing at any time or place so as to create a loud and raucous noise between the hours of 10 p.m. and 7:30 a.m. daily. And so the thing is that for amplification, which also has restrictions under this for hours, you can say, turn off your, turn off your speakers, we're okay. But for something like yelling and shouting, it's just very hard to govern. It's unenforceable. And so that's really, it speaks to why it's such a difficult situation to address. You'll hear from my client, Ms. Cynthia Edwards, in a minute, who's going to speak to some of her personal experiences living in the area of Gulf Lane for over 40 years. Before I do that, I would like to enter into the record. I'll call it a composite exhibit because it has a number of documents that are with it. One is a plat, which is actually Mitchell's Beach, Johns Pass plat from 1912. And it does have stamps on it, so it is self-authenticating. And what's interesting about it is you see that when you look at the history and character of a neighborhood, this has been platted for a residential community even back from 1912. And so, or excuse me, 1914, February 1914. And so it shows that the changes that have occurred throughout time are on top of this residential area. And so the residential area has been there first. I also have a photo, which is from the Pasco County Property Appraiser's website, that just shows an aerial view that does show where the Barefoot Beach is in relation to the other properties on Gulf Lane. And you can see the plats that show that they are largely smaller plats that are residential plats. And there are some larger ones as well, and you've gotten evidence that speak to, timeshares and multifamily. I've also included some photos on Google Street View, just down Gulf Lane, to provide context for the huge difference between Gulf Lane, which honestly, it's hard to conceive of it until you really look at it and how different it is versus Gulf Boulevard, which is on the other side, but which is, it's a huge thoroughfare. So it's, we're including that. I'm including some photos that my client had taken a while ago of dumpsters, the laundry, so you can see. I'm also including, this is something that had been referenced during my cross-examination of Mr. Morris. He had sent a letter relating to an earlier Barefoot Beach Club alcohol beverage permit application on February 23rd, 2022. And it is true, as he says, that this is a different application. It's not the same, but it does provide some additional context as far as what was requested and what is on the table today. In addition, there's a letter from John Bodziak, which is stamped, it's self-authenticating, that was sent February 3rd to 2022, that speaks to the idea that they were asking for an entertainment space with square footage of 830 square feet, which is different and smaller than the entire roof deck. And while we do not have a full accounting of it, according to the city, of what the dimensions are, it's relevant because it does speak to the fact that it's an expansion of a use that's potentially non-conforming. I've also included an email in this packet from Amanda Huffman relating to, and this is to Mr. Morris, that's relating to the roof deck drawing and the fact that they envision for using the rooftop for events of no more than 50 persons, but it goes to the idea that the idea is it's an event. It's, I mean, not every wedding is over 50 people. I mean, you can have quite a big party for 49 people with its own noise. I'm also including in this, there's a cutout of the wedding and events which are actually advertised on the Barefoot Beach Club website. And a copy of an earlier beverage permit application. And then finally, just sections of the code and comprehensive plan, which we believe are relevant for your review, which include just general burden of proof, conditions of rezoning, special exception, uses, noise. It'll let you review the sections that I mentioned about the noise issues. The idea that what are the penalties for the noise ordinance? And first violation is $50. A fifth violation is $500. So when you're looking at the costs and what is actually the enforcement, what is the mechanism, how, and while there is some discussion about the special magistrate being able to revoke the special exception, we believe that that's still not even clear enough. It doesn't give you enough guidance as a special magistrate or a future special magistrate of what flips the switch as far as when something really needs to be revoked. We've also included sections about nonconformities because we believe that if you take the position that the development agreement has expired, then what you're looking at is a property that's using a temporary use that's higher density that's allowed, and so you'd need a development agreement, and there's non-conforming uses require that there's shall be no replacement, enlargement, increase in activity, or alterations to any non-conforming use, permanent structure, or both. So that's another issue. I've also included Johns Pass Village Activity Center Development Standards for your review. And then finally, the special event definition, which is really interesting because it goes back to the idea of a special event, and this is under 4216, shall mean any organized meeting, activity, gathering, or group of 50 or more persons. But when you look at Ms. Huffman's email, she talks about events. She doesn't just talk about special events, and the concept of weddings or bachelorette parties or other kind of graduation parties that would happen. These are under 50 people. So these are all things to take a close look at. So with that, I'd like to enter these into the record as a composite exhibit. I have copies for you, Mr. Trask and Mr. Ongst. And then I'd like to call my first and only witness, Mrs. Edwards.
All right, why don't you pass those out to everybody first? And we'll give Mr. Ongst a minute to look at everything, same as Mr. Trask. I'll also take a look at it myself. All right, Mr. Ungst, do you have any objection to Composite Exhibit 15 or any document within Composite Exhibit 15?
Your Honor, just for the sake of moving this forward, I'm not going to object to it being included in the record, but I don't think anything related to prior applications or emails about prior applications, pictures of laundry trucks or dumpsters are relevant to the issue that's before you today, but you have the ability to weigh that for yourself. So I'm fine with them being in the record.
All right, Mr. Trask?
I would object to the following items being received into evidence as they are not relevant to the current matter before you. That's a letter from Mr. Morris dated February 23rd, 2022 on a previous alcoholic beverage permit application. The letter from Mr. Bodziak dated February 3rd, 2022 relating to a prior submission for increasing certain portions of the property for entertainment. That's not part of this application. There is one page that is part of something else. I don't know what it is. It starts at the top, items and gross sale alcoholic beverages. It's like right in the middle of some type of memo that was prepared. I don't know what that is from, and I object to that.
Can I see that?
This thing.
I would have no objections. I think that was accidentally printed. So that is, yes, it should.
All right, what I'm going to do is I'm going to put a big black X through that page, since you've agreed to withdraw that, okay?
And I would just say that as far
Can I
as the
finish my
letters.
objections,
I'm
please?
sorry, go ahead.
So there is also an email dated November 30th, 2023 relative to a previous alcoholic beverage permit application. It's not relevant. There's a second copy of Mr. Morris's memorandum dated February 23rd, 2022. This is in the packet. The alcoholic beverage permit application that was dated 2022 has no relevance. Object to that. Those are my only objections.
Your Honor, I'll amend it, join it, Mr. Trask objects.
All right. Mr. Trask, let me go through and make sure I'm looking at everything correctly. What was the first page you objected to?
It is a memorandum from Andrew Morris. It's 2 pages. It's dated February 23rd, 2022.
Okay.
May I respond or should I wait?
Let me just look at it real quick.
Okay.
And then, yes, I'm going to absolutely give you a chance to respond. All right, go ahead, Ms. Graham.
Yes, Your Honor. So that is provided as further background as far as the types of uses that had been requested before, and it contains information relating to the site itself as far as square footage and also of the city's interpretation of the development order. Now, what I would say is I am not including it in evidence in any way to say that the contents as specifically relating to that application relate to the city's position on the application in front of us, but it is being provided for the greater context.
I tell you what I'm going to do. I'm going to overrule the objection to the extent that I look at this as, and I'm not going to consider anything that had to do with the alcohol permit. But what I do see that is of interest to me, since one of the conditions is of the application relates to special events, and this letter does indicate there is a potential impact on nearby residential areas by expanding the use of the property with special events. I'm going to consider it for that limited purpose only. And then you said Mr. Bodziak's letter, Mr. Trask?
That's correct. Dated February 3rd, 2022. References Barefoot Beach alcoholic beverage application / parking.
Ms. Graham, tell me why this particular page of Exhibit 15 is relevant to what is before me right now.
I believe it is relevant because it speaks to the square footage of what was requested for the entertainment space. And if you look, that seems to only relate to the smaller indoor area on the rooftop, which also relates to parking requirements, and compare that to what is being requested, which is actually expanding the use to the entire rooftop. And it shows that at very least, there's an unanswered question about the dimensional requirements and what the change of use actually is and what had been previously allowed.
All right, again, I'm going to overrule the objection just based upon the special event issue, not anything to do with the prior permit. What was the other objection that I got? I already struck the one, and then going back to the second, it's just a copy of the same thing, correct? The two-page, February 23rd, 2022?
Yeah, but there's also an intervening email from Mr. Morris to me dated November 30th, 2023. It's relating to alcoholic beverage permit issued or applied for in 2022.
All right, I'm going to sustain the objection to the top two emails. I'm going to leave in the bottom one that reads, please advise on the below from Barefoot Beach Resort. They are apparently holding and certainly clearly advertising to hold special events, weddings, etc. My understanding is that events are not allowed. They agreed to only ancillary use per the 2015-2016 development agreement. See below. Apparently a wedding was recently held that created some excessive noise. Thank you. And that's an email from Robin Gomez to Ms. Rowan and Ms. Forbes on November 28th, 2023 at 2:31 p.m. All right, what else?
That was it.
Okay. And I think did you object to the permit application itself that's
Oh,
on?
I'm sorry, yes. The actual application that was submitted back in 2022 is in there too.
I don't have any problem with, if he wants that, with his objection, because I don't think that it really brings anything else. It had been included just for sake of being inclusive with documents.
I understand. I'll go ahead and sustain the objection on that just because I don't think that's something that directly deals with the elements. All right, Mr. Trask, anything else in
That's it.
Exhibit 15? Okay. All right, Ms. Graham, thank you for bearing with me. So I'll go ahead and admit into evidence exhibit number 15, with the exception of the pages that have a large X through them, and then with the pages where overruled the objection, that I'm admitting it for the limited purposes that I set forth on the record. So go ahead, ma'am.
Thank you, Your Honor. All right, I'd like to call my witness, Mrs.
All right, and then after Ms. Edwards, we're going to go ahead and take a break. We've been going at it for almost 4 hours now, so after Ms. Edwards, we'll take a short break.
My name's Cynthia Edwards, and I'm an affected party. I live on Gulf Lane. We own a house in very close proximity to Barefoot Beach. My husband's retired law enforcement, as you heard. We have owned our property since 1978. We moved into the house that we built in June of 1981. We raised our 2 children there. This is our only residence. We are full-time residents of Madeira Beach. Over the years, we've seen many changes to the quaint fishing village. The residential character of our immediate neighborhood has remained the same. Our neighborhood's a mixture of single-family homes, duplexes, rentals, hotel, motels, and one business, Total Realty Services. There's a mixture of modern homes, cottages, stilt homes. We have homes that date to the 1925s, although that one may have been washed away by the hurricane. Unfortunately, and I do have a list of those homes here, and the single-family homes and duplexes. Is this already in there? No, it isn't. Okay, this I would like to enter into.
That looks familiar. I think that may be attached to one of your husband's exhibits. Is it the same thing as this, Ms. Edwards? Or is it different?
No, that's the same thing.
Okay, great. So that, I'm looking at what's already been admitted as exhibit number 10.
Okay. The character of our neighborhood, and if you haven't been down there, you need to go down and walk the entire lane. Our neighborhood is the only true residential neighborhood directly on the beach in Madeira Beach, west of Gulf Boulevard. We are a very walkable community. Johns Pass Village is a few blocks down, and there's a couple of restaurants close by. People who live here are very friendly to one another and to the tourists who visit. A lot of dogs are also walked up and down the lane. The architecture of the homes are somewhat varies, but is mostly quaint, classic Florida, fishing village aesthetic in pastel and earth tones. This matches the character of the neighborhood of a quiet beachside retreat. My kids used to complain that the neighborhood was way too quiet. This isn't the first time in the 40 years that the development pressures have threatened to change the character and safety of our neighborhood. Back around the 1990s, the previous owners of the property, John and Lillian Stark, wanted to put in a family liquor store on the property at 13220 Gulf Boulevard. And this, I believe, is already in there. This is where they wanted to put the liquor store. They wanted a family-friendly neighborhood liquor store. The neighbors rallied against something that isn't part of family-friendly neighborhood, and the city listened. Our neighborhood safety and integrity was protected. Having a rooftop bar that allows groups of up to 50 people, whether they're hotel guests or not, is not in harmony with our neighborhood. Barefoot Beach Resort is not what belongs in a residential neighborhood. We are a residential neighborhood, and they built here knowing that. In 2020, I had to call the police because of a noise complaint based on an event at Barefoot Beach, which I later found out was an event that was unpermitted. I'd like to enter into evidence an incident report, and I think you may already have that. This was the Fish House party, and I did call. I did call down to the hotel twice. They said, okay, we'll take care of it. It continued, so then that was when I called the police.
All right, hold on, Ms. Edwards, just take a breath there. It
Okay.
looks like that is already in evidence as part of
Okay.
exhibit number 15. So, go ahead, ma'am.
Okay. So I can tell you that based on the Barefoot Beach's current operations, there's more than a minimum interference with traffic on abutting streets. There, while there is room for a loading dock that is at the north end of their hotel, it's not used. Instead, the trucks stop and go in the middle of Gulf Lane, notably the laundry truck. They come 7 days a week, twice a day. And they park between the two buildings that are on Gulf Lane, and you cannot get by them. And I do think that this is part of you know, their application here, because they state in number 6, and I don't have all of it here, that they have adequate off-street parking. Well, they don't use their off-street parking. And I do have the dates and the times that I took these pictures.
Mr. Ronks, you want to come up here and take a look at these? I think they're just dated copies of a picture I've already seen. And then will you hand those to Mr. Trask when you're done examining them?
No objection.
All right.
The,
Ms. Edwards, just so the record's clear, I'm going to go ahead and I'm going to mark these as exhibit number 16. Go ahead, ma'am.
The special exemption also requires that adequate screening is provided. The development agreement required that the dumpsters would be contained within the property and fully screened. And I do think that this is part of the development agreement. And I have my pictures of the 2 dumpsters.
And I've seen, if that's the same one I think your husband showed me.
No, I don't think it is, but you can
Okay.
see that this is the parking lot right here. There's
We cannot hear that.
All right. First of all, Mr. Ronks, this, I'm going to go ahead and look at this, but I already have sufficient evidence in the record to show these things. So I'm not going to introduce this as in a separate exhibit. So we just hand
That's
that back
fine.
to Ms. Edwards. Thanks.
Thank you. Most unsettling is that the Barefoot Beach freely admits that this is their first step to getting a liquor license. And in the application, they make it clear that they wants to serve drinks, not just on the rooftop, but poolside, which is on the other side of Golf Lane, directly next to the single-family home of Ron and Rose Lockett. It's incompatible to the open door to allow this use into our quiet residential street, putting us at risk. I strongly urge you to deny this application for a special exception, which is on the face is incompatible with our neighborhood. And if it goes further to a liquor license, it'll be much worse. Golf Lane neighborhood is a bedroom community within Madeira Beach. I strongly urge you not to approve the rooftop usage. And, you know, if you buy a home next to an airport, you really don't have a right to complain about all the noise because you chose to move there. Barefoot Beach chose to move into a residential neighborhood with single-family homes.
Is that all, Ms. Edwards?
That is it, I think.
All right. Ms. Graham, I'm going to give you a chance to talk, but literally it's 4 o'clock now. We've been going for 4 hours.
I have nothing else.
Me and the court reporter, I think, would like to take a break for sure.
Yeah,
So-
Your Honor, I have no intention of saying anything else. I was actually just going to confirm that with my client that she had entered everything into the evidence that she needed to.
We good, Ms. Edwards? I tell you what, take the time during the break.
Okay.
And if there's anything else you want to tell me, I'm going to ask you first and then we'll go on.
Okay.
For the lawyers, I want different people to do different things. I want you guys to be thinking about where I'm going. It seems like a lot of the comments are conditions 2, 3, 4, and 6. So Mr. Unks, be prepared to address that when you come back up, as in addition to anything else you want. Mr. Trask, if you wouldn't mind thinking about the legal objections that were made in regard to the what Ms. Graham argued there in regard to whether a development agreement or any other procedural issues that Ms. Graham has brought up, if you would be prepared to address that. And of course, Mr. Ungst, you can address that as well. But I would just ask the lawyers to be prepared to address that issue and any of the legal arguments that she made. For all the lawyers in the room, if there's any case law you want to provide to me, I've heard arguments so far today about, what is adjoining, what is substantial injury to value of the property. And in the application of any of those particular conditions, 2, 3, 4, and 6 especially, if there's any case law or anything else you want me to review on that, just be thinking about that for your closings, okay? All right, let's take a 10-minute break, and we'll come back and we'll finish up with Ms. Edwards and then go on to Mr. Bello. All right, everyone, if you can go ahead and take your seats, we're going to get started so that we can get on to everything else. And for all of those who are on the agenda afterwards, thank you for your patience. We're getting near the end here. So where we left off was, I said, Ms. Edwards, if there's anything else you'd like to add, I was going to give you that opportunity. Are you finished?
Ms. Edwards is finished. Thank
All
you very
right.
much, Your Honor, for your.
And I would like the record to reflect that during the break, I went ahead and I reviewed all of the documents again that were given to me. So I have now reviewed all of the additional documents. Okay. Mr. Bello, are you still here? You want to come forward? All right.
All right. Good afternoon, Special Magistrate. My name is Robert Bello. I own a property across the street from Barefoot Beach at 13301 Gulf Lane. Kind of like Rose said, it's kind of difficult for me as I consider the owners of Barefoot as good friends.
Can you pull up the microphone,
And-
Bob? Pull up
What?
the microphone.
Okay.
So we can speak into it.
Sorry. And I hope, just speaking up like this won't fracture friendships. At the same time, I feel I have to voice concern about the use case that are being implied that I feel is inherently incompatible with the character of the neighborhood, and I want to make sure to have my right of quiet enjoyment of my house. So for that, I'm extremely happy about the proposed restrictions that the city has placed. I followed different versions of this application for a while with the city and have always been strongly opposed to events and a liquor license on a property. And I kind of see those two tied together hand in hand. I've had the opportunity to speak with city staff about this application and appreciate the time they took at further improvements to the conditions. They're always great to work with. My concern is even with those conditions is I'm concerned with how things will play out in the real world. Is things that look great on paper don't always work out in the real world. Because commercial use is inherently incompatible and adversely affects residential public interest within a neighborhood, I have concerns with this moving forward as I don't want see this area turn into a John's Pass, like with bamboo and all that sort of stuff. I'm not sure if you're aware of it, but outside of Gulf Lane, there's only 3 other houses in the entire city of Madeira Beach that are on the sand. So you've seen the stuff, 28 single family, 7 duplexes. This 5-block stretch of Gulf Lane is unique. When house hunting, we specifically looked for a house that was on the sand and not on Gulf Boulevard and had a residential feel to it. We searched Clearwater to Pass Grill, and Gulf Lane was a hit. It's an amazing little area. There have been multiple instances in which noise from the rooftop has just bounced around inside my house because I'm catty corner to them. And to the point I couldn't relax, concentrate, watch TV. And I have impact windows, so they're fairly well blocking sound. Now, to be fair, I try to look at it from a business person's perspective, and I denying them a right to maximize their profitability. I would argue not really, as them getting the ability to do the extra story of hotel rooms, they've realized profit from them over the years, and that they would still not be even entitled to under the current code, absent, I guess, a PD. So it kind of seems like they foregone some of those rights in exchange for the heights. So in conclusion, this is my home. I simply want the ability to continue to enjoy my home. I love it here in Madeira Beach, and I want to spend the rest of my days in this amazing little town that I'm so passionate about. Thank you.
Thank you, Mr. Bello. All right, now, while Mr. Bello was going through his presentation, I have received another set of emails. It looks like this is from Mr. Loggett? Is that right, Mr. Trask? Am I looking at the right thing that we've just been handed? Okay. Hold on. I tell you what, Ms. Leggett, are you going to come up and talk to me in a couple minutes? I'm just going to hold this off to the side. When you get up here, you talk to me about it, okay? All right. Okay, Ms. Ray, have you shown up? Barbara Ray? Okay, Michael and Elena Costa, are you guys here? All right, Mitchell or Sandra Rayborn, or either or both of you guys want to come up and address me? All right, come on up, Ms. Rayborn.
First of all, thank you for letting us have a voice. I have to admit that if I was a stranger sitting over to the side and I met the Hoffmans and their lawyer, did a bang-up job. Then I met Mr. Morris, and I thought he tried to make a happy medium on how to try to please the residents and please them. However, as a resident, as someone who has lived there with their kids, with their grandchildren, it is imperative that we keep the community a community. One of the things that really struck me, I was at the last meeting, and I was watching all the notes on the board, and there were, I think it was like City Week or some kind of event that you guys were sort of celebrating for the city. And it really struck me because one of the things that you were passing, it said Florida City Government Week. That's what it was. And one of the things says, whereas City of Madeira Beach will have direct daily impact to enhance quality of life for its residents, making their city their home. That was a goal of yours. I love it, and I hope you keep it for us today. I had this written down to say before I even arrived. I've listened to a lot all the way around, and the only other thing I could say to the Hoffmans or anyone else who wants to do this, you can put it in your backyard and do the best you can, but please don't put it in my backyard. Thank you.
All right, thank you, ma'am. Mr. Rayborn, your wife said everything you want to say too? Sure has. Okay. Now let the record reflect Mr. Rayborn has deferred to his wife. Okay, Ms. Loggett, your turn.
I think Bob Bello and I are on the same page as far as, our relationships with the Barefoot Beach Resort. And it's kind of hard to do this, but again, we do feel compelled to speak up. Just to clarify what you received, it's an email, and it really, only page 1 is relevant at the bottom. It's one of our guests that actually was letting us know that about the noise and the car's doors slamming and how it upset the dogs and a rock actually being thrown and hitting our windows. So we would like to submit that into evidence.
Mr. Ungs, have you had a chance to look at this?
No, sir.
Take your time. Mr. Trask?
No objection.
No objection, okay.
We don't have an objection. I just want them to be able to read it.
Take your time. All right, I'm gonna go ahead and, ma'am, you said just the first page is the, what you
Yes.
want to go into evidence? All right, I'm gonna mark that as exhibit number 17. And that will go into evidence in the record here as exhibit number 17.
Okay,
All
thank
right.
you so much. As you stated before, my name is Rose Loggett. My address is 13231 Gulf Lane in Madeira Beach. We've lived on Gulf Lane since 1976. As longtime residents of the Tampa Bay area, Madeira was chosen because of its old Florida beach community. I'm an old surfer. I used to surf all the way from Paso Girl up to past Clearwater, only when there was waves. Gulf Lane was a small, primarily residential neighborhood where neighbors knew neighbors. The Little Gem was a much sought-after walkable neighborhood. Madeira itself was recognized and still is as a small, quaint fishing village. Even the master plan of the early 2000s cited that this was chosen as the identity of Madeira Beach. In fact, there was no locations west of Gulf Boulevard that were selling alcohol except for the now closed Skip's House of Rock and Roll, which many were glad to see go due to the loud music and ruckus. The property directly north of us was called the Sands of Madeira. It was a mom and pop hotel with cottages. The Stark family were the owners and our neighbors as they lived on premises. When they built the 3-over parking building to replace the cottages, they were mindful of the impact on the neighbors in the neighborhood. There were no large, loud music or parties. The ambiance of Gulf Lane as a hidden gem for Madeira Beach was maintained. Though the section is in the transitional area, the Gulf Lane neighborhood's quiet beach life residential atmosphere draws a different crowd. It's not Clearwater Beach, nor is it Treasure Island or St. Pete Beach. It is an old Florida residential beach neighborhood. It is, however, only a stone's throw away from the party atmosphere offered at John's Pass and other beaches, so visitors can enjoy the laid-back beach atmosphere, but still have access to the much more commercial party atmospheres. The Sands was purchased and turned into the Barefoot Beach. At first, it seemed to continue to blend with the existing neighborhood. Barefoot Beach then unveiled its plan to build a 5-over parking building, which would, much to our surprise. We were told the building was to obtain variances granted by then current city management. These variances were not to build in front of the existing structures, but I think you heard, they wanted to skew it all the way to the south in front of the homes and up against the other home that's directly south of them. They proposed not to build in front of the existing structure because we were told they could sell the condos at a higher price because they can see over the houses and they wouldn't be blocked by their own building. They also requested that Gulf Lane be vacated. That would mean that we would have only one way into our house. Luckily, the fire department objected because it would impede emergency traffic should there be a blockage on Gulf Boulevard. There were bold statements that were made that they could build whatever they wanted. The city management at the time also seemed to support the development, and when I told them that, reminded them that even on the website, it stated that we were a small, quaint fishing village, it disappeared quite quickly. It became evident, unlike the cooperative approach of the Starks, that the objective was to build bigger and better to increase Barefoot revenues at the expense and adverse impact on Gulf Lane neighborhoods and neighbors. Some of the impact has been increased traffic on Gulf Lane. There's also a stop sign only on one side of the driveways of Gulf Lane, which is an accident waiting to happen. People don't realize that it is a street and they walk out, but cars also shoot out of the parking lot on the side that doesn't have the stop sign. And it's pretty scary sometimes. Again, the infamous linen truck that parks there and blocks their driveway. It seems simple, and it was stated that it's only occasionally, but it does make a difference because you already are committed. When you come off of Gulf Boulevard, you turn south, and boom, you can't go anywhere. You have to either wait for them to decide to move, or you have to back up onto a thoroughfare and go all the way around. There's cigarette smoking because it's not allowed on their premises. They come over and they hang out in front of our yards, and it's full of butts, and they use our yards for ashtrays. There's liquor bottles and beer cans being dropped over our wall onto our property, and in the back where the cabanas are, there's a lot of them that we've dug out. There's also yelling back and forth you've heard of from the big building, the 5-story, to the pool, and from the other building out to the beach. And the guests don't seem to really know that there is a house next door and there's people sitting there. The large storage boxes on the beach rental, for the beach rental chairs, used to be up against the seawall by the Barefoot, but they're now out on the beach and quite visible, which disrupts the beauty of our beautiful beach. They also, please note that they broke loose during the storm, and also the chairs were not secured, so that they ended up all over the Barefoot. In fact, I think Aaron said it crushed his wall in the front, and we've had to dig out a bunch of pieces of those chairs that came up against our house and pushed our deck. The kiddie pool area and the partying atmosphere of the cabanas, it gets quite noisy. Again, they bring their own boom boxes, but the sounds from the amplified pool speakers also are pretty loud. Sometimes the music is set so that the bass level is vibrating our house. And being a good neighbor, I call either the office or I call one of the maintenance men, or Aaron gets text or calls from me as well. But it's, we've tried to maintain, because we're not there all the time, but when we are there, we would like to enjoy the solace of our house. So therefore, I think the number of police reports, I don't want to use our law enforcement officers' valuable time for noise when I can deal directly with the owners. There is also a lack of 24/7 premises management, so it is hard to supervise some of the activities. The impact already to our peaceful, walkable neighborhood of Gulf Lane is definitely different than what it used to be. The old charm of Madeira Beach in this area is experiencing an invasive and increasing disturbance. I use the adage, they pave paradise and put up a parking lot, and that keeps coming up because it seems that bigger and better keeps coming up, and they keep winning, and we, the people that have been here supporting Madeira Beach for the longest time, are paying the price. It's our paradise being paved over. Initially, the proposal was for a rooftop activities and liquor licensing. Therefore, neighbors did have a meeting with Aaron to hear his plans and perspective, and the neighbors were quite surprised when he actually stated his objective was to make more money. It seems that there was a lack of disregard, for the neighborhood and the change of its ambiance. Gulf Lane neighbors and the city surely understand business and profitability. We also understand the responsibility of new developments or enhancements to ensure that what is being proposed is not detrimental to the existing ambience and lifestyles of the neighbors and neighborhoods, and the value and attraction to our quaint little fishing village. We're doing a lot down at John's Pass to do that, and just because we're in a transitional area doesn't mean we need to carry over the more commercial atmosphere. The city should weigh the compatibility and breadth and scope of the owner's desires to make money at the expense of neighborhood lifestyles. One questions why there are no liquor licenses west of Gulf Boulevard except for Archibald Park and Caddy's. but those locations are situated in quite different areas than Golf Lane and its residential environment. Though the hotel is west of Gulf Boulevard, the intent, as we understood it from that meeting, was not only to serve liquor on the rooftop, but allow orders to come from the from the pool. I'm not sure if that has come up before, but that would mean crossing a public thoroughfare to provide alcohol at the pools. But there are examples in some cases of the Panhandle, Manatee, and Sarasota counties and beyond, where old Florida quaint and laid-back communities are located. These cities have made decisions and put in provisions, including building styles to ensure the continuance of what made them so attractive to those seeking the solace of beach life. We are asking for your considerations, and those considerations should include the impact of setting the precedents for the sale of alcohol and rooftop activities in our neighborhood. The fact that the two Barefoot Beach properties are separated by a public roadway called Gulf Lane. Additionally, as Aaron explained, liquor would be sold on the Gulf Boulevard building with the intent to take it across the street to the pool. My question is, who's going to supervise these activities and the consumption of alcohol? As most people know, many of us don't come to the beach to listen to music. We come to enjoy the natural sounds of the beach and the seagulls and the waves, and to take breaks from the day-to-day hustle and bustle. That's what Madeira Beach neighbors want. Those who want a more party atmosphere have many other options. Adding another location that is in the middle of a primarily residential area is doing an injustice to those people who have lived here in the neighborhood and have supported Madeira Beach for a lifetime. So I request that the city does not approve the special exception use request. Thank you for your consideration.
Thank you, ma'am. Okay, now is the time of the hearing for any persons who are not parties that would like to testify. Mr. Trask, do we limit these at all in time, or since it's quasi-judicial, as long as they have relevant information, we'll let them continue on?
It's the latter. Under section 2-9, paren D, it says, other parties shall follow the city in order their filed notices thereafter. Persons who are not parties may testify. Lastly, the applicant and the city shall be permitted to provide additional evidence to rebut the evidence presented by any other party or person.
Okay, all right, so are there any other members of the audience that would like to come forward today and tell me anything about this application? All right, if you do, great. First of all, has everybody who's getting ready to come talk to me already been sworn in? Were you here at the beginning, or is there anybody who came late? All right, Mr. Trask, can you just go ahead and swear in anybody who wants to talk to me that hasn't already talked to me, please rise and be sworn, okay?
You swear the testimony you're about to give is going to be the truth, the whole truth, and nothing but the truth? Okay.
Yes,
I
we hear
saw
it, yes.
2 head nods.
Okay, is that a yes? Can I hear a yes out loud? Yes, yes, okay. All right. Gentleman wearing the orange, you raised your hand first. The way this is going to work is when you come forward, please give me your name so it's clear on the record, and also give me your address, and then tell me anything you want to tell me about the application for or against it.
Hi, my name is Jim Beggins, and it hurts me to be here because my son called me before and said, Dad, will you handle this for me? Because I got to take my kids to the airport. And I'm listening to this. I came to Madeira Beach about 25 years ago, and when it was called the slum of the beaches, people would drive through Madeira Beach to get to Clearwater, get to Treasure Island, or get to Reddington Beach. And last year, I think it was the best on the beaches. We had the devastation of the hurricane, and 3 years ago, Ian almost hit us. I live on the beach over here. And it went south and went to Fort Myers, and it was 17 months before the price of the real estate came back to the day before the hurricane hit. It is now almost 7 months since our hurricane, and the prices are continuing to go down, and the economy in the country is worse than it was 3 years ago, so I would predict that it would go down for the next 12 months. As a real estate broker, what we're saying is do not sell. That's where we make our money in selling, because people are crazy to put their houses on the market right now. My son asked me to come over here because I know the owners of Barefoot Beach Club. I know what they went through with the storm. I know what they had to pay to do things. I know the shelter that they gave to the people that were taking care of people here, just like the Cambria Hotel. I was fortunate enough to be the listing agent of the Schooner Hotel, and we sold that, and it got wiped out in the hurricane. We lost all our money there because we were getting enough money to pay the rent on the land, and that was destroyed. And frankly, I'm going to get out of the Schooner, because if it comes back again, I don't want to go through this stuff. People saying, oh, we don't want an improvement, a 56-room hotel on the beach with a bar on the roof or whatever. I'll just go to some other town. What we're trying to do right now, what I'm trying to do is develop safety nests, new construction, modular homes to build the homes up for the people that have lost them on the beach. When you go up and you find out the vacant homes, and these people have great opportunities, because this is the best development in the country right now, because FEMA says you got to build new. Every time we build new, we're going to build a new community. So I thought this hurricane would mean neighbors helping neighbors. I'm not sure that's happening. And as a neighbor, I want to help the neighbors. We're not making any money as real estate brokers for telling people not to sell, and I'm going to put my son in his room for 2 months because he had me come out and sit here for 5 hours. So thanks for letting me share.
Thank you, sir. All right. Ma'am, come on up.
Hello. Good afternoon, Special Magistrate. My name is Andrea Bello, and I live in a house catty corner to Barefoot Beach on Gulf Lane at 13301 Gulf Lane. I love living here in Madeira Beach. It's an amazing community and run very well by the city manager, Board of Commissioners, and the city staff. It's also our home, and we are not snowbirds. We love all the neighbors we have met and become good friends with over the years. It's quite common for us to meet multiple times a day and stop to chat for 15 minutes as we walk our dogs on Gulf Lane. When Bob and I were looking for a house, we wanted to make sure it was a house. Condos and such were not conducive to our lifestyle, and we were willing to pay a premium to have a single-family house on the sand in an area that we felt like was a normal residential area. That is how we came to fall in love with Gulf Lane. And the only other places we found to be similar, from Clearwater to St. Pete, are the 3 following areas: Sunset Lane and Reddington Shores. That is only 1 block. Lee Avenue and Reddington Shores, that is only 1 block. And finally, First Street and Treasure Island, that's only 2 blocks long. That's it. So 5 blocks of predominantly single-family houses on the sand here in Gulf Lane in Madeira Beach is an anomaly, and it's magical. You also want to note that these houses have been here for years, well, mostly decades before Barefoot was even built, never mind the second Barefoot. Over the years, there have been a few what I would call noise events that were not tolerable, and it was stressful not knowing how long it would last, with the noise ordinance not kicking in until 10 or 11. When these happened, it could be hard for me or Bob to hold a conversation. Was Barefoot doing this on purpose? I don't believe so, and I don't think so at all. They're very nice people, and we get along with them very well. But unfortunately, this is a byproduct of commercial activities such as weddings and similar events. And to that, I have a debilitating illness that includes migraine headaches. And the doctors have been treating me for years, and noise is a major root cause to kicking one off. I'm on Nurtec, which is the most powerful migraine medication, and my doctors can only prescribe me 16 doses a month. So if I use them, I don't know when I'm going to have the amount of medication that I need. We are deathly afraid that if use is granted, it'll become a normal occurrence and destroy in our neighborhood in the events, between the events and alcohol. There are plenty of alcohol options that tourists can utilize, from the 7-Eleven a few blocks away to John's Pass. I'm extremely concerned that we will lose our unique piece of paradise, and that's all I have to say. Thank you.
Thank you. All right. Sir in the black shirt, I think you raised your hand. Or which, you guys choose among yourself who's coming first. All right.
The darker shade of black will go first, I guess. All right, Jeff Beggins. I own one of the parcels across the street, and 429 Bocasiga Drive is where I live. And I see this from a real estate perspective a little differently, right? I see this as I respect a lot of things people are saying here. I think there's a property right issue where he's got a hotel, he's just trying to serve his hotel guests. It's not like he's trying to open up a bar. So I think that it's being a little pushed that way. The other thing I find really interesting is most of the people, with the exception of one, this isn't even their homesteaded property, right? It's a vacation rental where they get people, and then one of the person that is homesteaded actually vacation rents too. Totally different issue. We talk about that, a different issue. But when the position of this a nice little quiet single-family residential home, the zoning on this neighborhood has always been, you could build condos there, you could build hotels there. If you wanted a residential home, there's places to do that. It's called Bel Air Beach, called Reddington Beach, and it's the zoning. It's the zoning that it's been all the time. So I think the portrayal that this is coming in to destroy just a residential area is not a fair assessment of what it is. And I just think from a property rights perspective, as a real estate broker, I just stand up for property rights, and actually knowing where you buy and what's surrounding what you buy is an important aspect. And that's where values are higher in areas that are zoned single-family residential than that. So I think the request is very fair, and I think it's just to serve hotel guests. I think there's no question that it should just be approved. So that's my statement.
All right, thank you, sir. All right, next.
Good afternoon. My name is Marcus Winters. I operate a couple of the restaurants that have been mentioned here today, Caddy's and Mad Beach Cantina. The Barefoot Beach Resort, they run a good show. They wouldn't have the reviews that they have. They give a lot of people jobs in the area. And, you know, I think by granting this, it was originally granted when the PD was done. Okay, they didn't open it up straight away. So now the PD is old or has expired, but they're only doing something that they want to do for their guests. I think a lot of people, you know, are saying, well, there's alcohol involved and there's noise involved. But the guys at Barefoot Beach Resort, they run a tight ship. They're going to employ staff. Staff are going to control alcohol consumption of people. They're going to control the noise of the people. You know, these guys do a great job in the area. Anywhere around the hotel always looks clean, always looks nice. And they're only trying to do something that, in a right, it's a hotel, they should be able to serve to their customers. So I think you should grant it.
Great, thank you, sir. All right, anyone else? Any other members of the public want to come forward? Okay. Mr. Trask, correct me if I'm wrong. If I'm reading the process correctly, the applicant and the city shall now be permitted to provide additional evidence to rebut the evidence presented by any other person or party. So I'll go to Mr. Unks first. That'll be correct, Mr. Trask?
Correct.
Okay. All right, Mr. Unks, this is your opportunity to come up and provide a rebuttal to everything that you've heard here today.
Thank you, Your Honor. Can we get this, the applicant PowerPoint back up, please? I just want to reference those conditions of approval, Your Honor, since you asked us to be thinking on those in light of what we've heard throughout I've got it here, okay. Throughout the hearing. So first, Your Honor.
Mr. Unks, too, if you go to this one right here,
Mhm.
or maybe that's picture two. We're talking about, just can you point out where this rooftop use would be?
Is that, can you guys point to it?
center vestibule on the very
The center, I
Gotcha.
want to explain it. Yeah, that's the enclosed portion. That's where the elevator is, and that's the enclosed portion where if you look on the site plan, it says conference room, I think. Let's see, there's the site plan. So you've got the conference room, that's the enclosed portion, and then you've got an area that's called covered deck and sun deck. And then that goes out towards the beach.
Understood. All right, thank you.
All right, of course. So Your Honor, you asked us to hit you with some case law. So I'll start off with some case law that I would like for you to consider and bring to Your Honor's attention. And that is Catherine Bay versus Fagan. The citation is 52 Southern 3rd 19, and that's Catherine with a K and Fagan, Fagan. And that related to appeal of a quasi-judicial hearing where obviously the standard is competent substantial evidence. And the appeal focused on what is competent substantial evidence in a quasi-judicial hearing, which of course you know, I'm sure as an expert yourself very well. But that case reaffirmed that when you have expert witness testimony about things regarding compatibility, and those things include noise, pollution, traffic, when you have expert witness testimony from Mr. Morris, that's compelling competent substantial evidence. When you have lay witness testimony regarding compatibility and home values, both of those issues are addressed in Fagan, that is not competent substantial evidence unless it is accompanied by some other evidence. So you really need expert opinion testimony in these quasi-judicial hearings, and the case law is very clear that staff rep reports are strong competent substantial evidence. The application itself is competent substantial evidence. And with all due respect, Your Honor, I think you've heard a lot of opinions, lay opinions today, but I'm not sure you heard a whole lot of competent substantial evidence that in any way could overcome the strong, compelling evidence submitted by Mr. Morris in his staff report and in his testimony and on cross-examination. So from a legal perspective, the applicant, I think, has more than met their burden based on any reading of the case law, along with the staff support. And I don't think you've seen anything that would rise to the level of allowing the court or Your Honor to tip the scales in favor of the lay witnesses because, again, the standard, I think, has been met, and their standard, the presumption that switches back to them has not been met, in my opinion. And that Catherine Bay versus Fagan is very clear on that issue. And I don't want to get into a tit for tat on all of the issues, but I do want to just point back out to the court what's exactly before you today. And that is a request to have a ancillary commercial open rooftop use in the transitional character district of the C1 Johns Pass Village Activity Zoning Center District. And I think Mr. Bagans was, I think it was appropriate to point out that this zoning is consistent with the neighborhood. The neighborhood's also in this zoning, and that many of the properties that are single-family homes are also rented out for commercial uses. I think that's important for the court to understand, particularly from the compatibility argument. Going back to the development agreement, on page 2 of the development agreement, in that table of uses, it talks about ancillary rooftop bar with typical and customary limited food service for hotel guests for their convenience only. That's what was approved by the Madeira Beach Board of City Commissioners back in 2015. That's what was understood to be the use of the rooftop. Yes, the sun deck is there and the fitness room is also listed as a use, but this use was always contemplated by the original developer. Obviously, the folks who lived in that area at that time would have had notice of the hearing. They would have had an opportunity to go to the city commission hearings and be heard. And the city commission specifically legislatively found that that use, amongst all the other uses that were approved for the hotel, was consistent with the city's comprehensive land use plan and the development regulations of the city. So I just wanted to address a couple of the specific things. Again, I don't believe these issues are before you for the open rooftop balcony special exception use under section D-105 subsection 6 subsection C. But Today was the first that my clients were made aware that the laundry pickup and delivery is causing any kind of an issue. And they were able to text during the hearing, and that has been resolved. The laundry truck will not be parking in the street anymore. I don't think that has anything to do with the application that's before you, but I do want you to know, and I want the neighbors to know, that if you reach out, Ms. Loggett, to Aaron and Amanda with a specific complaint or issue that needs to be resolved, they will resolve it. So I want you to know that. And the dumpster issue, again, I don't think the dumpsters are before Your Honor today as it relates to this application, but the dumpsters were in the enclosure that they were designed to be in, and the city actually asked for them to be moved so that they could be more easily accessed by my client. But my client is more than happy to enclose them or put them into an enclosure. But the city asked that they be moved out of the permitted enclosure so that the sanitation trucks could access them. And of course, sanitation is part of development review, so you'd think that would have come up during the development review process, but apparently this is more convenient for the city. So my client is happy to resolve that issue and work with the city and work with the neighbors to resolve that issue. I don't think it needs to be addressed by Your Honor, though, as it relates to the rooftop issue. So what are the relevant conditions for the rooftop issue, again, that as recommended by the staff? I think the first one gets to the heart of the matter. You've heard a lot about events. You've also heard a lot about noise and music. If there is no amplified music, if there is no noise problem, then it doesn't really matter if there's an event or not, right? Other than that's the root of the concern is this is going to be a party deck, you've heard. It's going to be raucous. There's going to be all these issues. So the no amplified music and no amplification of sound, including but not limited to radios, stereos, karaoke machines, and television shall be permitted on the open rooftop. That's an objective thing. You know, if the neighbors have a video of the rooftop with amplified music or a microphone or a megaphone or some amplification of noise, that's not something that is going to be difficult to dispute or acknowledge that, yes, that happened. And you have the ultimate authority then to enforce these conditions. You always retain jurisdiction in your orders, and this would be no different. And so my clients are already operating under, you know, these assumptions that these rules apply. Number two, I will admit, is kind of inartfully worded. It's a little confusing, but the issue is they're trying to differentiate between what's defined in the city code as a special event, which is 50 persons or more. There is no definition of a non-special event or a regular event, right? So basically what this condition, the intent of this condition is, there are no special events, period. No events as defined by the code. The only events, quote unquote, that would be allowed would be for hotel guests only, and they have to have less than 50 people. I understand you could say, well, how am I supposed to know if there's 51 people there or 51, you know? I get that that can be an issue, but if there's no noise problem, then why is it a problem? It's really not. If there's no amplified music problem, if the 51st person that's a hotel guest isn't creating some problem for the neighbors, then it's really a non-issue. But we'd be open to making that more clear. Something like, you know, no special events as defined by the Land Development Code will be permitted. I think that says it, because if it's less than 50 people and it's guests of the hotel, then by definition, it's not an event. It doesn't require a permit. So we may be able to just get rid of that first part to reduce the confusion. The third condition, as the city said, it has been enforced and is a regular condition of alcohol uses in the city of Madeira Beach. 60% of the sales have to be from food and non-alcoholic items. And again, this is for hotel guests only, not a public restaurant, not a public bar. And that can be confirmed with by requesting the books and records of the establishment. And that's what goes along with this condition. We have to turn that over. If we refuse to turn it over, then you pull our license. That's the outcome. And they've already done this with Caddy's, and Caddy's is in compliance, and Caddy's provides the regular updates. And the Huffmans are absolutely willing to do the same thing. So I don't think there should be any confusion. It's pretty clear. It's standard. It's a standard condition in the city of Madeira Beach that the city enforces on a regular basis. The fourth one, again, is that this continues the intent of the development agreement. We've talked about that quite a bit. That allowed for the rooftop bar and the sun deck. and that they're ancillary uses. The development agreement even states that because of the minor ancillary nature of the uses, that parking won't be an issue. The fifth condition I don't think is an issue. No lighting is changing, and we comply with the sea turtle preservation regulations. And then finally, again, you have the ultimate authority, Your Honor, to retain jurisdiction. And one thing I also am quite clear about, Your Honor, after this hearing, is that the neighbors will be holding the Huffmans accountable. So I am sure that they're gonna be hearing about it, and I'm sure that the city's gonna be hearing about it, and I'm sure that you and I will be hearing about it if there is an issue. And hopefully, there will be no more issues, and all these other concerns about like the laundry truck and the dumpsters can be brought to their attention and resolved and taken care of. The only other thing I wanted to point out again, this whole argument about 50 people versus 60 people, this is a hotel key card access rooftop only. You have to have a hotel room key to get there. That doesn't mean you couldn't hand out your key to your friend or whatever, but it's still a strict limit on how you access that. It's a hotel key. You must have an active, valid hotel key. They put wristbands on their guests. They do not allow non-guests to use their pool. It's a boutique family hotel. So the wristbands are another thing that they've implemented. And they've also implemented this 24-hour on-site manager who's there all the time. And that may be, Your Honor, why when you looked at those police reports, by the way, you probably noticed only about 8 of those said noise. The vast majority of them were unrelated. But if you look at those police reports from 2020 to 2023, you hadn't seen any police reports from 2024. You haven't seen any police reports from 2025. And I know you heard, you saw the video and you heard some kind of, you saw an email from a renter of the Laggett saying, well, yeah, there was a little bit of noise. I didn't think complaining would do any good. That's really circumstantial evidence, Your Honor. If this was a problematic site that law enforcement was having a problem with, the city staff would not be supporting this, in my experience. People that create problems for cities don't get support to get special exception uses, in my experience. And I think that should give you some solace. Mr. and Mrs. Huffman, did you want to add anything before we conclude?
Hello, I just have a few notes and I'll try to keep it brief. The first thing I wanted to start with is that we are not developers. We are a family-owned and operated business. Even our 16-year-old daughter works at the hotel over the summer. Both of our children have grown up over the past 16 years and will continue to grow up at Barefoot Beach Club. It's our backyard too. It is my goal to keep everything a very family-friendly, safe, happy atmosphere, not only for our guests, but for my children, our neighbors' children, and all of the families on Madeira Beach. Especially since the storm, I cannot tell you the amount of locals who have come to us looking for work because so many businesses were destroyed. As a mom, as a business operator, my goal is to find a happy unison in giving jobs to locals and keeping the neighbors happy. It's truly what I want. I am more than happy to give my personal cell phone number to any of you to call if there's ever an issue, and I'm happy to rectify it. You have to believe that being a mom of a 9 and a 16-year-old who live at Barefoot most of the year too, I want them to be safe. So it's really what I want for everyone. That's all. Thank you.
Thank you, Your Honor.
All right, thank you. Mr. Trask, I think it's over to you at this point.
So I wanted to address, first of all, staff recommendation. You've seen, it's been discussed on a couple of different occasions by both the lawyers who are here. The city is recommending approval of this special exception use application, subject to the conditions that are listed. I agree that paragraph number 2 is a little inartfully written. I discussed it with staff before today, thinking that maybe we could clean it up a little bit. We ultimately decided that we wanted to leave it like it is because it is reflective of the definition in the city code. So we're asking that you do approve the special exception use subject to the conditions set forth in the report. I do think it's important to address one of the items that was brought up, and that is whether non-alcoholic items is really food. I think it's appropriate to change the recommendation and condition of the word items to beverages. So it reads 60% of 60% of sales from food and non-alcoholic beverages instead of items. That way we don't have to address, does it include a cap? Does it include a shirt? Does it include a koozie? Those types of things. It'll be a little bit clearer if the word items is changed to beverages. I also wanted to address some of the legal arguments that were made by Attorney Graham. First of all, is there a need for a development agreement? The answer is no, it is not needed under current law. There has been a change in zoning on this property from PD to C1. All current uses on the property are legal, non-conforming uses. There's a question as to whether or not that the change in the rooftop, the use of the rooftop is a change in the use of the property, and the answer is no, there's no change, there's no expansion. Why is that? Well, it is because of the fact that when the original development agreement was drafted, it specifically provided for ancillary rooftop bar, sun deck, fitness room with typical and customary limited food service for hotel guests for their convenience only. So I think that there was not an expansion of the non-conforming use, therefore nothing further needs to be addressed. As for the special exception use process, it's obviously set forth in our code. It's mentioned that you have the authority under section 110-121 and section 2-506 to decide these issues on special exception uses. That's why we're here today. And as for the burden of proof that was brought up by Attorney Graham, I'm in agreement with her. It is not the city's burden to show that this application should be approved. It's the applicants, and I think that they've provided everything that they think is necessary to get that approval. I think I've addressed the issues that were raised by Attorney Graham relative to the legal arguments. If there was one I missed, I would be happy to respond.
No, Mr. Trask, I think you got them all. All right, anything else, Mr. Trask?
No, thank you.
All right, as I read the order of presentation, at the conclusion of the evidence, each party shall be permitted to make a brief summary statement. Assume this means the affected parties too?
Yes.
Mr. Trask? Okay. Mr. Unks, is there anything you'd like to say as a final summary? I think you've done it, but is there anything else you'd like to say as a final summary? And I'm going to give you one more chance after all
Just
the
want
other.
final word, that's
Yeah.
all. Yeah,
Okay,
thank you.
I'm going to give you the final reply since the burden of proof sits on you. Mr. Trask, before I go to the affected parties, is there any brief summary statement that you'd like to give?
Nothing further, thank you.
All right. These are going to be the affected parties again. Believe me, I've heard everything you said. I've considered everything. You have the opportunity to come up. If you want to come up and give me a 30-second closing, you can do so. If you don't want to, you don't have to. Ms. Graham, I'm going to give you the last word before Mr. Unk, so just, I'm not going to skip you, but I'm going to get you at the last. So, Mr. and Mrs. Klein, would you like to come up or make a 30-second closing statement? Are we good? Okay, we're good. Mr. Luggett? Okay, Mr. Edwards? Okay, Ms. Claiborne's still not here. Ms. Edwards, would you like to say anything else? Okay, Mr. Bello, anything else? All right, Ms. Ray is not here. Mr. and Mrs. Costa are not here. Mr. and Mrs. Rayborn, would you guys like to come and say anything? All right. Ms. Leggett, anything else you'd like to say? All right. Okay, Ms. Graham, I'm going to give you the last word before I go to Mr. Unkst. And I want to see if I had any questions for you based on your arguments. Give me 1 second to look at my notes. Okay, I don't think I have any questions, so tell me what you want to tell me.
All right, thank you very much, Special Magistrate. Jenny Silver really said it the best, where she stated today in her testimony, this is very difficult for us as a city to enforce. And I think that while we genuinely would like to see conditions that are available to manage these situations, it comes up short. I'll go through the conditions quickly, and then I'll just have a final word, which is, as far as condition 1, to the extent there's a restriction on amplified music and amplification, if there's something that can speak to the noise requirements for yelling and screaming that go beyond the hours, I mean, that could potentially help, but there still is an enforcement issue. As far as number 2, for the hotel guests who may attend events on the rooftop, we would say, we do think that this language is somewhat ambiguous, and particularly when looking at events that are up to 50 people, whether you call it an event or a gathering or a party, it's still going to potentially have issues, and so we would like that to be further looked at. We do support it to the extent, now, first of all, just make it very clear, my client does not support alcoholic beverages at this site for a license. The change on number 3 to replace items with beverages is helpful, and so if you do go ahead with this, that is something that we would support. Ultimately, 6, speaking to the enforcement, the special magistrate's ability to revoke the special exception, it's not clear enough as to what the process is, and that would need to be further clarified. Ultimately, I'll go back to Catherine's Bay case, which is what my other counsel mentioned, and it is a well-known case. I'm sure you know it, and I would say that it is relevant because it explains that if there's layperson testimony on subjective matters that do not require expertise, such as the development's impact on the area's natural beauty, it is relevant to the legal inquiry and it is competent substantial evidence. You have heard a lot of that today in the form of testimony relating to compatibility and the character of the area. You've also had lay witness testimony that is coupled with specific information such as maps and photos and videos and documentation that back it up. And so I would certainly say that what you've heard today is competent substantial evidence from the neighbors of the community. Ultimately, it is the applicant's burden to make sure that they have met all of the requirements under a special exception, and our position is that they've failed to do so. And ultimately, this goes to number 1, the issue of operated that the public health, safety, welfare, and convenience will be protected. You've heard lots of issues and seen videos that show how this is truly a problem. As far as number 3, the use will not cause substantial injury to the value of other property in the neighborhood where it is to be located. Remember, it's the applicant's burden to provide competent substantial evidence, and we don't think that they've done so. I mean, they've made a generalized statement that it's on a commercial, that it's a commercial corridor, that it's not going to impact. You've heard from Mr. Beggins from a generalized real estate perspective, but you've also heard testimony from individuals and Ms. Rose Yaget that speaks to impacts as someone who's renting their property, and that the noise and it's almost a blighting influence on their property value. So that's something to certainly take into account. Compatibility, this truly starts and ends with compatibility, and you've heard lots of testimony saying that it is incompatible. As far as the landscaping and screening, if there are ways that the neighbors can work some of these issues through with the Barefoot Beach, I'm sure that they would be willing to do so. So, I mean, that's something to look at, but right now, it isn't in compliance. The off-street parking and loading, again, the dumpsters are blocking the loading, and so that would really need to be fixed. And that's not something that you need a traffic engineer for when you've got photos of a dumpster blocking the parking spaces. Just say ultimately, and actually number 9, special exception use will not grant the land more privilege than the best use available in a zone where that special exception use would be a principal permitted use. I would actually say you should take a look again at the Johns Pass Activity Center regulations, because this is not this would not be a principal permitted use east on Gulf Boulevard. And it's really telling when you look how there is a distinction that the activity center regulation makes for Johns Pass between the west and the east side. And so you've heard lots of testimony regarding Gulf Lane being truly a residential area, and the code does reflect that as well. And so to have this type of commercial use really is not something that a principal permitted use would be allowed. And you haven't heard anything to rebut that. And where there's a flaw in the testimony, even if it is from city staff, that is not competent substantial evidence, and there's case law on that too. Thank you very much for all the time that you've given us today. We truly appreciate it.
All right, don't go anywhere, Ms. Graham, because I have a couple questions for you, and I'm not putting you on the spot, but I want you to help me with this. Because I read the 6 as, number 6, special magistrate may revoke the special exception use if the conditions and safeguard for use approval are violated. And I know I've had, when I sit here as code enforcement,
Yeah.
I've had the city bring forward to me where people have violated the special use exception, and it's come forward as a code enforcement proceeding. But what would you like to see changed in 6? Because to me, I see it, I think I understand the process. And also I'd say this, right now, the only thing they have is general code enforcement. So if there's the complaints we saw, that would have to be documented by code enforcement, and they'd have to be some other city ordinance other than these conditions here.
Right.
So I think that the city is putting in as this condition more protections than the residents currently have to enforce these conditions. But what is it you'd like, how would you like to see this language different? And I'll give you a second to confer with your client if you
Yeah,
want to. Because again, to me, the way I see this working is if there's evidence, let's use the 60-40 compliance rule. Because I can tell you, if I grant this, one of the things I would put in there is that would somehow be an annual reporting. And if they didn't meet it, then that could be something that would be brought before me. If there's, let's just use that as an example. So how would you propose this language to be different? And you can think about that for a moment. The second question I have for you is, you brought up a good argument that I listened to about, number one, I view that as a condition where they want normal voices, restaurant type noises up top there. So I think the city's trying to go to great lengths, say no amplified music, no amplification of sound by any means. So you can't have a guy up there playing a guitar with a speaker. You cannot have TVs like you'd see in a sports bar. I mean, that's what I'm reading there.
Yeah.
But you did raise an interesting argument that, and I don't think the intent of this is trying to change those other noise ordinances, but I saw the video of people yelling. Could that condition be massaged to include the language that you brought up so that there's just no question about that? In other words, I don't want this to be limited, if I go forward on this, to just these things. I want to address all the noise issues, and I don't think I would be, but I just want you to think about that. And then the no events that include non-hotel guests. I certainly see the no special events. I guess your concern is they could have a wedding up there, a bachelorette party where some of the things that you focused on, and that's part of your objection is, hey, no special events up there. People want to come up there, you object to it all, but if people want to come up there and eat, which is the only thing before me today, I'm not granting anything to do with alcohol. That is going to come before the city commission later on. But if the idea is that it's just people going up there to eat as the restaurant, it sounds like maybe somebody could rent it out as a restaurant or something, and that's what you're concerned with?
I think the fact that it said, and Your Honor,
Yeah, go
the
ahead.
fact that it says, wait, could I? It
Yeah, no
uses-
events. And again, this language, I'm going to have Mr. Trask work on this if I end up granting the application. But
Yeah.
I think the purpose of this is no special events at all. And again, we're only talking about, everything I'm doing today is only in this upstairs rooftop area. things that happen in the pool, not before me today. Things happening out on the beach, not before me today. Nothing I do is going to be able to permit any of those uses. So with just upstairs, there's still an objection, I take it, to if they just rented the restaurant out for hotel guests to use.
Yes, and I'll confer with my
Okay.
client, and we'll see if we can come up with something.
Yeah, take a
Yeah.
moment, and like I said, the last one too, because
Yeah.
I view that last condition as providing the residents a protection that they wouldn't otherwise have today. And my understanding of the way that works, so that everybody's aware of that, is if any of these conditions were to be violated, then you contact code enforcement, and code enforcement then would investigate, and if one of these conditions were violated, it would come back before me, and basically the action that they would ask me to do is to revoke a special use. But take a second and
All right.
confer with your client. Everybody just hold on for just 1 second. And Mr. Trask, while she's conferring with her clients, I do have one question for the city. The dumpsters being out, I heard Mr. Unk say that I did read in the development order on page 11, it's up at the top D, it says dumpster and trash pickup will be contained within the property and fully screened from adjacent residential properties. But then I understood from what Mr. Unk said that that was something that the city requested be changed.
I don't have any information on that whatsoever.
All right.
But obviously, if the current code requires the dumpster to be fully screened from adjacent residential properties, we would pursue that as a code violation for whatever code provision that is. Obviously, we would not be enforcing this development agreement. Yeah.
All right, Ms. Graham, I don't mean to rush you, and whatever order comes out, you're going to have a chance to look at it before I sign it, but is there anything else that, any way you can help guide me on those couple questions, or anything you want to add at this point?
I mean, I would just say that I think that we would need more time to really come up with some language. I'd be happy to continue to work with you in the event that you do grant this. What I would say is for the second condition, if there's some way of rewording it so it doesn't even mention that there are any events, but instead that it's really seen as, kind of, it truly is an extension of like a restaurant atmosphere or something, and we need to massage the language a little bit more. It's not there yet. To make it clear that non-hotel guests are not allowed on the rooftop. Yeah, something along those lines. I think what's important to my client is they don't want it to be like a TGI Fridays up there or like a sports bar. They want it to be kind of.
I get that
Yeah,
sense.
Yeah,
Okay.
so, and I'm not sure how, yeah.
Okay.
Now, the other thing I would say is, as far as number one, I would be happy to provide some additional language that does relate to the noise ordinance, but kind of is like a noise ordinance plus, in the same way that it says no amplified music and no amplification of sound. It could have something about just like no yelling, or kind of echo some of that same language that's in the noise ordinance without the timing restrictions, because I think that that's what the hangup is.
Yeah, I mean, my concern is I don't want, I think I understand the intent of number one is to try to appease your clients and say that there's not going to be this
Right.
loud noise. But I don't want it to be read as contradicting some other restriction on the, in the ordinances. And I'll say this, look, again, what I'm dealing with is if people are yelling on the balcony and, playing loud music off the balcony, that's still not before me today.
Right,
I can't do
absolutely.
anything about
Yeah,
that.
no, for
But
sure.
I appreciate what I've been told today. All right, Ms. Graham, thank you so much for your presentation. You gave me a lot to think about today, so thank you.
very much.
All right, Mr. Ungst, you're up. And I'll let you conclude, and if there's any questions I have as I'm thinking about it, I'll let you know.
Thank you, Your Honor. Just very briefly, we are in agreement with the city's revision to condition number 3, changing the word items to beverages. And we are happy to work with you and Mr. Trask and Attorney Graham on finalizing the language of the conditions of approval, should you be so inclined to grant it. Having said that, I think the city and my client have done everything they possibly can to address the concerns. And I do want to just make sure that, it has to be a workable condition for everybody. And it certainly can't be a Trojan horse that makes it impossible for them to sell alcohol or to have a commercial use on that space, which has always been intended for the commercial use. And the language regarding the noise ordinance, it does talk about create a loud and raucous noise, yelling, shouting. I mean, I think we could work with something in that regard, but again, just saying generalized yelling or shouting is going to be very difficult for anybody to interpret or enforce. So, but I think we can work it. I think we can figure that out.
Yeah, and I was just thinking along the lines of something to the effect of, nothing in this order shall,
Be in conflict with.
yeah, be in conflict with any other ordinance,
That would be
something along
perfect.
those lines.
Yep.
So where it's, if there's, I don't want somebody to allege that I've approved people yelling yelling and singing at the top of their lungs up there on the rooftop, so.
Right.
Let me ask you this, Mr. Unks, because I think I understand everything. The events is the idea that, because I go back and I look at this, and this is my thought process here. Certainly, I get your argument. I certainly understand. I've read the development order now several times. The ancillary rooftop bar with limited food service, it sounds like we're talking about a rooftop restaurant here. The inclusion of events, I get the no special events, but the only thing I'm struggling with, is this going to be promoted as an event space, or is this going to be a restaurant? And if the city permits alcohol to be served, alcohol for the people who are guests at the restaurant?
Right, and I'll let the Huffmans kind of have the final say on that, just so you hear directly from them. But this is for hotel guests only, period, hard stop. For any use, whether it's just sitting up there, sun deck use, whatever, whether they get approved to sell alcohol, for hotel guests only. I think you hit a very important point on the head, which is there was no regulation of events in the development agreement. There currently is no regulation of events, other than if they want to have more than 50 people who aren't hotel guests, they have to get a special event permit, which goes through the city. So these conditions are actually much stronger than the restrictions that were in the development agreement, and are much more protective and stronger of the neighborhood than what the current status quo is, even without the alcohol. So can you address the non-event events and how this will be marketed to your guests, and how you book that, and explain it?
So when we get, I do want to mention the bachelorette party because it's been mentioned. I am the only person that any group bookings have to go through. It was recent, and I do have proof of it. A bachelorette party emailed me, and I just explained that unfortunately, we're not that kind of atmosphere. We are a family-friendly atmosphere. So first and foremost, it is me that anybody would have to get through to even book a family birthday party for their 87-year-old grandmother. But we do have families who want to have a cookout. They want to gather together, and it's in-house guests that are doing a reunion that's small. I do not want to be a wedding planner. That's not in my goal ever. I'm happy to accommodate people going to local venues for events like that, but that is nothing in the scope of what we would like to do.
Okay, and I do have a question for you guys, because I get what the residents are saying. I saw the pictures, and I'm glad you guys are addressing that. But if you guys have a truck that comes in to drop off food, is there a place for that
There is.
truck to come onto,
Yes.
temporarily block some of your parking spots
Yeah,
versus
and to be
somebody
honest,
else's?
the laundry cart, I think, was just a creature of habit. That's just where he stopped. So we have, anybody can easily come into that, one of our lots where it's not covered. They can fit any size and they won't disrupt traffic at all.
What, in your concept here, like how late would you guys plan to be open?
In my perfect world, 9 PM, because
Okay.
I will be there. And like I said, we all know I have 2 kids. I don't want to be there late. I
Okay.
don't want it to be an Applebee's. I don't want it to be a Texas Roadhouse, nothing like that. Truly just grab a bite to eat with your family, head to the beach.
Okay. All right. Mr. Unks, last word for you? Okay.
You've heard it all. Thank you, Your Honor.
Thank you. All right. All right. Thank you, everyone, for your participation today. I truly appreciate it. I am going to go ahead and grant the special exception request. I'll give you guys some of my thoughts and reasoning. I certainly reviewed everything. I understand, I did review all the police reports and everything. A lot of those were for things that frankly looked like they were outside of the control of the applicant here. I did hear you guys loud and clear in regard to the parking. I've got some thoughts on that. The noise ordinances, the dumpster. And again, everything I'm saying today, my order is going to be limited to just what happens up there on that rooftop. It has nothing to do with pool. I am not, make it real clear, I'm not permitting the sale of alcohol. I have no power to do that. That's going to be something that comes back up before this. Your elected officials are going to make that decision for you, not me as a magistrate. My job is to specifically look at the factors that are set forth in the ordinance. I believe there's no question that the applicant makes it on all of them. In regard to number 2, that's the use is so designated, located, and proposed to be operated, the public health, safety, welfare, and convenience will be protected. I believe the conditions do that. A lot of the things I've heard about with unruly guests, it's unfortunate, but has nothing to do with what would occur up here on the rooftop. The number 3 deals with substantial injury to the value of other property. I haven't heard anything that's specifically allowing this use that would have been permitted back under the original development agreement would cause substantial injury to the value of other property in the neighborhood. Number 4 is compatibility with the adjoining development. One of the reasons I asked about that is because, yes, we're in this transitional zoning, but we're also just a couple blocks away from, or a couple blocks away based on the evidence that even Mr. Edwards provided from Johns Pass. It's even designated as a transitional area with Johns Pass. Plus you have at least one restaurant bar across the street. So I think when you look at the adjoining development and the character of the district, that letting them serve food up at a restaurant is going to be consistent with that and will be compatible with that. The landscaping and screening, again, I look at that just for the what's upstairs. And I haven't heard any testimony that the rooftop is not enclosed or does not have adequate landscaping or screening. And then the adequate off-street parking and loading. I really didn't hear anything about the parking. I did hear about the loading. And the parking I noticed too, it looks like, at least in the divisional development agreement, there are 84 spaces provided, 73 required. I also understand the city's objection to the events and how that would impact parking, but I also see the condition in regard to, when we really talk about events, we're just talking about allowing the guests to use that space. So here's what I'd like to do, and then I'm going to ask you, Mr. Trask, you, Mr. Unks, who wants to take the shot at the first order. So I'm going to grant it with all of the conditions that are set forth there. I'm going to add a couple conditions, which I understand I'm authorized to do under Section 2-506 of the code. The first one is I want to revise condition number 1, like I stated, that nothing in my order is going to be construed as limiting or in conflict with or limiting the other noise ordinances or anything else in regard to the noise ordinance. And I like this, I'd like to leave this in, but I'd like to add that clarifying language. The number 2, the no events shall that include non-hotel guests. I think that I'm in agreement with Mr. Unks that the best thing to do is just put a period right there. And then the next sentence would be, there shall be no special events, 50 people or more shall be permitted on the rooftops. Just basically break that into 2 sentences. And then the third, I'm comfortable with that, but I'm comfortable with that being the spirit of this is only going to be used for registered overnight hotel guests. But if Ms. Graham has something to offer on that, then certainly please consider what she says on that. Same goes to you, Mr. Unks, please consider that. But I understand the intent of that to be, these are people that are in the hotel. If they want to go upstairs and go have a bite to eat on the rooftop, then that's all my order will allow them to do. I also want to put a condition in that it will close at 9 p.m. I want to modify the condition for the alcohol beverage use to be the item, so it'll only include food, which I think was an issue Mr. Leggett raised. I want to include that as a condition. And Mr. Trask, I'm going to rely on you, but I would like there to be something that, and I heard that it's happens elsewhere in the city. It might have been Mr. Winters that said that, but just something where at the end of the year, there's something that's provided that confirms they're within compliance with that 60/40 rule. So that if a resident wants to say, I want to do a public record request to see if they're in that 60/40 compliance, they have the right to do so, or code compliance has a right to do so. Since it was argued, I'm going to go ahead and add a condition that the dumpsters will be, just like the development order said, dumpster and trash pickup will be contained within the property and fully screened from adjacent residential properties. Add that as a condition, please. And add as a condition that any deliveries, the trucks will be on the applicant's property. Delivery shall be made on the applicant's property. Mr. Unks, do you understand the changes that I made and the additional conditions that I added?
Yes, sir.
All right. Mr. Unks, is there, because you mentioned the Trojan horse, that's certainly not what I'm trying to do. Is there any issue you have with those additional conditions I've added? All right, come up here and say no, just so it's on the record.
No, my clients confirmed that they are supportive of your revisions.
Okay. Mr. Trask, I'll say the same thing to you. Is there anything I did that gives the city any sort of problem with those conditions that I've added?
No, I don't think so.
All right. Very good. Mr. Trask, anything else on this hearing? Oh, one last thing. Between you and Mr. Unks, I'd like you guys to draft the order. Would you like to take lead, or you want Mr. Unks to take lead?
I'll take the lead.
All right.
Okay.
If you, yeah, of course, of course. The rooftop. All right. All right, so Mr. Trask, if you can please take a stab at the proposed order, send it to Mr. Unks, send it also to Ms. Graham, and then if for whatever reason you guys don't reach an agreement, since as I read this, I have to have my deliberations in public. So if for whatever reasons you guys can't agree on the form of proposed order, if you can just notice that for hearing and come back next month, just for purposes of entry of the order. And I think it's actually going to be July, because I've got a conflict with the June meeting. All right, you understand that, Ms. Graham? Is that good with you? Okay. All right, everyone, thank you all very much. That concludes just the first item on the agenda. Thank you, guys. Okay. All right, everyone, just give us one moment. Thank you for coming, sir. Have a nice day. Just give us one moment so that the court reporter can get her stuff out of the way, and then we'll go on to the next one. We need to take a break?
I need to grab some water.
All right, we're going to take just a 2-minute break till Mr. Trask gets back, and then we'll get started. Have a
Oh, and just so that you know, item D, we're not moving forward on.
$24, $253.
Correct.
That's,
We're going to pull it because
Pull
we,
it.
changing ownership.
got it.
Okay.
Andrew, are you on the next one? We good, Andrew? Okay, 2025 dash. All right, everyone, we are still here in the special exception variance hearing. And now we're going to go on to the second matter on our agenda, VAR 2025-05, 13119 4th Street East. Is the city ready to proceed?
We are.
Go ahead, Mr. Trask.
I just want to make sure that everyone else has been sworn in before.
Excellent. All right, yes, if anybody wants to present anything to me today on any of the other hearings, including the code enforcement hearings, please go ahead and raise your right hand and be sworn in.
If you have not already
If
been
you're already
sworn.
not, is there anybody who hasn't already been sworn in?
Okay, everybody
Okay.
has. All right, thank you.
We're good to go.
Okay, thank you. The city would call Andrew Morris as its witness on this particular variance case. Andrew, if you could state your occupation and job responsibilities here at the city?
Yes, my name is Andrew Morris. I'm the long-range planner, and one of my tasks I do is review variance requests.
Okay, are you familiar with the property that is located at 13119 4th Street East?
Yes, sir.
All right, and did the property owners apply for a variance for that property?
Yes, they did.
Okay, and did you in fact review the application and prepare a staff report and recommendation?
Yes, sir.
Okay, I'm not sure that mic is on.
Oh, is it not?
Now
I
it
guess-
is, okay.
Okay.
All right, if you could please go ahead and present your staff report and recommendation.
Okay, I was just moving, I want to get to the, here we go, right page. Okay. So variance request 2025-05. The request is to reduce the front yard setback from 20 feet to 11 feet and 4 feet 9 inches. And to reduce the parking spaces required from 2 spaces per unit to 1 space per unit. Background. The requested variance for the property at 13119 4th Street East are to reduce the front yard setback from 20 feet to 11 feet and 4 feet 9 inches, and to reduce the required 2 parking spaces per unit to 1 space per unit. The applicant is requesting these variances to allow for a fourplex to be rebuilt after a catastrophic loss from Hurricane Helene. The existing structure received substantial damage from Hurricane Helene's storm surge. For the fourplex to be able to be rebuilt, the requested variance would be required. Located below is a summary table that shows the required setbacks, existing setbacks, and proposed setbacks. Also located below is a table that shows the required and proposed parking counts. And I will scroll to it. So in the R2 zoning district, we normally require 20 feet. And this lot is it's a irregular shaped lot where because of the shape, there's a section of the lot where the structure is closer to has a closer front yard setback. And then this was existing, and then this is what's being proposed. And with the side yard, minimum's 5 feet in R2. And the applicant's proposing to meet that with the 5 feet 3 inches and 5 feet 4 inches, and then the rear would be conforming also. And then there's the parking requirement. Section 2-507, variances, criteria, and analysis. Special conditions and circumstances exist which are peculiar to the land, building, or other structures for which the variance is sought, and which do not apply generally to the lands, buildings, or other structures in the same district. Special conditions to be considered shall include, but are not limited to, the following circumstances. Those include substandard or irregular shaped lots. If a site involves the utilization of existing lot that has unique physical circumstances or conditions, including irregularity of shape, narrowness, shallowness, or the size of the lot is less than the minimum required in the district regulations. Significant vegetation or natural features, if the site contains significant native vegetation or other natural features, and the residential neighborhood character. If the proposed project promotes the established, historic, or traditional development pattern of a block face, including setbacks, building height, and other dimensional requirements. D, public facilities, if the proposed project involves the development of public parks, public facilities, schools, or public utilities, architectural and/or engineering considerations. If the proposed project utilizes architectural and/or engineering features that would render the project more disaster resistant. So under staff findings, we felt like A, C, and E were the most relevant to support the variance. The lot is less than the minimum required dimensions for a 4-unit residential structure in the R2 zoning district, and both the lot plat and the structure predate the dimension requirements for the R2 zoning district. Under C, the proposed variance would allow for the new structure to support maintain the existing residential neighborhood character. Many neighboring properties have similar non-conforming front yard setbacks since they were built before the R2 zoning district setback requirements were adopted. The new structure would promote the traditional development patterns of a block face. The existing fourplex was substantially damaged during Hurricane Helene. The existing structure had nearly 5 feet of water inside the structure from storm surge. The new fourplex would be disaster resistant because it would need to meet all the applicable Florida Building Code and FEMA requirements. And under the next set of criteria, the special conditions and circumstances do not result from the actions of the applicant. A self-created hardship shall not justify a variance. Staff findings. The plat for the lot was approved in 1935. The existing fourplex located on the lot was built in 1945. Both the lot and the existing fourplex predates the R2 low-density multifamily residential zoning district and land development regulations in the Madeira Beach Code of Ordinances. The applicant's request would not be considered a self-created hardship. And then the next one is granting the variance will not confer on the applicant any special privilege that is denied to other lands, buildings, or structures in the same zoning district. For rebuilding after a catastrophic loss, duplexes, triplexes, or multifamily structures on non-conforming lots are required to meet the front yard setbacks. Many nearby R2 zoning district properties would require a similar variance to allow for a duplex, triplex, or multifamily structure to be rebuilt on a non-conforming size lot. Granting this application would not give the applicant any special privilege. The next is liberal interpretation would deprive the applicant of rights commonly enjoyed by other properties in the same zoning district under terms of the Land Development Regulations Subpart B of this code or Section 14-205 of the Code of Ordinances and would work unnecessary and undue hardship on the applicant. Staff findings, the existing fourplex was substantially damaged during Hurricane Helene. It would not be possible for the applicant to be able to build back their fourplex if they were required to meet the current front yard setback and parking requirements. Other neighboring properties with non-conforming structures would need to apply for similar variances. The liberal interpretation of the code would deprive the applicant of the right to rebuild after a catastrophic loss and create an unnecessary and undue hardship on the applicant. The next one is the variance granted is the minimum variance that will make possible reasonable use of the land. The applicant is proposing a front yard setback variance that is similar to the front yard setback of the current structure. The side yard setback and rear yard setback of the new structure would meet the minimum required in the R2 zoning district. The proposed parking space variance would still give each unit one parking space, and there would also be a bike rack. The variance granted would be the minimum variance required to make possible a reasonable use of the land. The granting of the variance will be in harmony with the general intent, purpose of the city land development regulations or the code of ordinances when it relates to section 14-205, and that such variance will not be injurious to the area involved or otherwise detrimental to the public welfare. The proposed variance is in harmony with the general intent and purpose of the city land development regulations. The R2 zoning district is a residential zoning district that does allow for low-density multifamily structures. The new fourplex would not be injurious to the area involved or otherwise detrimental to the public welfare. Under staff recommendation, city staff recommends the approval of variance 2025-05, 13119 4th Street East with the following conditions. Condition 1 is the parking for the apartment units must be on property. And number 2, the driveway must meet the requirements in Article 2 sidewalks and driveways of the Madeira Beach Code of Ordinances. Attached is to the staff memo. It is the applicant's application. And it shows their answer to the questions and also a conceptual site plan that shows that has existing survey of the current structure and then what's being proposed. And then attached is a summary document that explains what's required, what's existing, and what's current or what's required and what's currently being proposed. And then there's also a document that shows the existing front setbacks of neighboring properties. That is my staff report. And then the property was noticed and we sent out the 300-foot mailing and posted it at City Hall and the library and at the property and on our website. We've received one affected party form, which I printed out.
Okay, you're asking for the special magistrate to receive into evidence the agenda package starting at page 75, going through 99?
Yes, sir.
Okay, so I have a few questions then, just for clarity's sake. So let's talk about, in your report, the chart that you created in the top of page 2. So the front yard setback, the code requires 20 feet. Currently, on one side of the property, the front yard setback is at 11 feet. The other side is at 5 feet. Am I getting that correct?
That is correct, yes.
Okay. And so what the property owner, the applicant is asking for is for it to be very similar to what's currently in existence. For the front yard, it would be 11 feet on one side, which would be the same. And on the other side, instead of 5 feet, it would be 4.9 inches, 4 feet 9 inches, correct?
That is correct.
All right. As for the side yard, although the side yard setback is only 5 feet, neither side, or actually one side of the property currently meets that requirement. But with the new proposed setbacks of the building in place, it's going to meet both side yard setbacks.
That is correct.
Okay, so we're putting this property in a better position because now it's not encroaching into one of the side yard setbacks, correct?
That is correct.
Okay. And then as for the rear yard setback, required under the code is 25 feet. Currently, it's 24.6 feet. But because of this change in the property, it's actually going to now meet the rear yard setback requirement because it's going to be 25 feet, 2 inches on one side and 31 feet, 3 inches on the other side. Correct?
Correct.
So we're correcting a side yard encroachment and we're correcting a rear yard encroachment with the approval of this application, correct?
That is correct.
Okay. As for the notice of intent from the affected party, or to be an affected party, you said the city only received one. I think that the special magistrate has that in his possession. That would be William and Jean Simmons. Is that correct?
That is correct.
All right. Has the city received any other letters in support or letters in objection to this variance application?
I've not received any.
All right. All right, and can the conditions that you've placed on your recommendation of approval, have you had the opportunity to talk to the property owner applicant to see whether or not that they're in agreement with those two conditions?
They're understanding that the variance is for that specific criteria and that it will have to meet all on other, including those two, because as of right now, with the existing one, there is some parking that would be removed and they understand that.
Okay. So my question was, are they in agreement with these two conditions?
Yes.
Okay. All right, I would tender into evidence pages 75 through 99 of the packet. And you do have a copy of the notice of intent to be affected party. Okay, all right. Ask that that be received into evidence.
All right, I'll go ahead and accept in as exhibit number 1, pages 75 through 99 of the agenda packet, and I'll go ahead and just mark for purposes of identification, exhibit number 2, which is the notice of intent to be an affected party by William and Jean Simmons. All right, anything else with Mr. Morris?
No, thank you.
All right, who's here on behalf of the applicant?
Good evening, Your Honor. Kessie St. Louis, representing Cal Properties LLC. I'm here with Philip St. Louis, who is here on behalf of Cal Properties LLC.
All right, give me your name again and spell it for me, please.
My name is Kessie, K-E-S as in Sam, I, last name St. Louis.
Okay. All right, ma'am, this is your opportunity to ask Mr. Morris any questions. As you can hear, he's recommending approval of your variance, subject to 2 conditions. I'm going to give you an opportunity in just a few minutes to present any evidence you want to present to me, but do you have any questions or cross-examination for Mr. Morris?
I do not.
All right. Are our affected parties here, Mr. or Mrs. Simmons? Are you guys here? Okay, all right, great. All right. Mr. Trask, anybody else from the city?
No, but I would just give the opportunity to the affected parties to have the right to cross-examine Mr. Morris if they have any.
No, bro, I was going to give them that when they came up. We'll do it
Okay,
now.
all right.
Mr. and Ms. Morris, do you guys want to come up and ask Mr. Morris any questions? All right, come on forward.
Did you verify the existing?
Sir, can you identify yourself, please?
Oh, William Simmons, 13101 4th Street.
Thank you.
Did you verify the existing corner, that west corner?
Of the existing structure?
Yes.
The applicant said it was 5 feet.
Yeah, you said so, but it's not.
Okay.
Okay. Let's see what else. You know, he showed those nice pictures of, you know, it's similar to what's in the, current, you know, setbacks, and he had numbers in there. Those numbers are not accurate. He said that.
Sir, questions. This is the time to ask questions, not to make statements. So,
Okay.
do you have any questions of Mr. Morris?
Yes. Did you follow up on all the measurements that he sent you?
So this isn't approval of his plans. Like, he will have to turn in a site plan that is drawn the scale, that meets the variance, because this is a conceptual site plan that's obviously not like the final one. So I mean, whatever they have to turn in has to meet all our site plan requirements, has to be drawn the scale, and if they don't meet, they have to meet whatever variance, if it gets approved, they can't deviate from that. So I did not measure because it's just a conceptual plan, and the special magistrate can't approve the building plans for it. So they still have to go through the site plan review process.
But if you're basing that variance on the 11-foot 5 and it's not right, then you're doing something wrong, right?
Well, their site plan won't get approved if it doesn't meet what gets approved with the variance. I mean, with other variances we've done for similar non-conforming multifamily structures, people turn in conceptual plans, and then they turn in actual real plans when it comes in as a site plan and do the building permit stuff. But I mean, it's based off of their request with a conceptual plan, and the special magistrate can't approve the building permit and all that site plan stuff. So I mean, this is what, for previous ones, this is what we do.
How can you approve a variance if you don't know what a building plot really is?
So if the applicant didn't put the right stuff down, then their site plan wouldn't be approved. So
Yes, but if we approve the variance now of 11, whatever, based on existing, and it's not existing, then you're doing it wrong.
Mr. Simmons, let me jump in here because I'm only going to approve the variance that's requested. So for my purposes of considering this variance, it's really not what exists. I approve variances all the time where there's nothing existing on the property right now, where there absolutely is nothing that exists. So I understand the questions, and maybe it's better suited that you tell me in a couple minutes what your objection is, but do you have any more questions for Mr. Morris?
No.
Okay. All right, anyone else from the city, Mr. Trask?
No other witnesses for the city.
All right. Ms. St. Louis, sorry to make you sit down, come on back up. This is your opportunity to tell me anything you want to tell me, tell me anything you want to tell me, give me any evidence, call any witnesses.
Sure, thank you. In an effort to save time, if I may, provide the facts and evidence in the form of a proffer rather than formal testimony, with the applicant being subject to cross-examination, if there's no objection to that.
I think you should have your client testify.
Okay, formal testimony. Can you please state your full name and your relation to the property?
Philip St. Louis, owner, Kell Properties LLC.
And the property is located at where?
13119 4th Street East, Madeira Beach, 33708.
And you're requesting a variance today from the special magistrate?
Yes, site variance.
Okay, and that's to reduce the front yard setback from 20 feet to 11 feet and 4 feet 9 inches?
Yes,
And to reduce the parking requirement from 2 spaces per dwelling to 1 space per dwelling?
correct.
And why is the variance necessary?
Because we're trying to follow the same footprint that we have in place now, typically. But as the city attorney mentioned, we're now going to be in compliance with the 2 sides and the rear setback.
Do you currently have a 4-plex existing there right now?
That's correct.
And that was substantially damaged due to the hurricane?
About 5 feet of water, correct.
Okay. And you're trying to build substantially the same structure?
Correct.
And what's different about it? It's just elevated?
We are now coming in compliance with FEMA and the city of Madeira Beach. Ours elevated to,
Sir, if you could speak up, we need to hear you.
we're now elevating it to become in compliance with FEMA and the city of Madeira Beach.
Okay, and is the lot irregular shaped?
Yeah, it's sort of a parallelogram versus a rectangle.
Okay, and if you, why can't you build the fourplex as is? With the lot as it is, without the, if you didn't have the variance, would it be a functional fourplex?
No, we wouldn't be able to do that.
Does the buildable area become functionally unusable?
Correct.
Okay, are the lot dimensions any result by actions that you did?
No, this was as a result of Hurricane Helene.
Have you taken any actions to subdivide this lot or alter the property lot in any way?
No,
Okay, so the hardship is existing from pre-existing dimensions and
Correct.
structure?
correct.
Okay, and will giving you this variance provide you with any special privilege that's not available to others in the same zoning district?
No,
Are you asking for more than the minimum relief requested?
no, only asking for minimum necessary. I said, no, we're only asking for the minimum necessary.
And do you currently have one parking space per unit currently?
Yes,
And you're asking for that to remain the same?
correct.
And with this design that you've proposed, will it be still one space per unit?
We're probably gonna have more than 4 spaces because we're gonna have parking underneath the property, diagonal parking, 2 in the front, and then probably 4 underneath, probably 6 spots. Plus we're a bike rack, because more of the people that live there usually are at transportation by electric bike versus cars.
And do you believe this request for the variance is in line with the purpose and intent of the city's land development? Meaning this will promote or encourage resiliency in the construction and make reasonable use of the property?
I do.
That's all I have for now, Your Honor.
Mr. Trask, any questions of Mr. St. Louis?
Yes, I do, two, or actually one. Sir, do you agree with staff recommendation relative to the two conditions placed on the property? The first being that the parking for the apartment units must be on the property, and the second is that the driveway must meet the requirements of Article 2, sideways and driveways of the Madeira Beach Code of Ordinances?
Yes, sir.
Okay, thank you. That's all I have.
All right, I don't have any questions. Mr. Simmons, do you have any questions of this witness? All right, come over here and sit next to Mr. Trask so you can be on a microphone so we can have a clear record, please.
Did you have a survey done of the existing property?
We do, yes.
Okay, and can you show it today?
It's in the application.
Where's the survey, Cass? Wanna go
I
ahead
didn't
and
see
take it?
survey.
Can you go ahead and take it?
You just have to answer questions. You just have to answer questions.
I've got a copy of it. I'll provide it to him.
Thank you.
Yeah.
Where is it? So I can see it.
So,
It's right there.
let me ask you a question. Can I do that?
I can't
No,
see.
you need to ask questions of him.
Okay.
Yeah.
Thank you. Can you help me understand this? So when you said it's 11 foot, 5 inches or whatever it is, by your existing property,
Right.
okay? Can you tell me how far that is from the curb?
Okay, from the
Can you-
curb,
To the curb?
it's to the building lot is, as I
Right.
said, parallelogram. So it's longer on the left side, the north side of the property, than it is on the right side.
Right. Oh, no, I understand that, the 4'9", I can't see it from here.
Basically asking you the question, you know, in relation to the property line, how far back is it going to be from the curb instead of the property line?
What you're looking at, the building right now, because you're the neighbor to to the south of me. The way the building is situated right now is what it's gonna look like when it's done, except for it'll be 3 inches shorter on the right-hand side.
On the west side?
Correct.
Yeah.
Than what it is right now. It's 5 feet on the on the south side. It'll be 3 inches shorter than the setback that it is currently. As you drive by it right now, the way it sits, you won't notice that 3 inches, but we'll meet all the other setbacks on both sides and on the back.
So, again, can you help me understand the distance from that west corner to the curb? Can you tell me how far it is existing right
Existing,
now? Because if you're, go ahead.
it's 11 feet right now existing on the west side.
Okay, I measured it, I don't believe so. So are you measuring that 11 feet? Is that saying that you are measuring from the right-of-way? Is that off the right-of-way?
Where are you measuring? That's what I guess I gotta ask you.
Oh, sorry.
I didn't measure this, okay? This is, my architect drew this, but we had a surveyor go down there and
Okay.
survey this.
So this is the surveyor?
This is what the surveyor did, that drew up.
Okay.
And Andrew, can you pull up the survey, please, and see if you can blow it up so everybody can see it?
Okay, I can do that.
Thank you.
Can't see it.
And it should be to the property, whatever the property line is.
Right, but I think the question was, is how far is it to for the curb? Can you
Yeah.
tell by
Can
looking at
you
that survey?
calculate that for me? If it's, just the short corner would be fine.
Did we get an answer, guys?
I was just looking at, like, we're trying to see where that 7.3 feet is from. Is there an overhang or,
There is,
okay.
yeah.
Because the architect said it was from 5 feet. So, but she would have been, it'd go to the property line. We're not measuring within our right of way. It would be like where their property ends. It would be from the front yard setbacks from, see, the front of the structure to the front property line. But
They don't know the answer.
so I don't see I see a 7.3 feet, but it looks like there's part of the structure overhang that goes in a bit. And then the architecture listed 5 feet on the short corner.
Does that include the overhang? You said something about overhang?
I can't tell if that's 7.3 feet, if that doesn't include the overhang, and then the 5 foot does. It's hard to tell from.
Okay.
But It's important with the variance, whatever site plan comes in, it has to meet what was approved. So, no matter what.
Let's not get too far away. Right now, we're on cross-examination of Mr. St. Louis. Is there anything else you have for Mr. St. Louis? And again, Mr. Trims, please understand, I'm going to give you every opportunity in the world to tell me everything you want to tell me about this,
Okay.
this project and this application.
The proposed 4'9" that you're proposing, is that going to be to the corner of the building or to the wooden posts that you have in your design?
On the corner of the building.
So then how about the posts? How close will they be to the road?
The post should be parallel with the corner,
Can you
you're
speak
talking
into the
about the south
microphone?
side, correct?
Speak into the microphone.
You're talking about the south corner, correct?
Yeah, the west corner, probably more west than south.
Southwest, then, okay, yeah.
Fine.
Yeah, that's that column that you're looking at. Do you have a diagram? That's directly underneath, that'll be parallel with the building.
Okay, how about the other corner?
The north,
Yeah, oh,
that's, those will extend maybe, I don't know, 6 inches from that column.
so really you're allowing less than 4 foot to the right of way?
No, that'll be the finish. That's what I believe will be the finish. 11 feet, that's 4 feet 9 inches.
Did you verify all the two Amendment A and Amendment B? Did you verify those distances that were reported on those?
No, this I did not.
Okay, so in the photo, I think Amendment A, you had a picture of the old house that was on 13-117. So you're saying it's in common in the neighborhood to be that close to the road. And in fact, they rebuilt it and put the setback at 20 feet, the way I would expect it to be in a neighborhood.
That's a aerial shot of 4th Street. And what it did was represent the current setbacks of the current existing properties.
It's
That were
not
taken, I don't know when that photo was taken.
Okay.
That's what we had as an aerial photo available to us.
And do you know who verified those distances?
I don't, no.
You did not verify those.
No, I didn't go measure my neighbor's setbacks.
Well, you could have looked up the surveys, sir. You could have looked up the surveys to do that. Oh, thank you. Okay, I guess I'm done for a while.
Okay, hang on right there.
Okay.
Okay. Anything else you guys like to
I just
present?
have a little bit rebuttal.
Okay.
Did you have a professional architect prepare these plans?
Yes,
Did you have a professional survey done to get the measurements?
yes as well.
Okay, thank you. That's all I have.
Anything else, Mr. Trask?
No, sir.
All right. Okay. Mr. Simmons, it's your opportunity to go ahead and tell me anything you want to tell me about this project or the application or your thoughts on the application.
Well, I'm a little concerned that the information here is not accurate. I brought my survey of my property, and it's not what you have listed right there as a setback. So I'm kind of worried about all these accuracies. And the property at 13-117 isn't even there anymore. It's moved back 20 feet. It's been rebuilt to the proper setbacks. And if we allow these to continue, even on inaccurate information, these setbacks and the precedent that it'll set to move everything towards the street, it's concerning when you don't have accurate numbers.
All right, thank you, Mr. Simmons. Mr. Trask, do you have any questions of Mr. Simmons?
I do not, thank you.
Ms. St. Louis, do you have any questions of Mr. Simmons?
No, Your Honor.
All right. Mr. Simmons, I just want to make sure I understand what you're saying. Are you telling me that the house, essentially where that red arrow is over it right now, that house is no longer there? Is that what you're
That's,
saying?
no, the one with the brown,
The brown one's no
yeah,
longer
that
there?
one.
Okay.
That one's gone and been replaced with a 20-foot setback.
All right. What about the home that is right above it? Is that one still there?
Above it, yeah, it's still there, but it's coming down.
Okay.
And then there'll be another question about variance. So are we just gonna have made-up numbers and variances?
All right, sir, I think I understand. Is there anything else you'd like to tell me?
No, let me check my notes I threw down
Yeah,
here.
take them. Do you have them back there on the table? Do you need to go look at your notes for a second?
No, I'm good here.
Okay.
I'm good, thank you.
All right, thank you, Vern. All right. Ms. St. Louis, take a seat for just a second. I'm going to see if there's any members of the public that want to provide any comment, and then I'll give you and Mr. Trask the final word. All right. Are there any members of the public that would like to step forward and provide any sort of testimony in regard to this variance for the property located at 13119 4th Street East? All right, come on forward. If you can just give me your name and address, please.
My name is Pam Odom. I live at 13101 3rd Street East, so I'm right across the way. So I'm very familiar with this property because I can see it from my back windows. So I'm just concerned that this is going to set a precedence of which there's a lot of short driveways, right? And do we want to try to move things back? And when I've looked at these drawings, and I looked at the new drawing for the new proposal, and is there a way for them to shift the building back and then request a variance for the back setback? Because it looks like there's a lot of room there, and then that would allow the parking to be a normal parking lot instead of having to reduce it.
Thank you for your comments.
Sure.
Are there any other members of the public that would like to come forward and comment on this variance application? All right, seeing none, we'll go ahead and close public comment. Ms. St. Louis, I think I understand everything. Was there anything else you'd like to add? Feel free. You had to wait this long. You may as well go ahead and take all the time you need.
Thank you, Your Honor. Just a few things. Although it's understandable that the other neighbor got an expert to come in, these were prepared by two experts. We had it surveyed, and you heard testimony from my client that he had a professional surveyor and he had a professional architect draw up these plans. These are the numbers that were provided to us. He didn't come up with any numbers. These are what were provided to him from the experts. And then as for the setbacks, given the dimensions of the lot itself, this is what the architect came up with that works for it. This is how to keep the structure similar to what is currently existing now. So now it's a fourplex where he's just asking for it to now be elevated and continue to have the fourplex, this to be, have the same parking spaces, same dimensions. He just wants it elevated so that way every hurricane season, he's not going down there to have to completely renovate it. And this is in line with FEMA and what the city of Madeira Beach is asking for. And this is just a variance to have the same structure that's currently existing, just elevated. And this is the most minimally invasive way possible. And I think that I have just a few closing remarks I jotted down. The variance request satisfies all criteria under section 2-507, the lot's unique shape and size, the established neighborhood patterns, and the non-self-imposed hardship support this request. The requested reductions are the minimum necessary to enable reasonable, harmonious, and safe development consistent with Madeira Beach's planning principles. The applicant respectfully requests the approval of this variance. Thank you.
Thank you. Mr. Trask, anything else?
No, sir.
All right, I'm going to go ahead and grant the variance. Mr. Simmons, I listened very carefully to what you said, and I'll say this. The variance I'm granting is only what the applicant requested, and it's with the conditions that are set forth therein. And if the applicant builds a structure that does not comply with the proposed setbacks, and as I view this, as I see it, it's a very minimal change. In fact, the side setbacks are both going to be brought into compliance with code. The rear setback will continue to be in compliance with the code. And the only difference is the front setback is changing by approximately 3 inches according to the application. And if I don't grant a building permit, the applicant still will have to go and get a building permit which will include a final site plan. If the applicant doesn't build in accordance with the variance I grant, then that creates code enforcement issues for the applicant. So I understand your arguments, and at the same time, the variance does go ahead and meet the criteria that are set forth under the Code of Ordinances. And so therefore, I'm going to go ahead and grant it with the 2 conditions that are in here. And with that, Ms. St. Louis, will you just write on a piece of paper your email address so I can serve the order on you? Yes. Perfect, thanks. And if you need a piece of paper, I got a sticky pad right up here that you can use for it. All right, switching gears now, we're going to move over to code enforcement. Okay, welcome to the City of Madeira Beach Code Enforcement hearing. My name is Bart Valdez, and I'm appointed special magistrate to hear today's cases. I'm a practicing attorney and have been a member of Florida Bar for approximately 25 years. I've been appointed to this position in accordance and with the authority set forth in Chapter 162 Florida statutes. It is my role to fairly and objectively review the matters presented. As such, I would like to advise you of certain matters related to today's proceedings. Today's matters will be heard in the order that they appear on the agenda. Every effort will be made to hear all persons, thank you so much, having relevant evidence, arguments, or comments to offer related to the specific case that is being heard. If you wish to speak today, as you know, it's necessary that you be sworn in by the city attorney. In all cases, the city has the burden of proof, and the city will present its case first. The respondent or landowner will be given the opportunity to refute the city's allegations. Formal rules of evidence do not apply to this proceeding. However, I will exert every effort to ensure that fundamental fairness is afforded to all parties. After hearing all relevant evidence, I will issue an order. The order will be reduced to writing, and you will be provided with a copy by mail. Additionally, you are advised that I do not have the authority to grant you a variance, permit, or special exception of any kind. My role is solely to determine whether a city code has been violated and to provide you a reasonable time to correct the violation by whatever means is available to you. Please be advised that you may be subject to a fine, and a lien may be recorded on your property if the violation is not corrected by the compliance deadline. If there's anyone who has not been sworn in today that plans to talk to me about these remaining matters on the agenda, please raise your hand and let me know. Okay, I'm going to assume everybody has been sworn. So the first case we're going to bring up is CE 24-234 for the property located at 121 140th Avenue East. Is the city ready to proceed?
Yes, we are.
Go ahead, Mr. Trask.
The city is going to call Holden Pinkard. Holden, if you could tell us what your occupation is here at the city and what your job responsibilities are.
Sure. I'm Holden Pinkert. I'm the building compliance supervisor, and one of my duties is to issue building code violations.
Are you familiar with the property located at 12140th Avenue East?
Yes.
Okay. And is this property coming before the special magistrate the result of complaint, or was it proactive enforcement?
This was proactive.
Okay. And when this property was determined to be in violation of a city code section, was a courtesy notice of code violation issued?
Yes.
Okay, and when was that?
That was March 4th of 2025.
All right, and what was well, first of all, was the property inspected on March 4th?
I believe, let me get to the photo of when the unfit was posted. Let's see. So it looks like the initial inspection, or this photograph, was taken on November 13th of 2024. That's on page 105. And I believe it shortly after the storm is when we were made aware of it.
Okay. And who is this property owned by, and how do you know that?
Navarro Estella Estate, and that's the Pinellas County property appraiser.
Okay. If you could turn to page 100 in the packet. See, you've got that in front of you. Is this the printout from the Pinellas County property appraiser that the city used to determine who owned the property?
Yes.
Okay. And up in the upper left-hand corner, there is a date that it was printed.
November 13th, 2024.
Okay. When the courtesy notice of code violation was issued to the property, what were the cited code sections?
Section 14-69, which is same, maintenance of the exterior of premises, and 1470, same general maintenance, specifically sections 6, 7, and 11. 6 is supporting structural members are to be kept structurally sound, free of deterioration, capable of bearing imposed loads safely. 7 is walls and ceilings shall be in good repair, free from excessive cracks, breaks, loose plaster, and similar conditions. And 11 is foundation and walls shall be maintained structurally sound and free from defects.
And what was determined to be the actual violation? Not the code section, but what actually happened on the property?
This property, like others, took substantial damage from the storm. There's broken windows. You can see the roof material here is missing. And also here, I believe this is the rear of the property. So more broken windows and debris. And then page 108 is a picture of the interior. And as of today, we have not received any communication or any type of permit application to do any work on the property whatsoever.
Okay, when the courtesy notice of code violation was it sent by regular and certified mail?
Yes.
Okay, and what was the date again on that?
The courtesy notice went out on March 4th of 2025.
Did the courtesy notice include the photographs that you were just discussing?
Yes.
Okay.
And the follow-up date for that initial letter was March 18th of 2025.
Was the property brought in to compliance by March 18th?
No.
Did the city issue a notice of code violation for the same code sections?
Yes.
Okay. And when was that done?
That was on March 18th of 2025.
And is that reflected on the pages starting at page 109?
Correct.
Did it cite the same code sections and attach the same photographs as depicted in the courtesy notice of violation?
Yes.
All right. And what time frame did you give the property owner to come into compliance when that notice of code violation was issued?
It was another 14 days. So the follow-up date for the certified letter was March 31st of 2025.
Okay. Did it come into compliance by that date?
No.
Was it sent by regular and certified mail?
Yes.
Okay, I'd like you to turn to pages 15 and 16. It's just the letter that was included the notice of violation and the
Correct.
green card that was returned?
Yes.
Is the property in compliance as of today?
No.
And you've had no contact with the property owner?
No.
Okay. I'd like to turn your attention to page 122. Starting at 122, did you issue this statement of violation or request for hearing for today's hearing?
Yes, I did.
Okay, and did you send that by certified and regular mail?
Yes, it also was posted here at City Hall and at the property.
Okay. And did you also prepare an affidavit of service reflecting that you did post it in those locations?
Yes,
And is that on pages 117 and 118?
that's correct.
All right, and lastly, I have, well, maybe two more questions. You issued a notice of hearing for today's hearing,
Yes,
and that too was published, posted on the property and posted at City Hall?
correct,
Okay, and it was also sent by regular and certified mail?
correct.
You've got no response from the property owner as of today?
None.
Okay, the last question I have for you is, are the photographs, if you could turn to page 124 and 125, can you explain what those are?
124 is the notice of hearing posted here at City Hall, and 125 is a photograph of the notice of hearing posted at the property.
Okay. And what do you think would be the appropriate period of time for the property owner to be, to bring the property into compliance?
I think with the amount of work that has to be done would be 30 days to get the required building permits and have the work done.
Okay, and with regard to the daily fine, should the property owner not bring it into compliance by that time, in that time frame?
I would say the $250 per day.
And what's the reason that you've come to the conclusion it should be $250 per day?
The current status of the property is a life and health safety concern.
Okay. All right, those are all the questions I have for Mr. Pinkert. I would tender into evidence pages 100 through 125 of the packet, ask that they be received.
All right, I'll go ahead and accept into evidence as exhibit number 1, pages 100 through 125 of the packet. All right, is the owner of the property here? Anybody on behalf of the owner of the property here? Okay, seeing none. Are there any members of the public who would like to comment in regard to this code enforcement matter? Seeing none. Mr. Trask, anything else on this one?
No, thank you.
All right, based upon the evidence provided, I do find that the property is in violation as set forth in the notice of violation. The property owner will have 30 days to take the corrective action set forth on the record today and also in my order, which is going to be to apply for and obtain the necessary building permits to bring the property back into compliance, or if the permits cannot be attained, then the structure must be demolished or removed. If the property owner doesn't bring the property back into compliance within 30 days, it'll be a $250 fine, $250 a day fine thereafter. Okay, moving on to the next matter. I understand that item D, CE 24-253, is being pulled from the agenda. Is that correct, Mr. Trask?
That is correct. The ownership of that property has changed, and we need to provide a proper notice to the new owner.
Okay, and so that leads us to item E on the agenda, CE 24-255 for the property located at 14239 West Parsley Drive. Is the city ready to proceed?
Yes.
All right, go ahead, sir.
Call Holden Pinkert. Holden, again, if you could tell us your occupation here at the city and your job responsibilities?
Building compliance supervisor, and one of my duties is to issue building code violations.
Are you familiar with this property located at 14239 West Parsley Drive?
Yes,
Was this property cited with a code violation?
yes.
Who's the owner of the property and how do you know that?
Gerald and Deborah Westner, and the Pinellas County property appraiser.
Okay. And was this a complaint driven or was this proactive enforcement?
This was proactive.
Okay. I want to bring to your attention page 140, starting at page 148. This looks like a printout from the property appraiser's office. This is what was used to determine who the owner of the property is?
Yes.
Okay. When was it determined that that the property was in violation of city code?
That would be November 26th of 2024.
Okay. And what were the violations of the property at that time?
Section 14-70, general maintenance, specifically exterior of every structure and/or accessory structure. This violation is specifically the dock.
Okay. Did the city issue a courtesy notice of violation for the property owner about the dock?
Yes.
Okay. And when was that done?
December 3rd of 2024.
Okay. And was there a follow-up date set forth in that letter as to when the property was to be brought in compliance?
December 17th of 2024.
Was the property brought into compliance by that date?
No.
Okay. When the city issued the courtesy notice of violation on the property, did it attach to that courtesy notice of violation a photograph of the violation?
Yes.
Okay. You turn to page 154 of the packet. Okay, you've got that in front of you now. Is this the dock in this photograph that looks collapsed?
Yes.
Okay. Was the courtesy notice of code violation sent by regular and certified mail?
The courtesy was sent with regular mail.
Okay. Did you get any response before December 17th?
I did not, but I do have a response from the property owner in an email as of Monday, the 19th, and I've got 2 copies of that.
Okay, well, I'm going to hang on to that just a second. We'll get to that.
Okay.
I want to go through the rest of the evidence first, and then we'll get to that email. Okay. So was a notice of code violation issued for the property?
Yes.
And when was that done?
December 17th.
Is that reflected starting at page 155 of the packet?
Yes.
Okay. Did that also include a photograph of the dock?
It did.
All right. And was that sent by regular and certified mail?
Yes.
And if you turn to pages 158 and 159, could you tell the special magistrate what these 2 documents reflect?
158 is the backside of the certified mail, and 159 is the signed certified mail returned.
Okay. When this letter was sent, did you also give a compliance date for the property?
Yes.
And what date was that?
January 3rd of 2025.
Did the property come into compliance by that date?
No.
Is it in compliance as of today?
As of today, no.
Okay. And did the city issue a statement of violation or request for hearing? If you could turn to page 164 of the packet and tell me whether that's that statement.
Correct.
All right. And the city also issue a notice of hearing starting at page 162?
Correct.
And those are sent by regular and certified mail?
Yes.
Was the property also posted?
Yes.
Okay, did you issue a affidavit of service reflecting the posting and the mailing?
Yes.
And is that reflected at pages 160, 161?
Correct.
All right, if you could turn to page 166 and 167 for me, and 168. So 166, this is the way that the dock looks today?
Yes.
And the next page? What is that
160
photograph?
167 is a photograph of the notice of hearing posted at the property, and 168 is a photograph of the notice of hearing posted here at City Hall.
Okay. All right. Now, you said that you had received an email from the property owner, and you had a copy of that available for the special magistrate?
Yes.
Okay. If you could present that to him at this point. Thanks. This email is an email from, it looks like from Jerry Westner. It is directed to you. It is dated May 19th, 2025. And what is the email all about?
Just explaining the damage that the home took from the storm and the priority was getting back into the home, and they fully intend to repair the damaged dock as soon as they can make the home habitable. They're hoping that can be done by the end of the summer. That's basically in a nutshell what their email was.
Okay.
And they did request that I bring it to the hearing today.
Okay. How much time do you think it would take to bring the property into compliance?
To have a permit issued to remove the dock, I would say 30 days.
Well, the city has not cited him for failure to have a building permit, correct? The city cited him for a dilapidated dock, correct?
Correct.
So the compliance would actually be taking the dock out or have the dock repaired. It wouldn't just be pulling the permit, correct?
True.
Okay. So how much time do you think that it would be appropriate to give the property owner to have the dock repaired or removed?
To remove the dock, I would still say 30 days.
Okay, if the property is not brought into compliance within those 30 days, how much would say would be the daily fine that the city would be seeking?
I would say the $100 a day.
Is there any life safety issues involved with the dock in its current condition?
Appears to be structurally sound and there's no loose debris. I don't see any life and health safety concerns as of today.
Okay. All right, I don't have any other questions of Mr. Pinkert. I would tender into evidence the agenda packet 148 through, I think, 168. Asked it be received into evidence, and also the email that was received from the property owner that was discussed.
All right, we'll go ahead and accept into evidence as exhibit number 1, pages 148 through 68
Yes.
of the agenda packet. Also, exhibit number 2 will be the email from the property owner who indicates they've done something. Mr. Pinkard, it says that we received our rebuild permit from the city on April 21st, 2025. What permit was that they received?
I believe that's for the interior of the home.
Okay. All right, and I'm looking at the dock. Having seen it, what happened to this dock here?
I don't know if there was a boat attached to it at some point when the storm came through, but it looks like the pilings on just one end lifted.
Yeah.
Yeah, I'm not sure. It obviously does have to be either removed or repaired, but I think it was just lifted somehow.
When you spoke with the owner, well, did you ever speak with the owner, or did you just communicate by email with the owner?
I don't remember if I spoke with him on the phone or not, but I know that they're making an effort to get this fixed. I just know the priority at the time for them was to obviously get back in their home. I know that pretty much anyone who lived on the water had some form of dock damage, so I know that contractors are busy. But I think 30 days is enough to have the dock removed.
All right. Okay. Mr. and Mrs. Westner, anyone on behalf of the owner here for this code enforcement matter? All right, seeing none. Any members of the public that want to provide comment on this one? All right, I'll go ahead and, based upon the evidence presented to me, the testimony as well as the photographs, I certainly see the violation here. I'm going to find there is a violation. $100 a day in 30 days is acceptable. I mean, we are getting into another storm season here, and, you know, I want to at least see the owner trying to move to address this. So 30 days is fine on that one. All right, let's move on to old business next. We've got some requests for additional time and some affidavits. So let's start with the old business item A, CE 24-233, 703 Sunset Cove. This request for additional time Mr. Trask, how do you want to deal with these? You want to see if the owners are here first, or how do you want to deal with it? Okay. All right, so we've got, I see some people walking forward, so come on up here. Thank you again for waiting so long today. Okay, so you guys are asking for some more time to come into compliance, which is absolutely fine. Tell me what you'd like me to do and tell me why.
Okay,
And also, give me your name too.
oh, Debbie Chanchuli.
All right, thank you, ma'am.
We had a code violation for our air conditioner, and we couldn't get a permit because of substantial damage to the house, which what we did is we got an appraisal done, and it shows that we are not in substantial damage. So we would like to request that we get the violation fixed so we can get our permits.
All righty.
I have a copy of the appraisal here.
Yeah, you can give it to Ms. Trask. So if I understand, just make sure I understand your argument correctly. There's been a substantial damage determination found on your home, and you guys were challenging that substantial
Yes.
damage determination? Okay. And in order to challenge that, you've gotten an appraisal of the property. Okay, but there's been no determination on your appeal or whatever you've done to challenge the substantial damage determination? Is that where we stand right now?
Yes.
Okay. And do you know when that's going to happen?
Kent Baker. That's our next step. First, we're going to come for more time just because of the fines and stuff. And then we had the appraisal. And then the next step would be, I guess, to apply to the city to dispute the substantial damage letter.
Yeah.
We're not really sure what to do next. Oh, my head's a bubble anyways. I could tell you anything you want to know about variances to rooftop bars and
All right. Okay, thank you, sir. Mr. Trask, what's the city's position on this one?
I just have a few questions if I can first.
Yeah, go ahead.
So the last hearing we were at was March 31st. What have you done to bring the property into compliance since March 31st?
we tried to hire contractors, and there's so much work that they're kind of hesitant to work, or they aren't really very reputable. And then Madeira Beach has kind of got not a bad reputation, but just difficulty hiring guys to work in Madeira. And so I came for the last month, and I didn't realize that it was the end of the meeting and that it was poor timing on my part. And beyond that, we're just trying to get a contractor who can come in and do the estimate, but now that we have the appraisal, we're gonna try to dispute the substantial damage. And then, because the AC companies applied multiple times for the permit. It wasn't like we said we don't want to do it legally. We just, between you guys saying that we need the substantial damage and them being denied getting the permit, we're kind of stuck in the middle.
Is this a rental property?
Yes.
Well, it's not anymore.
Well, yeah, no, it's just, yeah. I mean, it was previously.
Okay, so is it occupied right now?
No.
Okay, when was the last time it was occupied?
Day of the hurricane.
Okay, why isn't that you cannot remove the air conditioner unit then to bring the property into compliance?
We applied for a permit for after the fact, and you denied it because we had substantial damage report.
I didn't ask as to
Well,
why you
we
didn't get
could,
one to
but then
install
would
it.
just turn it into a mold farm, and it would be more destructive to the house.
Okay, so the air conditioner unit is running then, is what you're saying?
Yes.
Okay, and you're doing it for the protection of the interior of that structure?
Correct.
Okay, all right.
But if push comes to shove, we'll disconnect it and go from there.
What do you mean by, hold on a second, Mr., if you can respond, since you've been talking, What do you mean by disconnected?
Well, you guys said that if I disconnect it, then that we're not in violation.
Correct. So there is an opportunity for you to remove it then to bring it into compliance, correct?
Yes,
Okay.
but then it would turn the house into a mold farm, and that's what we're trying to avoid. Because without AC, things don't go well.
Okay. Did you want the special magistrate to receive these? Because you won't get,
Yes, that's a copy.
that's his copy?
Yes,
Okay.
he can have that.
And I'm a bubblehead.
Give me 1 second, guys. Let me just take a look.
Mhm.
Yes, sir.
All right, I've taken a look at this. Thank you very much. All right, Mr. Trask, any other questions of the respondents here?
No, thank you.
All right. Do you want me to keep this as part of the record, or do you want me to hand it back to
Sure,
you?
you can keep it for the record.
All right. We'll go ahead and mark it as exhibit number 2. We'll make exhibit number 1 whatever was in the agenda packet. All right, what else would you guys like to share with me about this request?
Any recommendations on how we should proceed?
Well, one thing I can't do in this position is give any legal advice, but you may want to consult a lawyer in the area, because I'm sure there are several lawyers out there that might be able to give you some advice on this. All right, just sit tight. Mr. Trask, what's the city's position on this?
City would ask that you receive into evidence the documents that are in the agenda packet, which is the notice of hearing, request for additional time, the affidavit of service, and the prior order, findings of fact, conclusions of law, and order imposing fine and certifying the lien, ask that they be received into evidence, as well as the photographs of the posting of the property and at City Hall. City has no objection to an additional 30 days to come into compliance.
All right. I'll go ahead and receive into evidence exhibit number 1, pages 169 through 177, the agenda packet, as well as the appraisal. What I'm going to do is I'm going to give you guys an extension of time to the next hearing, so it's a little bit longer than 30 days, but it's July 7th of 2025. But I do encourage you guys to find a local lawyer here that can help you out with this process, so that, you know, it's moving along. And as long as we're moving things along, I understand the argument you're making about wanting to, you know, not keep the AC running and everything like that. That seems to make sense. And I see in the pictures, it looks like the house is for sale, so I understand that as well. But I just want to make sure, you know, my concern always is when there's something major in a home, like electrical, plumbing, HVAC system or something, that didn't have a building permit, that it wasn't installed correctly to begin with. And that can lead to bigger issues. And I think, didn't you have a contractor that installed
I have a
this?
question. Yeah, we had a
Yeah.
person apply for us, the contractor that put in the AC, and the city denied it because we had substantial damage, but now I've proven that we don't.
No, but I mean, whoever installed it before you applied for the after-the-fact permit. And I just forget, did you guys have a contractor when you first installed it? Did you do that work yourselves?
No, the
A
contractor.
certified license.
Yeah.
Full
Okay,
deal.
that's what I thought I remembered, that for whatever reason, that contractor just didn't pull the appropriate license to get it the first time around when it was installed.
I guess, no, the first.
Well, they put it, yes, because it was right after the hurricane, and then they tried for the after the fact.
Yeah, I get it. Listen, that makes me feel better sitting here, giving you till July 7th, knowing that it was an actual contractor that put it in.
Oh, yeah.
And you guys were trying to do things right. So I'll give you till July 7th. The reason I say that is I'll be here again on that. That's the next date for me being here. So again, come back, come at the start of the meeting. Probably won't have that long of a meeting next time. But if you need more time after that, but I would encourage you guys to talk to council about
Yeah,
the substantial damage determination.
Okay.
All right. You have any other questions, ma'am?
No.
Okay, thank you all for coming today. I'll enter an order granting the extension of time until July 7th.
Get out of here, you guys. Go home.
We got more work to do here. All right, next one up is CE 24-106 for the property at 140th Avenue. All right, ma'am, I take it you're here for this last one, or you're the last person here at least, so. All right, give me your name, ma'am.
Nancy Saplinsky.
All right, ma'am. Tell me what's going on. What's going on with your property and why do you need more time?
Well, why I need more time is I was trying to contact demolition companies. Nobody was returning my phone calls. I was leaving messages. I finally did get somebody. He actually spoke to me. It took him another 2 weeks before he saw the house, another 3 weeks before he gave me a quote. I did send, he gave me a contract. I did sign it. I did send a copy of it to Holden Pinkard. And he also sent me oh my gosh, the permits to sign. I signed all of that. At this point, I'm just waiting for him to knock the house down. As far as I know, everything is signed.
All right. Ma'am, how much time do you need for the contractor to do that work?
I would say a week, but I don't know because I've been in contact with him. It's when he shows up.
If I gave you till July 7th, like the owners
Oh,
before you,
God,
would that be
please,
enough
I
time?
hope so.
Okay.
Said everything is signed. It really is. I paid him their down payment. I did everything I could.
All right, I'm not ruling yet because I need to hear from Mr. Trask, but go ahead, Mr. Trask.
So
Any
it's,
questions?
would tender into evidence the notice of hearing, request for additional time, the affidavit of service, the notice of hearing, and the order that was entered on April 16th, as well as the request for additional time that was sent to the city by email from the property owner, asked that they be received into evidence. City has no objection to the request for additional time until July 7th date that you had suggested.
All right, ma'am, well, your reward for waiting this long is I'm going to grant exactly what you've asked. So I'm going to give you till July 7th. I know
Yay.
the city and the city staff really appreciates when owners do what you do, which is take immediate action in response to my orders.
I tried my best. I just couldn't get anybody to call me. They were so busy.
Well, if every resident took their, responsibilities like you, the city would never even be here ever. So
I know.
I appreciate you for doing that. I'll go ahead and get an order in the mail, so there will not be any fines running or anything
Okay,
like that.
thank you.
You'll have time. However, please remember, as soon as your contractor completes that work and the demolition is done, reach out to the city because they've got to come out and confirm compliance. So there's
Okay.
one more step that you have to do to be brought in compliance, okay?
Mine's easy to see. I'm right off
All
of
right.
Gulf Boulevard.
Just make sure when your contractor completes the work that
I
you call the
certainly
city
will.
and come out. All right. Thank you, ma'am. Thank you for your patience today.
Thank you very much.
All right. Okay, let's go on. Looks like the next one is for 14110 East Parsley Drive. That's an affidavit of noncompliance.
Yeah, I just need to put on Mr. Pinkard for this to get some testimony. So, Mr. Pinkard, your occupation, your job responsibilities here at the city again?
Building compliance supervisor, and one of my duties is to issue building code violations.
Are you familiar with this property, 14110 East Parsley Drive?
Yes,
Okay, you familiar with the fact that the special magistrate entered an order requiring this property to be brought into compliance by March 28th?
correct.
And was the property brought into compliance by that date?
No,
Okay, did you issue an affidavit of non-compliance on May 15th of this year?
yes, I did.
Okay, if you could turn to page 193 in the packet. Is that the affidavit of non-compliance?
It is, yes.
Okay, and what did you do to determine whether the property is in compliance or not?
Just want to make sure I have the right property here.
Special magistrate required that the property brought into compliance by the property owner obtaining a building permit and requiring that all utility facilities that were required had to be underground.
Yes, there was, to verify that the property was not in compliance, was to see if a building permit was issued, and it has not been.
Okay. All right, and in the packet, there is some additional paperwork. There is a notice of hearing of affidavit of non-compliance. It looks like it was signed by you on May 15th, and an affidavit of service signed by you on May 15th in the packet. You in agreement that you were the one that issued those?
Yes.
Okay. And in addition to that, was the property posted?
Yes,
And for this hearing today?
correct.
Okay, and is that reflected on page 197 of the packet?
Yes.
All right, and what is the photograph on 198?
That is a photograph of the notice of hearing posted here at City Hall.
Okay. Thank you. So the property is still not in compliance as of today, correct?
Correct.
All right. I would tender into evidence the notice of hearing, the affidavit of service, the affidavit of non-compliance, the prior special magistrate order, and the photographs that were just testified to, and ask that they be received into evidence. So that is pages 188 through 198 of the packet.
All right, I'll go ahead and accept into evidence as exhibit number 1, pages 188 through 198 in the packet.
City is also asking that you enter an order finding the property was not in compliance by the date that was required by your previous order.
All right, anything else you want in my order, Mr. Trask?
No, sir.
All right, just not in compliance, and the fine started running from the day after non-compliance?
Right.
Okay. And the fine was $250 a day in my order, right?
Yes, correct.
All right, is anyone here on behalf of the owner of the property located at 14110 East Parsley Drive, Aurora Investment, REM Capital Group? Anybody here? All right, seeing none. Any members of the public that wish to comment on that? All right, seeing none, I'll go ahead and find that the property is not in compliance and enter an order saying there's $250 a day fine from and after the date, compliance date. All right, let's move on to CE 24-53 for the property located at 13063 Boca Ciega Avenue. City ready to proceed?
Yes.
Go ahead, Mr. Trask.
So I'd call Holden Pinkard on this particular case too. Holden, your occupation here at the city and your job responsibilities?
Building compliance supervisor, and one of my duties is to issue building code violations.
Okay, you're familiar with this property located at 13063 Boca Ciega Avenue?
Yes.
Okay, you understand that the special magistrate previously entered an order requiring this property to be brought into compliance by March 26, 2025?
I do.
Okay, did you determine whether or not that the property was brought into compliance by that date?
I'm sorry, can you repeat that?
Did you determine whether or not the property was brought into compliance as of that date?
Yes, I did.
Okay, did you issue an affidavit of compliance?
Yes.
Is that reflected on page 201 of the packet?
Yep.
Okay.
Yes, I'm sorry.
Did you also issue a notice of hearing for today's hearing and an affidavit of service that are also in the packet?
I did.
Okay. Have you heard from the property owner on this particular one?
I have. I've gone back and forth with the property owner, Mr. Mike Fortunato, I believe it is.
Okay.
And the dock concern has been corrected, so the property is now in compliance.
Okay. Did you post the property with the notice for today's hearing?
Yes.
Okay, and is that reflected on page 208?
Yes,
And the photograph on page 207 is the posting at City Hall?
correct.
Okay. All right, I have no other questions of Mr. Pinkert. I'd move into evidence the documents in the agenda packet, page 199 through 208. Ask that you enter an order finding the property was in compliance as of March 26, 2025.
All right, go ahead and accept into evidence the agenda packet for page 199 to 208 as exhibit number 1. Go ahead and find the property in compliance as of March 26, 2025. All right, let's move on to, and let the record reflect there is no one left in the audience. All right, let's move on to the next one, which is CE 24-63 for 435 South Bay Shore Drive. City ready to proceed on this one?
Yes, I'd call Holden Pinkard. Holden, could you, well, let me just back up. You're familiar with this particular property located at 435 South Bay Shore Drive?
Yes.
Okay. You understand that the special magistrate previously entered an order finding that property in violation?
I am, yes.
Okay. And the cited code sections were section 1469, 1470, and 110446. Is that correct?
Correct.
And the property was ordered to come into compliance by May 10th, 2025. Is that correct?
Correct.
Was the property brought into compliance by that date?
It was not. There has been some work done to the soffit and fascia, but there are still the issues on the interior.
Okay. Did you issue an affidavit of noncompliance then?
Yes.
Is that reflected on page 214 of the packet?
Yes.
Okay. Did you also issue a notice of hearing and an affidavit of compliance for this case?
An affidavit of noncompliance, yes.
I'm sorry, noncompliance. And you posted the property
Correct.
with this notice of hearing for today?
Correct.
Did you also post it at City Hall?
Yes.
And are those reflected in the photographs at pages 218 and 219 of the packet?
Yes.
Okay. Have you had you had any contact with the property owner?
I
Or-
have not.
Okay. So the property was not in compliance as of May 15th. There's a 5-day lapse between what was ordered in the order by the special magistrate and your affidavit of noncompliance. Can you tell us the reason why?
I'm sorry, the incorrect date is on the affidavit of,
Well, it may be that you went out to see the property on May 15th, even though it was ordered to be in compliance on May the 10th. I'm just trying to figure out why the affidavit of noncompliance reflects May 15th.
that is most likely an error because it was the posted date. It should be the order, the May 10th, the date on the order.
Okay, so it was not in compliance as of May 10th,
Correct.
2025. Okay. All right, I would tender into evidence at this point the notice of hearing, the affidavit of service, the affidavit of noncompliance, the former special magistrate order, the photograph of the posting at the property, and the photograph of the posting at City Hall. Ask that they be received into evidence. The city would also ask that you enter an order finding the property was not in compliance as of May 10th, 2025, and order the daily fine to begin.
All right, I'll go ahead and accept into evidence as exhibit number 1, the hearing materials from page 209 through 219. Let the record reflect there are no members of the audience appearing here today. Therefore, I'll go ahead and enter an order of noncompliance as of May 10th, 2025, and a $250 a day fine thereafter. All right, is the city ready to move on to the next one?
Yes.
All right, the next case is CE 24-264 for the property at 633 Normandy Drive. Go ahead, Mr. Trask.
Would call Mr. Pinkard. Your occupation, sir, and your job responsibilities?
Building compliance supervisor, and one of my duties is to issue building code violations.
You familiar with this property at 633 Normandy Road?
Yes.
Okay. And are you familiar with the fact that there was a prior special magistrate order that was entered on April 16th, 2025,
Yes,
finding that the property was in violation of this code section 8652, requiring a building permit to be issued?
correct.
In the special magistrate order, the property brought in compliance by May 30th. Was the property brought into compliance by that date?
Yes, the property was brought into compliance on May 7th of 2025. The building permit was issued on that date.
All right, and you prepared an affidavit of compliance, and that's reflected on page 222 of the packet, correct?
Correct.
You also issued a notice of hearing for the affidavit of compliance. Is that correct?
Correct.
And that's reflected on page 220?
Yes.
Did you post the property with the notice of hearing for today?
Yes, I did.
Okay, did you also post the notice at City Hall?
I did, yes.
And those are reflected in the photographs that are in the packet at pages 228 and 229?
Correct.
All right. I would tender into evidence the notice of hearing, the affidavit of compliance, the affidavit of service, the prior special magistrate order, and the 2 photographs relative to the posting. I ask that you enter an order finding the property was in compliance as of May 7th, 2025.
All right, we'll go ahead and accept into evidence as exhibit number 1, pages 222 through 229 of the agenda packet. And let the record reflect there are no members of the audience. Therefore, I'll go ahead and find that the property was in compliance as of May 7th, 2025.
Thank you.
All right, we've got the last one on the agenda, case number 2024.3764 for the property located at 13342 3rd Street East. Is the city ready to proceed?
Yes, and I would call Holden Pinkard. Holden, your job, your occupation here at the city and your job responsibilities?
I'm the building compliance supervisor, and one of my duties is to issue building code violations.
You familiar with this property at 13342 3rd Street East?
Yes,
Okay. So you're aware of the fact that the special magistrate had previously found this property in violation of city code?
yes,
Okay, and that code section was 8652, failure to obtain a building permit?
correct.
The special magistrate order provided that the compliance date was to be on May 30th, 2025. Did the property come into compliance by that date?
Yes.
Okay, and what date did it come into compliance?
Sec here. Sorry, give me one sec, still loading here. Be the date of the final inspection. Let me see here.
If you could turn to page 233 of the packet, the affidavit of compliance. That affidavit reflects a compliance days as of May 2nd, 2025. Is that correct?
Correct.
Okay. Did you issue the notice of hearing for today's hearing?
Yes,
Okay, and that reflected in the packet starting at page 230?
correct.
All right. Did you also post the property?
I did.
And is that reflected in the photograph that was on page 239 of the packet?
Yes,
And the photograph on page 240, is that the posting of the notice at City Hall?
yes.
All right. All right, I don't have any other questions of Mr. Pinkard. I would tender into evidence the notice of hearing, the affidavit of compliance showing compliance date of May 2nd, the affidavit of service, the prior special magistrate order, and also the 2 photographs that were testified to. As you receive in evidence, pages 230 through, 240 of the packet.
All right, I'll go ahead and receive into evidence as exhibit number 1, pages 230 through 240 of the packet. Mr. Pinker, just out of curiosity, how did he bring this property into compliance? Did he actually get a building permit for those fixtures, or did he have to remove the structures?
The outdoor toilet was removed.
Okay.
And the outdoor shower was also removed, yes.
Okay, that's what I figured, but he was adamant that he might get a permit for it, so.
No
just wanted to
comment.
know. Okay, very good. Then I'll go ahead and find the property in compliance based upon your testimony, Mr. Pinkard. Mr. Trask, I'm ready to go as long as you want. Is there anything else we'd like to go over tonight?
I think that we've spent enough time here today.
All right, thank you. That concludes today's hearings.
Thank you.